Oh shit, here we go again.
Low, low, man. Low, low, man.
You like contracts, right? You're a contract guy.
I read contracts instead of conventional pornography.
You are coping and seething. You just can't accept what you see. Yes, you're coping and seething. The truth, it is scalding, and now you are molding and coping so hard.
Nice argument, Senator. Why don't you back it up with a source?
My source is that I made it the fuck up.
What's up, everybody? It's your boy Andrew Esquire, and this is Legal Mindset. We teach you to be your own judge. We fixed the camera today, so we're good. We can go 360 here. Look at that. We can go over here. I can even show. Look. Oh, okay. Well, maybe it's not liking to track me that hard. But anyways, that said, we're back here today on the Legal Mindset, doing it live once again. And it's good to be back. All right. So we've got day 6 here of the Sarah Boone case. And I am very much looking forward to how we're going to do with this. Also, we've got Ava. What's going on? Good to see you, Ava. Scuff, no scuff. What scuff? I'm using the right microphone. It's all good.
Good morning, everybody. I saw what you did there, by the way.
What did I do? What did I do? I did nothing.
You know what you did. That was one cover play. It was one cover play, and you introed me so hard.
I introed the shit out of you. Right? It's good. All right. So today we've got day 6. So we're going to get the end of the state's rebuttal case. And I think, let me just fast forward. I think we're, right now they're getting towards jury instructions, but there's going to be a lot of outside jury presence stuff today. So that's going to be a lot of attorney battles, because I know we all love those. But it's good that we're starting late because we're going to have to skip over a lot of stuff where they're going to take time, where the counsel's going to be working around, looking around, working on stuff. Also, I was informed there may have been an out of court incident, right? Apparently, allegedly, there was some sort of incident, whether it was a protest or somebody saying something related to domestic violence outside of the courtroom. So we'll figure out, maybe I don't know whether the judge will talk about that or that's something that'll come up, but that might be interesting. Now, what can happen with these high profile cases is if you have any activist groups that are interested in them, oftentimes they're allowed to protest and they're allowed to be around the courtroom. But here's the thing. They're not allowed to go in the courtroom. You can't be protesting in the courtroom. Your right to protest is not absolute, right? And that's one thing that people have to remember. And if you're doing anything inside the courtroom that is distracting or otherwise is trying to signal the jury or say anything else, you're going to possibly be held in contempt, certainly removed from the courtroom. So that's one of the things. They balance the right of the public to access the trial with fairness of the proceedings. So if it is going to make the proceedings unfair, then you can enact certain restrictions. One of the big things that's kind of controversial is, well, what if the protesters were like playing music or shouting or doing something so loud it could be heard in the courtroom? Well, technically the court has the power to stop that, right? They would have the power to remove them to such a distance that they wouldn't be disruptive. Now, have they done that historically? Not as much. But I do think that it's something that we're going to get into in the future, particularly with people trying to break the rules. Yeah, and there's some people that don't like following rules or don't like being civil, particularly some activist groups. So we'll see. Golden Helm says 300 ping Ava, still the best lawyer around. Ava, you got a lot of fans. I'll give her a second to respond to that. The Elf fan club grows.
I do have 300 ping. I am not the best lawyer around. I'm a baby lawyer, but thank you.
She's doing a pretty good job. King Lugia for 5 legal mindset memberships. Thank you so much. Appreciate that.
Yes, yes.
Woof.
Thank you. Anthony says, are you going to cover the murder trial of the defense case after yesterday's fiasco? The defense got absolutely destroyed yesterday. Now, we'll see what they do on closing, because remember, closing argument, you do have wide latitude to make, to spin a yarn, to tell a tale. I can only imagine the amount of fibs, lies, and bullshit that the defense is going to spin in their closing argument. So I'm very excited for that. I do hope we do get to that today, particularly in the afternoon session. I really hope to hear that today, even if we don't get a jury verdict today. Although getting a jury verdict would be awesome before the weekend. That'd be great. They do have to cut it off around the time when they would have to stop.
Owens absolutely obliterated your 1 week trial prediction.
That's on him. Yeah, that's on that motherfucker. Because otherwise it would be 1 week, but this will actually blow it to Monday. At worst, I think they'll finish Monday, which isn't horrible. But to be honest, if they have time to think about this over the weekend, I think that's not going to go in the favor of the defense. The more they think about this, the more it looks bad for the defense. There is no defense. I don't know. I mean, there's arguments, but they're just not good arguments. They're really bad arguments. Over on locals, they say Ava isn't a baby lawyer. She's a lolly. It's very true. Very true. Legal lolly. A legal lolly. Not illegal lolly. Very legal. All right. So let's get to this, starting this case. So this is day 6, and we're going to start once again, like before, we're starting a little bit behind so we can kind of catch up here. Let's see here. Sarah, here we go.
Tony Henderson for
Here we go. Once again, this is still the rebuttal
Good
case.
morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Ms. Boone is seated at counsel's table wearing a light gray suit and a white blouse. She is in custody, however, will not be wearing any restraints. As such, we will continue to stand when our jury enters and exits. We're here for a charging conference. The court has reviewed, I believe, both parties' red lines as to the jury instructions.
So we're going to talk about the jury instructions
submitted last night. The defense's red line as to the jury instructions that were provided by the court. Let's try to get as much done as we can until our jury arrives. I believe what we had discussed yesterday was starting at the beginning and moving through as quickly as possible until we get to the real meat of some of the issues in the 3.6F and the 3.6G instructions. Mr. J?
May I remain seated during the charge?
Yes, sir, you may. Thank you. All right. I have in my hand a 34-page document that was emailed to the court last night by counsel for the defense.
Say the 34-page document
at 12:06 a.m. from Lauren Henderson. That's what the court's going to be relying on. Does everyone have that in front of them?
Good stuff.
Yes, sir.
Defense.
Yes, Judge, I did.
Okay. All right. Let's start on page 1 of 34. 3.1, Introduction to Final Instructions. Any objection to the form of this instruction state?
Sigrun, we're just starting with jury instructions. Jury instructions.
Now I'm confused.
Chris Candler says the jury is staying past 9 p.m. tonight. Bro, then that means they're making a decision.
There was an email at 12:06.
Hang on. Let me make sure.
If that's the case, they're making a decision today. Then my 1 week prediction stands.
Give me a moment.
Market
Then
Reality
it
said,
was
keep in mind the
what
order of
was
closing
sent
arguments.
At 11:31 yesterday.
The
I
state
could
makes
see
the
the jury
closing
be
first
willing to do that.
to get it done. Yeah.
Okay.
State makes closing first, then defense, rebuttal, and then defense makes its actual closing, then state makes its rebuttal. Yes. But also, Mark, the defense can do those together, so they can just run through rebuttal and actual closing as a joint. But yes, that is the order. Thank you, Mark, and appreciate everybody who's here today. Thank you, all the members. It's been really awesome to see the members growing here and everybody getting access. I think we're going to need a suitcase emoji. People want pink shorts.
Excuse me, Judge.
Yes, sir.
That may have to be a
Henderson explained.
an element for Ava. She has a pink short.
Fine by me.
Attire element.
Only when I'm talking to the cops.
Seriously. Actually, I technically have an elf girl emoji. Is it still up there? Hold on, let me see if I took it down.
We approached and I had asked if that format was okay for you. I believe Mr. J had said.
Yeah, it's still there. It's still there.
So it'd be easy to incorporate in your final instruction.
And that's what was sent at 12:05 last night. All right.
Just for more convenience.
Yeah, we've got knife ears in the chat.
Okay. But
We've
the
got
balance
knife ears
of the
in the chat.
instructions, because that just addresses those. What you just advised only speaks to the 3.6, 3.6G instructions.
Yeah.
Correct. Okay.
Very nice.
All right. So I'm talking about the balance of the instructions that may or may not be at issue.
Mark, you've summoned an elf army.
Okay. All right.
Andrew,
Rivendell
right?
has answered the
I just
call.
woke up.
They have a 34-page document.
Yes, sir.
I have a 31-page document that was emailed to us by Ms. Henderson at 11:32 in the morning.
Are you looking at October 24 at 11:31 a.m.? Subject, defense proposed jury instructions in red line format?
I'm sorry.
No
Defense
worries. I'm
Miss-
looking at the email correspondence of October
witnesses
24,
and their last
2024,
witness was the
11:31 a.m. Subject, defense proposed jury instructions in red line format. Is it possible that you don't have your track changes are off? And maybe that's why. That's the difference. In Word, under review, or I can just have Madam Clerk print out 2 more copies. And we could just work our way through that.
Track changes for everyone is still 31 pages.
This is the most boring part of legal work, but you know what's funny?
I
When
just
people
forwarded it to
think
Madam
of
Clerk
legal
and have her
work
print out 2
and
copies.
they
That way
think
we've
of the
got hard
courtroom
copies
stuff,
so
the
we can be
sexy
all on the
stuff.
same page.
This is the reality check for people that want to be lawyers. Fucking track changes and making edits to long documents is way more time than any time you're spending in court. Look at this. This is a fucking murder case, but I guarantee you these people spent more time in the office prepping by far, like 100x to the amount of courtroom time.
They were literally sent a
I mean, imagine that you're like editing and doing track changes to a 30-page document in between the days.
30-page for document at midnight.
Yeah, and you've got to work on that. And it's like, oh, and they'll send it to you at midnight, and you've got to work on it now. And I've had those days too, even in when I was in transactional law, because we'd have closings, like real estate closings. I would have 100-page, 200-page documents I had to review and make changes to before the closing. So I'd be up all fucking night. And as they say, that's why they pay you the big bucks, especially in the business and transactional world. But that's the real work of the law, more so than anything in court. So anytime everybody's like, every time anybody says, "Oh, well, you know, you haven't spent that much time in court or court this and that," I'm like, guys, the practice
The
of law
biggest
is
fight for
barely in court.
any lawyer is a proper sleep schedule.
Yes, exactly. Sleep is for the unemployed. Yeah, someone says I'm glad I didn't pursue a law degree, even though I did exceptionally well in law. Exactly. The study of law and the practice of law are completely different. Yeah, real court cases aren't like Ace Attorney. Exactly. Crimson Splat for 5. Thank you, brother. Says hope they order the jury pineapple pizza if it goes to 9 p.m. Ban him. Crimson Splat banned. Banned. Beer Bear Beard for €2. Thank you very much. Suitcase emoji. Thank you. Thank you.
He can't even get through the word pineapple without a ban.
Yeah, I'm sorry to tell you, Boston legal isn't real. I'm sorry. I know I'm breaking your heart. Matlock isn't real. Although this guy may be like Matlock's brother.
Yo, Boston legal. The Dinah on Thoyd Suite. That's where you need to go.
If you want to get the trial over today, get the entire pizza, the entire courtroom pineapple pizza, then tell them they can't leave till it's all gone or the verdict is had. Oh, that's cruel. That's cruel. Also, Veggie Han and Local says nobody puts Lolly in pink shorts. Unless she puts herself in pink shorts. Anthony said, I would have preferred pink shorts the last time I had to call 911. The big, strong fireman had to help me get dressed. I could barely move. Oof. Not good. Yeah, it's the worst when you have to like call the ambulance or firefighters or police and like, you know, you're not properly dressed. Like I've been to the hospital where it's like I'm wearing like pajamas essentially. And at one point I was wearing no shirt, but somebody handed me a shirt because in Miami I would sleep shirtless. It's hot. Mark says, what about suits? Tell me that this is true. I'm sorry to inform you. I'm sorry to inform you.
No! No!
Suits is not real. Not even close. The attorneys in suits would be disbarred very quickly. Also, the whole not taking the LSAT thing, yeah, that's not going to happen. I mean, unless you're in a state that allows you to go through alternative procedures, like California, which has other procedures, but you do have to take tests and other certifications, right? You can't just like be like, I'm smart, make me a lawyer. That's not how the practice of law works.
California, and there are 3 other states that do it as well, which I believe Virginia, Washington, and I'm forgetting the 4th.
Yeah, I don't know the 4th item. I don't live there, so I don't really give a fuck, to be honest. NYPD Blue has to be real. No. I'll fast forward the shuffling of papers.
Reno 911 is real, though. Trust me, as someone who's been to
Defense is
Reno,
provided
that's
to
just
the court yesterday,
true.
34-page document.
Yeah.
which
So here you go. State will finish rebuttal case followed by jury instruction and closing.
includes the defense's red line with regard to the proposed jury instructions. We'll start on page 1 of 34. Instruction 3.1, introduction to final instructions. Any
And
objections?
guys, this is important because, you know, the defense's case really is hedged on these jury instructions and these specific defenses. So if they don't get the language they want in there in the right way, they have 0 chance of winning.
To the form of this instruction state.
No, Your Honor.
Defense.
No, Your Honor.
Moving to page 2 of 34, instruction 3.2, statement of the charge. 8.
Brooklyn 199 is not real.
Defense.
Neither's Magnum PI.
Moving to page
or
3
Reno
of 34,
911.
7.1, introduction to homicide. Those 3 paragraphs, any objection?
No objection from the state.
No objection.
Moving to the next portion, justifiable homicide in the singular paragraph. Any objection, state?
No objection.
Defense.
No objection.
Moving to excusable homicide and the 4 paragraphs, including paragraphs numbered 1, 2, and 3, state.
I'm sorry, my father
no objection.
must state that Magnum PI
thank
is
you.
real. He
Defense.
was very adamant.
Moving to page
Night court.
434, 7.4, second-degree murder instruction.
Kobayashi Castle.
Defense, any objection to the form of the instruction?
No objection.
Cops.
And also
Cops
the
is real.
removal of the lesser included chart on page 5 of 34.
SpongeBob is
correct?
real.
Correct.
Moving to page 6 of 34, instruction 3.4, when there are lesser included crimes or attempts. My only question is, if
Oh,
I understand.
let me
from the
invite
defense, they're
my,
looking to see
let me
culpable
invite my
negligence
blonde friend.
Is a
Hold on.
lesser included?
Yes, Your Honor.
Would that not need to be included here?
Yes, Your Honor.
Okay, so is the only addition to this, the balance of the 3.4 instruction would be correct with the exception of the last sentence, which would read the lesser crimes, plural, indicated in the definition of second degree murder is manslaughter and followed by culpable negligence.
Yes, so it should go to R. Yes.
State?
State objects, there's no evidence to support a misdemeanor culpable negligence lesser included offense for a category 2 lesser to be included in the jury instructions. Both must be supported by the charging instrument as well as the evidence in the case. There is no evidence in this case that he only suffered culpable negligence. The crime for culpable negligence with death is manslaughter. Culpable negligence isn't even a category 1 lesser of manslaughter, it's a category 2 lesser, which includes, by inference, there must be some evidence that her culpable negligence did not result in death.
What's your response to that?
Judge, the instruction that we're asking for is 8.9. It reads to prove the crime of culpable negligence. The state must prove the following 2 elements beyond a reasonable doubt. 1, Sarah Boone exposed George Torres Jr. to personal injury.
These 34 pages of jury
Two,
instructions, everyone, they're going to have to read them verbatim before they make an actual decision. So it's going to take longer than 30 minutes.
Yes, much longer than 30 minutes.
There is evidence of culpable negligence as to the case in the fact that Ms. Boone, while Mr. Torres is still in the suitcase, goes upstairs. As to it being charged, it's a category 2 lesser included that's available to the defense. Defense can get category 2 lesser included offenses as long as there's evidence to support the category 2, and there is evidence in this case to support the category 2 lesser included. That's
And
why I would ask.
any other further argument, Mr. J?
No, Your Honor.
Okay, all right. At this point in time, the court is inclined to include the culpable negligence as a lesser included. We'll get to the instruction momentarily. Any other revisions to the 3.4 instruction, defense?
No, Your Honor.
Moving now to 7.7 manslaughter, there are some objections. The defense is now objecting to paragraph 2C, the death of George Torres was caused by the culpable negligence of Sarah Boone. So how could you ask for a culpable negligence instruction and then object to 2C in the manslaughter instruction? Logically having trouble understanding that.
Because this is my argument, because I'm not arguing that there isn't evidence of it, because I just said there's evidence of it. The difference is, and I think the burden is different from the state because it's not alleged in their information.
Does not the instruction say give 2A, 2B, and or 2C depending upon allegations and proof?
Yes, the allegations would be the information.
Okay. Any response, Mr. J?
Judge, it's a category 1 lesser. All the theories are included in that. The language does not need to be included in the charging instrument. And quite frankly, it's not inconsistent with the language in the charging instrument. She's accused of having a depraved mind when killing him. And what the evidence has also shown is that she was heavily intoxicated when she made this decision. that supports a conclusion for a trier of fact to reach that this was not a culpable negligence.
Yep.
If they reject
Yep.
our argument that it was done knowingly, not patriots, ill spite, etc.
So,
Any other argument, sir?
No other argument.
yeah, they're going to have a lesser included there. So,
At this point in time, the court is going to overrule the defense's objection
yeah.
as to the objection to 2C in the manslaughter instruction,
Yep.
including
They're getting
the final
manslaughter in
two
there.
paragraphs of what the definition of culpable negligence is on the bottom of page 7 of 34. It seems like it's stipulated between the parties that 2B, Sarah Boone intentionally procured an act that caused the death of George Boone, should be George Torres, is not applicable. Is that correct, state? Is that correct, defense? Okay, thank you. And also, since 2B is not applicable, the to procure definition will not be provided. Any other questions regarding the 7.7 instruction?
That's actually pretty big. Hold on, let me wait for. Let me see if we get a lolly back here. Sorry, I'll rewind that because I want you to, Ava. I want you to catch this because they actually got they got some. This is actually pretty important. So let me rewind this a second because they got a lot of instructions out there. And so hold on.
Yeah, sorry about
Culpable
that.
negligences on the bottom of page 7 of 34.
I had to refresh. It was the audio was coming in
It
like
seems like it's stipulated
a
between the parties
helicopter.
that 2B, Sarah Boone intentionally procured an act that caused the death of George Boone, should be George Torres, is not applicable. Is that correct, state? Is that correct, defense? Okay, thank you. And also, since 2B is not applicable, the to procure definition will not be provided. Any other questions regarding the 7.7 instruction?
No, Your Honor.
This is a long jury instruction. So, so mind you guys, if they're reading 36 pages, think about, and you know, they're going to read through it, particularly if they're going to read it out loud, understand how long that takes. That may take just to read those pages an hour, right? Just to read the pages without coming to a conclusion.
With regard to the
Second lesser.
The second lesser? Yeah, thank you.
No objection to that.
All right, very good. Thank you very much. What is the instruction number for the culpable negligence instruction? I think it's 8.9, isn't it?
8.9.
Okay, thank you very much. Moving now to page 10 of 34, 3.6D, voluntary intoxication. Does this now need to address culpable negligence? Or is that only?
No, yeah, we would request to add it, culpable negligence since it's going to be given. So it should read second degree murder, comma, manslaughter, comma, or culpable negligence.
You're talking in the last sentence, correct? Voluntary intoxication is not a defense to second degree murder, manslaughter, or culpable negligence.
Yes,
correct?
Your Honor.
Thank you. Any objection,
No,
defense?
I agree.
Thank you. Do we want to take an attempt to address the 3.6F?
I would suggest we do that later and see if we can just get not
This-
3.6 done.
At this time, just going to make a note that we're going to bypass the 3.6F instruction and 3.6G instruction. That'll take us all the way to page 23 of 34, instruction 3.7. Plea of not guilty, reasonable doubt, and burden of proof. Any objection to the form of this instruction, defense?
No objection.
Moving now to page 24 of 34. Weighing the evidence, 3.9 instruction.
Should we go to 3.7, plead not guilty?
Did I skip it?
Yes, sir, page 23 to 34.
I'm sorry, I thought that's what we just covered, Mr. J. I apologize.
Oh, I didn't. I was just making sure that there were no edits that either the court made or the defense made, so I was scrolling, but no objection to 3.7.
Okay, thank you. Moving now to page 24 of 34, 3.9, weighing the evidence.
Yes, Ava.
Looks like give as applicable paragraphs 6, 7, 9, and 10 have been struck. Is that acceptable, state?
Yes, Your Honor, I agree that A, consistent statement instructions should get bumped up to 6.
Agreed.
And the remainder should not be.
With those revisions, is that instruction 3.9 acceptable to the defense?
Yes, Your Honor.
Moving now to page 25 of 34, the latter portion of the 3.9 instruction. Any objection to the language contained on this page state?
No, sir.
Defense?
No, Your Honor.
Moving now, the 3.9A instruction was struck by virtue of Ms. Boone testifying in this matter, so that need not be addressed. The 3.9B defendant's statement instruction also included the requested language by the state. Is there any objection to the form of this instruction at this time? Defense?
No, Your Honor.
Okay, Ms. Boone, earlier this week, and I can't recall if it was yesterday or the day before, the state had filed a motion seeking to add additional language to this instruction. And I had read that language to you at that time. Do you want me to read it again to you this morning? Okay, so I'm going to read you the entire 3.9B instruction. 3.9B defendant statements reads, a statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore,
I'll
you
answer
must
all the super
determine
chats
from
once
the
they're
evidence
passes, guys.
that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including,
Nice mic, bro.
but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything
3.6F is
in order to
justifiable
get
use
him
of deadly
to make
force.
it. That should be revised to the feminine.
The
Any
feminine.
objection?
No, Your Honor.
They got to get those pronouns right.
That
Gotta
is the
get
form
those
instruction
pronouns
created by the
right.
Florida
3.6D
Supreme
is
Court, ma'am.
justifiable use
What
of
has been
non-deadly
added is
force.
the next paragraph, which reads, law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Similar to other conversations we've had this past week, ma'am, I don't want to know about specifics of any conversations that you had with you and your attorneys, just simply whether or not those conversations have been had. Did you and your lawyers discuss the proposed language that I just read to you?
Yes.
Do you have any questions with regard to that proposed language?
No.
Are you in agreement with this additional language being added to this defense?
Yes.
All right, thank you, or to this instruction rather. Thank you. The last sentence read, if you conclude the defendant's out-of-court statement, was not freely and voluntarily made, you should disregard it. Any other clarifications to that instruction state?
No, Your Honor. Thank you.
Defense?
Judge, in looking at it, it says in the final part, consider whether the defendant's statements, can we replace and put rather Sarah Boone's statements?
Where are we specifically, sir?
In the state special that I have no objection to, it says, this is however one of the factors you may consider whether the defendant's statement, if we could have Sarah Boone's statements were voluntarily made.
The language used all throughout the instruction is the defendant.
Yeah, I tend to agree with the state on that.
Okay.
Rule 3.10, or I'm sorry, instruction 3.10, rules for deliberation, page 28 of 34. Looks like the parties agree that paragraph 7 is not applicable.
Yes, sir.
I agree.
All right, that would change paragraph 8 to 7. Any other revisions to 3.10? Defense?
None from the defense.
Moving to 3.11, cautionary instruction. Defense?
No objection.
The court then interlineated on page 30, the 2.7 closing argument form instruction. Any objection to that instruction state?
No, Your Honor.
Defense?
No, Your Honor.
Moving now to 3.12 verdict instruction, page 31 of 34. State.
No objection.
Defense.
No objection.
Moving now to 32 of 34, instruction 3.13, submitting case to jury. The only other question I have for the parties is with regard to, I believe it was Exhibit A, the suitcase. Are we going to send that back, or is that going to be viewable upon writing similar to the baseball bat?
They need to keep they need to give the jury the suitcase.
Agreed.
Okay, all right. Is
Give
this
the jury
instruction
the
acceptable to the
suitcase.
state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Very good. And then moving to, that concludes the, except for the 3.6F and 3.6G instruction, that includes the verdict or the instructions. I'll have Anita clean that up and send it to the parties so that we have a cleaner red line to work with. The only other question that I think we can address this morning is the verdict form. I received the defense's verdict form, and it looks like manslaughter is no longer being sought in the verdict form. Manslaughter was struck out, and it was just culpable negligence.
Under the defense's part, yes.
Right.
Yes,
Okay.
Your Honor.
So how do we want to address the verdict form then? Because if we're giving instructions on manslaughter, it certainly needs to be included in the verdict form.
I understand, Judge, but the defense isn't requesting manslaughter, but if it's instructed, it has to be in the verdict.
So the verdict form would read, we, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. Is that acceptable to the state?
Yes, Your Honor.
Is that acceptable to the defense?
Yes, Your Honor.
That's
Similarly,
the
I'll have
instruction.
Notarios make the
That's the
revisions
important. That's the
and
money
submit
shot.
them to the parties as
That's
soon
the
as
money shot.
possible. Anything else, state, we need to address before, Bruce, do we have everybody as of this time? Everybody's here? Thank you, sir. Other than the 3.6 instructions and the state's
By the way,
request
like
for
the video.
other instructions, which I think we'll have to table for now,
Yes, sir.
are we prepared to go ahead and bring in our jury at this time?
Only thing I wanted to bring to the court and the defendant's intention was.
Brought
apparently
my
has
Thai
some
inhalers.
sort of domestic violence.
So good.
Event out in the
So
quad.
good.
A coworker indicated
Smash alike.
that, without believing it was any particular jurors in this case, that he did see people with juror badges in and about the area. So I don't know if that warrants inquiry by anybody.
Defense?
I think it should be mentioned.
I agree.
Okay.
I agree.
Just to see,
Sure.
we spent all this time, we've got a bunch of alternates. Let's utilize them, but I do have an issue.
Yes. What do we got?
I think the state attorney, the last piece of evidence is they extracted from Sarah Boone's phone a bunch of pages of text.
Yes,
messages.
Chet. Andrew is squeezing lemon juice up his nose. That's what's happening.
All those text messages, which were quite a few, but I think they want to read specifically out a few to the jury. I'll look at
It's
some
highly
of those
effective.
ones they're going to read out, and under the rule of completeness, if there's a thread where it needs to be put in context, we would ask that all of that be read. So I don't know exactly what they're going.
Mr. J, any response?
Leaves a citrusy
Going
scent
back with
and
them,
isn't as
just
bad as
like I
rackets.
told them during
Rickety
some
crackets.
Body worn cameras. Only some of it's published. It's all going to be there for them to use. I do not intend on reading all 108 pages. I don't intend on trying to delineate what contextually is one conversation from the other. I think it's just fair to say this is all going back with you. You're going to have a scrub laptop. You're going to review it all.
Mr. Owens, you can make any objections you deem necessary at the time, and we'll address it. Because it's just hard for me to say what should or should not be. I understand the state's position, but if it's something that's you believe in the rule of completeness should be provided at that time, regardless of it going back, we'll address it.
It's going to be about 40 minutes worth of reading text messages. Are we going to have some people come in to read the messages?
Again, I'm not sure how long it's going to take. I did not practice reading what.
They've already been entered into evidence, so
Number two, no. I don't understand why a witness would be called. It's in evidence.
There you go. Shut up, defense boomer.
Anything further, Mr. Rollins?
Bro, shut the fuck up.
All right.
Not on that issue, I would like to take like 5 minutes to use the bathroom.
Sure, we can do that.
How
Okay,
about-
so
Motherfucker.
I don't want to highlight that it was a domestic violence event. So are the parties, is it acceptable to the parties to inquire of if anyone heard or participated, got any information, or observed anything of the event that transpired yesterday afternoon in the courtyard? Is that acceptable?
Yeah, you definitely should.
Poke the like
Agreed.
button like it's
Got a thumbs
grandma-see.
up
Wait,
from Mr.
what?
All right, we'll take a
Wait, what?
10-minute recess. We'll just plan on bringing back here at 9:30. We'll bring the jury in at that time. Thank you all very much.
Did you just hear that? Did you hear that? They just said, do we have any witnesses to show what happened in the courtyard?
That'll be interesting. All right, let's get through this. Mark Arriati took office at lunch, then afternoon court. See ya. See ya. Mark. Captain Spire said, good morning. Say, Elfpire Ava, were you able to research if the defense dropped all his other cases to take this one? Good luck on your channel. Did you get that answer, Ava?
So I looked into it and he dropped some cases and that's what's been reported via reviews, but there's no definitive proof to show that he did actually drop cases. I haven't seen anything like that in any court documents or anything like that.
So, okay, what happened in the court? Apparently, there was an incident. Now, we don't know whether it was quote-unquote DV. It might have just been a woman yelling at a man, right? Which, once again, 50% of the population of the world is female and male, right? Or it's like 51%, sorry, 51% female, 49% male. But once again, a man yelling at a woman, you have no idea what that is. You have no idea if it's quote-unquote DV, etc. Right? Someone's saying it's DV. Okay, well, sure. But when you observe something, however you're going to perceive that is what the judge is saying is that's, kind of up in the air. So we're going to see if that would have impacted the jury in any way, right? And influenced them. All right. So next we had Anthony said, on a plus side, that E-room visit was the last straw and forced the VA to get in front of me on the back surgeon. And I've been mostly good since. Well, good. I'm glad you're doing all right, Anthony. Farmer Jack said, good morning, folks. I've had the coping and seething song stuck in my head for 3 days. So F off, Andrew. To that, I've got to say this.
Slippery little bastard! Making the mother of all omelets here, Jack. Can't spread over every egg.
Or every person that you get stuck with coping and seething in their head. Appreciate that. Hey, thank you everybody joining today. I really, really have fun on these streams. NR said, I'm so glad to be part of an extremely niche law, anime, elfu, real-time AM court streaming YouTube subgenre. Thank you for what I do. If I can take credit for creating the sub law tube, the sub niche of like VTube, court, court watches, that's good. Cause I don't think anybody has that. Like, there's no VTubers that do like primarily even legal stuff or do court watches or anything else. So I'm happy to monopolize that niche, right? Especially when I
have an idea. I want to do something called VTC, which is VTuber Court, where basically that's what we try to do.
Yeah, I think it's a great idea. And that's, once again, people think that you do well by appealing to everybody, but actually that's not true at all. You actually do better if you have a niche and you tend to just live that niche and own that niche rather than trying to get everybody to fucking like you. Because to be honest, there's about 50% of people that, or not 50%, but in the comments, maybe 10% or 20% will be like, what is this VTubing stuff? Or what is this? Why are these anime girls on the stream? I don't understand, or what's going on. And that's actually good because I don't really care about those people. I care about the people that enjoy the content, the people that are positive interactions, and the people that are here for the entertainment, right? You don't try to appeal to everybody. Yeah, it's impossible and insane. And too many people try to do that. And I think it's crazy. VTubers are the future of court cases. Whoever has the best model wins. Royal Wee for 5 says, legal. Have you been to Iwalak, Korea? No, I have not. I don't even know where that is. So you know what? If you want to email me, some information on it, I'll check it out. I'm here for a couple weeks, so I have time. So yeah, send it over to me and I can see if I can check it out. Thank you so much, Roll. Tatsumi said, since Ava is a legal elf lolly, if she waves at us, is it legally classified as a microwave? Bro, Tatsumi, get out of here. The door's over there. The door is over there. Or actually over here. Hold on, I gotta lean this way. Door's over there. All right, Meteoric says, what happens to the evidence after the trial is concluded? Can it be destroyed? There's a period of preservation for the purposes of appeal. So until the appeals have been exhausted, the evidence will be preserved. So, and that's a statutory thing. So there's preservation of evidence rules. So it cannot be destroyed until the end of the preservation of evidence rule. Chaos Smash 64 said, did you see Sparky AI's cover of you singing Coping? Yes, I need to find that. I'll find it a little bit later. And Bologna Bong says, your smaller niche, give monies. Yes. Thank you, Bologna Bong. Thank you for that. Appreciate that. Let me see if I can find this Coping and Seething Sparky version, because I had it pulled up earlier, but I think it may just be on Sparky's page. Let me see. Sparky, I think he just posted it.
I actually have it. Give me 1 second. I'm going to send it to you in the back room.
I thought he DM'd it to me, but I think I was just tagged in it somewhere. So I'm trying to see if I can find it real quick. Oh yeah, he sent it to me. Here you go. I got it.
I had to do a re-recording because he got the instrumentals isolated really well.
Yeah, he did it really good. This is actually really good. Okay, here we go. You are coping and seething. You just can't accept what you're seeing. Yes, you're coping and seething. The truth in is scalding, and now you are molding and coping so hard. Yo, I mean, shit. AI karaoke. Andrew AI can rock it, man. Andrew AI can do it. DSP's theme song, 10 out of 10. Yeah, that's good, right? That's good. I like how we've got all these other versions of that song now. It's so great. Okay. Let's fast forward to the and get into the next part of the trial here. So we'll get to that. Also, Bad News Badger says, I am not really a cat. We're aware. We're well aware. Okay, so let's get back to the case.
Yeah, he's not a cat. He's clearly a badger.
But he's bad news. Anthony says you're part of a very small niche because Ava is one of the few VTubers with more than one brain cell.
Bold of you to assume I have more than one brain cell, and that brain cell isn't just like really hopped up on caffeine.
It's just a really big brain cell. It's like a fucking amoeba. To be honest, though, for real talk, some VTubers do need like some serious intervention with some of the choices they make.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, members of the jury, you can be seated. Members of the jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Just again, if you could raise those hands, confirm you complied with the court's instructions. All right, all hands have been raised. Thank you very much. Members of the jury, before the state continues with their evidence presentation today, I just have a couple of questions to go over with you.
I expect Cher to
Yesterday,
jump
there
the
was an
judge
event
like
in
an
the courtyard
L4D,
of
Left
the
4 Dead
Orange County
Hunter.
Courthouse.
For two.
Did
Thanks,
anyone happen
Smash.
to observe that event? If you did, please raise your hands at this time.
What do you mean by observe?
We'll get to it.
Okay.
Okay. Did anyone happen to hear anything during that event? All right. Record reflects no hands have been raised. Did anyone see anything during that event? All right. Juror number 2, first row. Thank you, ma'am. Did anyone participate in that event? Record reflect no hands have been raised. Did anyone receive any writings or review any material from that event? Record reflect no one has raised their hands. Can the parties approach for a moment? Everyone out except for juror number. All right, members of the jury, I'm going to send everyone out except for juror number 2 in the first row. We've got a couple follow-up questions for you individually, ma'am. Same instruction I've given you all previously. Please don't conduct any independent investigation or research as to the person, places, things, or charge involved, and don't have any discussions amongst yourselves or anyone else, and we'll bring you back in as promptly as possible. Thank you.
Uh-oh, jury number 2 called out. What happened?
She saw it. Just saw it. That's it. So they have to make sure there's no influence.
You all may be seated. Thank you.
It could bias the jury. They might replace her with an
Juror in
alternative.
seat 2 on the first row from right to left. You had advised, based on the court's question, that you had observed something, and you said what does observed means. And instead of getting that out in front of every other juror, we just want to have that individual conversation with you now. So tell me what it is that you saw or heard or anything yesterday in the courtyard yesterday.
When we were walking back from lunch, and we saw that they were gathered, and I asked the deputy if he knew what was going on, and he said it was somebody talking about domestic violence.
Okay. And you said we were walking. Who's we?
Another juror. I don't want to say her name.
Okay. All right. Is that a juror that was on our panel here?
Yes.
Okay. All right. Do you recall
She ain't no
where
snitch.
they may have been seated?
No, in the back over there.
Okay. All right. Do you recall what color her hair was?
Yes.
What?
You want me to tell you?
Please.
Dark brown or black?
Is it the shorter juror? Okay. Thank you very much. State, any further questions?
And after you were told what was going on, then what happened?
I walked back in.
So it's a fucking nothing burger.
I couldn't hear anything.
Anything further from the defense?
Ma'am, did that affect your ability to be fair and impartial?
Can the parties approach for a moment?
All right, yeah. So, if it was like, for example, if this was a cop shooting and you've got BLM outside chanting all cops are bastards or whatever else, right? That could affect the jury. So you got a DV person out there that's like, justice for Sarah or whatever the hell else it was, right? That could affect somebody. Now seems like it's nothing. And honestly, that's on the sheriff for even like saying what it
We
was.
appreciate you, ma'am.
The
Thank you so
sheriff
much.
should have
We're
just
gonna
said,
go ahead
oh,
and
it's a
bring in the balance
protest or a
of the panel.
group.
You just hang out where you're
The
at,
sheriff
okay?
kind of even fucked up on that one. The sheriff shouldn't even said what it was. It's a nothing burger, but
We stand for you. You do not need to stand. We stand for you.
the law students are more back today. There's more of them. I think because they know it's going to be closing arguments. It's a VTuber burger? No. It's not full of it's not full of unconscionable contracts. That's a VTuber burger. Someone asked if a juror purposely searched for the news, what would happen? They'd be dismissed and they call in an alternate.
State you recognize our jury.
If you looked at the
Defense, do you
news, you're
recognize our
dismissed.
jury? All right, y'all can be seated. Thank you. Again, members of the jury, if I could see those hands, you complied with the instructions during that really short break. Record reflect all hands have been raised. Thank you very much. Mr. J, you may proceed, sir.
Permission to publish from states 21, which was previously marked as P for identification.
You may proceed, sir.
Real quick, Sparky says, glad you like them. I'll have to do more and see if the elf and others want covers done also. Awesome. $4.99. Thank you so much, Sparky.
Again, this is a DVD exhibit with 2 folders in the main directory. One entry is in a folder called attachments.
Zin says for 5, after getting through the text state read, I wish that state could have brought first degree. She's a monster and there's only one answer. Wow. So we're about to read those. I know it's a little bit spoiler for those that read ahead. We're going to catch up very quickly though here. We're not that far behind. But we're going through a shit ton of pages of text messages.
There will be a laptop provided to them to utilize this exhibit.
So they're going to have all these text messages.
I'm going to go by page number and date unless something requires more specificity. And for to and from, I'm going to just use the name of the contact if one exists or the phone number if one doesn't. On page 1, creation time for notes, 7:49, asking Jorge or George not to be despicable to me, making more drink after he guzzled his and I shared mine. On page 2, date March 8th, 2018. You are now in a relationship with Jorge or George on Facebook.
Oh, remember when that was a thing, when being a Facebook official was a thing?
1000,
that was so cute.
14, etc. for Jorge Torres.
That's so boomer.
To Sarah Boone, owner.
No, we're finishing the rebuttal argument. This is the last
3,
part of the state's evidence.
May 21st, 2019.
They agreed upon jury
407 716 8684 to Melissa. And he can still live here, correct? Or until I decide to finally get him out if he doesn't clean up his act after tomorrow.
Yeah, I deleted Facebook a long time ago. MySpace is beyond. But there was a point in time where MySpace was what was up.
May 30th, 2019, from a contact labeled as Mom, Jorge or George, to 407 716 8684.
Tom is my friend too.
Which I will just refer to as owner in future references. Where is my clippers in the gray box? From owner to Mom Jorge, all capitals, dumpster, separate message, like you, separate message, so is your 2 shirts, separate message, no more Rick and Morty, a response from
Rick and Morty destroy. Where's Cypher?
To owner.
I gotta invite her. Hold on.
From owner to Mom Jorge. Lucas cried when he saw the adventure fund was gone. Thank you. No wonder you're out. Fuck off.
Fuck off.
From owner. He's the one that broke it because you took it. From owner. Wanted to go on an adventure. On to page 10. From owner. Be proud. Feel good. You made my, quote unquote, our son cry. Cheese stick. Lucas. Your kids. Get the fuck out of my life and my sons. No one. Spinster. Good. For nothing. Dumpster diver. That's what you are, and the rest of you.
Text messages like a fucking maniac. These text messages alone are maniac text messages.
On the same page. Owner to Mom.
And
Jorge,
the rest of you? What in the world?
Mean, selfish. Fuck all you. Your firstborn is a joke. Going on to page 11, same date of May 30th, 2019.
Wow.
From owner to
By the way,
Jorge. Get the fuck out of my life.
I'm gonna play
Lucas
the
2,
interview
bad
with the
influence.
family of George later.
From Jorge to owner, I am, as you can see, go drink your life away.
Ooh.
From owner to mom Jorge, your kids are too. Yuck. Shucks, I only have one. Beaters, you're 3 together. Yuck. Going on to page 12. From owner to mom Jorge, still dated 5/30/2019. Gross, and all the time, gross. Mom Jorge to owner, I love that guy. I love that guy. You're the one who kicked me out. Owner to Jorge, mom, finally.
This is fucking schizo
Get
posting.
your shot together and check me out in 2 to 3 months. Hope you're there. Unless I find someone better. Shit. Together. From mom Jorge to owner, are you serious? Are you serious? Owner to mom Jorge, that's what happens? No. Mom Jorge to owner, I'm helping out dad right now. Call you in a few. Owner to mom Jorge, can you help me put out, fuck off? Jorge, mom to owner, how? No problem. From 267-216-5170 to owner.
Remember,
Damn.
everybody, two bodies,
You
one
can only
soul.
talk when you're drunk and talking shit. Owner to the previously mentioned 267 number. Stop calling, texting my phone. He's not here anymore. And it's damn. 267 number to owner. NP, you didn't have to be a bitch about it. Owner to 267. Going on to page 13. Still May 30th, 2019. Yo, I like you all. He's a dick and the sheriff just left. Sorry I couldn't text back. I'll always respect you all. You know that. He's not here anymore. And yes, I am a bitch. So are you. 267 to owner. Look, I'm not here to be taking shots at you. I never called you a bitch. I said you were acting like one. I'm not going to be here going back and forth on some childish shit. Have a good night. Owner to the 267 number.
That's, I mean, they seem
Friends
really
forever,
close,
thank
like
you.
one body, two
Would
souls type
love
shit.
To chat sometime.
Yeah, this is one body, two souls,
Call
guys.
his parents, I guess.
Nobody understands us. Anthony says, frankly, for
Further
5.
down on page 13,
Frankly, I think Sarah needs
now
to be
on to
fixed by a
May
certain
31st,
switch being flipped on her.
2019,
She
from
tortured this
owner
man.
To mom Jorge. Tell Jorge to call me. I want my things he took. I have his birth certificate and propane certificate. Until then, if he wants those back. And I have your quote unquote art box. Mom Jorge to owner, stop being petty. I did not take anything that wasn't mine, I swear. Owner to mom
Oh,
Jorge.
no.
You're a liar.
That would have been
I
crazy.
never can believe you from
We
all
don't
the
have
other
those, though.
lies. You stop being petty and take shit like you always do. Another one bites the dust, Jorge. Hope you're miserable like you've made everyone else. Mom Jorge to owner, I'm not lying. Owner to mom Jorge, Lucas said he won't miss you either. When I get mine back, you'll get yours. Mom Jorge to owner, I didn't take it. I'm coming over in a few to get my stuff, and I'm coming with Jean and Melissa. Going on to page 14. Owner to mom Jorge, go for it. Bring mine W. Mom Jorge to owner, I don't have anything of yours. That's why I'm coming with them so they can vary that. Owner to mom Jorge, I don't care. They're not going to babysit you because you're an asshole and got kicked out after being taken off the lease. Mom Jorge to owner, they seen what I had in my hands. Owner to mom Jorge, still don't care or believe you. I'm going to get Lucas anyway, so don't waste their time or mine. Mom Jorge to owner, exactly. Owner to mom Jorge, You were a visitor and a terrible resident. Boyfriend too. Just go away unless you bring my stuff. Mom Jorge to owner. I don't have your shit, Sarah. I need my birth certificate. Owner to Mom Jorge. I don't give a shit either. I worked for that birth certificate, voter's registration, and your ID card. Just because your name is on them doesn't make them yours. Even paid for them. I needed you to be a man and take care of me, not beat me, call me names, and make me feel like I'm not a person. Not giving back until I have mine. Mom Jorge to owner, whatever.
Yeah,
Sarah. Owner
his
to Mom
name is
Jorge.
on him. Those
Next
are
step is
his
restraining
documents.
order.
What the hell?
Know that. You can come over here 100 times. Doesn't mean I have to open the door.
Bro.
Jorge, go away.
This is insane.
Mom Jorge to owner, whatever. Owner to Mom Jorge. It's been a great day without you. Will be from now on. Mom Jorge to owner. You need to do. Owner to Mom Jorge. Enjoy living with your parents at 41 with no girlfriend and lonely.
Bro.
It was the inevitable, just like it has been before.
Wow.
Owner to Jorge. Mom, did you take Lucas's sunglasses? Mom Jorge to owner. OMFG. No, I did not.
They're accusing George's mom of stealing his fucking the sunglasses. What?
Turning to June 2nd, page 15.
We're gonna listen to the family's perspective after this. I'm sorry. Why did that die? I think Court TV crashed again. Jesus Christ. Sorry about that, guys. Court TV can sometimes be finicky as fuck. So hold on. We'll go back. We'll go back here.
Yeah, these text
this is pretty
messages are
nuts.
absolutely wild.
This is pretty schizo posting. I'm not gonna lie. Let's see. No, we already did this. Hold on. I'll just fast forward.
Dumpster. That was your owner. Took feel good.
We did this.
All you owner them as you or from owner. I hope you're there. Serious out. No problem. To owner. Own a bitch about 2009. It's not here anymore. And yes, I won. Yes. First, I did not.
Sorry, I'm gonna skip to
Stop.
skipping
Lucas
forward.
said he won't miss you either. Take it. I'm going on. Bring mine. Have that asshole and got kicked out after being taken off the lease.
Wait a
Babysit
second.
you because you're. Oh, I'm coming. My going on to page. Get my stuff to. Won't miss you either. Another Jorge, not box. Any. You're a liar. I never can believe you. Another one bites the dust, Jorge. Hope you're miserable.
Do we already review
everyone
this?
Else. Mom Jorge to
Ava,
owner.
do we already
I'm
see this or
lying.
not?
Owner to Mom Jorge. Lucas said he won't miss you either.
Whatever,
When I
I'll let
get
it go.
mine back, you'll get yours.
We're about where we should be. Yeah.
Yeah, okay.
Take it. I'm coming over in a few to get my stuff, and I'm coming with Jean and Melissa. Going on to page 14. Owner to Mom Jorge.
Okay, yeah,
Go
we're
for it.
good.
Bring mine W.
This is fucking psycho.
Mom Jorge to owner. I don't have anything of yours. That's why I'm coming with
Zin says,
them
fun
so they
game.
can
Line up the text messages
bury-
to the body
bury
cam.
that.
That'd be fun.
Owner to Mom Jorge. I don't care. They're not going to babysit you because you're an asshole and got kicked out after being taken off the lease. Mom Jorge to owner. They seen what I had in my hands. Owner to Mom Jorge. Still don't care or believe you. I'm going to get Lucas anyway, so don't waste their time or mine. Mom Jorge to owner. Exactly. Owner to Mom Jorge. You were a visitor and a terrible resident. Boyfriend too. Just go away unless you bring my stuff. Mom Jorge to owner. I don't have your shit, Sarah. I need my birth certificate. Owner to Mom Jorge. I don't give a shit either. I worked for that birth certificate, voter's registration, and your ID card. Just because your name is on them doesn't make them yours. Even paid for them. I needed you to be a man and take care of me, not beat me, call me names, and make me feel like I'm not a person. Not giving back until I have mine. Mom Jorge to owner, whatever, Sarah. Owner to Mom Jorge. Next step is restraining order. Know that. You can come over here 100 times. Doesn't mean I have to open the door. Good one, Jorge. Go away. Mom Jorge to owner, whatever. Owner to Mom Jorge. It's been a great day without you. Will be from now on. Mom Jorge to owner. You need to do. Owner to Mom Jorge. Enjoy living with your parents at 41 with no girlfriend and lonely. It was the inevitable, just like it has been before. Owner to Jorge, Mom, did you take Lucas's sunglasses? Mom Jorge to owner, OMFG, no, I did not. Turning to June 2nd, page 15, 1:10:57 a.m. from owner to Mom Jorge. Jorge, question mark, call me. If Jorge is with you, can you have him call me, please? Text to Mo. (1:18, 16 seconds on June 2nd. Owner to Mom Jorge. I beat you to the punch. Want to do the dartboard with me? Come. Owner to Mo. I know you won't answer, Mo. Tell him to come finish the dartboard with me, please. Owner to Mo. I miss him. Owner to Mom Jorge. Ask Jorge to call me, please, when he gets a minute. June 2nd, 7:43:40 a.m. Can you have Jorge call me, please, when he gets a chance if he's with you? 7:45 a.m. Owner to Mo. Going on to page 16, June 2nd, 2019, 10:50 a.m., 55 seconds. Owner to Mo. Hello. Can you please have Jorge call me? Willing to give back. Don't know if he's there.
Tyler Dirted says Sarah should
really
have
want
gone
to
with the
see him.
Frank's motion. I heard those are real good.
Owner to Mom Jorge.
Oh no,
16
not a
a.m.,
Frank's
not
motion.
pursuing
No.
after 12 o'clock. Ever again.
Oh, Tyler Durden, no. Go back to posting on Zero Hedge.
12:19 p.m., 23 seconds.
Go back
Owner
to Zero
Mom
Hedge.
Jorge, please call. Come over. I'll come get you. Come over, please. I need a super hug. Hugs, please, need. You.
Hugs, please, need.
6:23 p.m. Owner to Anna. He doesn't live here anymore. Call parents or Mo in response to an incoming phone call that was made at 6:10 p.m., 54 seconds from Anna to owner. Entries 9803, 9804 in the PDF timeline, June 2nd, 2019. Image 0092.heic. Capture time 6:33:01 p.m. Image 0093 HEIC captured 6:33:26 p.m. Publishing from attachments. Image underscore 0092 metadata showing 6/2/2019, 6:33 p.m. And image or IMG underscore 0093 metadata date taken.
Did she
6/2/19,
post proof of
2019,
ripping up her
6:33
verse?
p.m.
Oh my God, she did.
Wait, what? No. Wait, is that hers or his? Whose is that?
That's his birth certificate she ripped up out of
PM,
being
51
petty.
seconds,
Oh my
June 2nd,
God.
2019. Outgoing from owner to Mom Jorge.
What
Oh,
a
to
fucking
you now, big
psycho.
boy. And for the record, those images were sent to Mom Jorge
Dude,
at 6:34
guilty.
p.m. 33 seconds.
They have proof for
Look what you made me
premeditated
do.
here.
Or maybe your mom will for you. Response from Mom Jorge to owner. Wow, that's
Yeah,
really childish.
I can't think of
Owner
I want
to
you
Mom
dead more
Jorge,
than ripping
but
up
effective.
the certificate of your
Mom
birth.
Jorge to owner. Yeah, I see what you are doing. Did Lucas leave? Owner to Mom Jorge. I'm watching shadows. Be gone for good. Minus birth certificate. Mom Jorge to owner. Okay, cool. Enjoy. Owner to Mom Jorge. Am. Nice. You're not. And nice was from Mom Jorge to owner. Going on to page 17. This is still June 2nd, 2019. Mom Jorge to owner. Yes, I am. You are not, though. Owner to Mom Jorge. To who? Your mom? Brothers? Not me. Mom Jorge to owner. To everyone. Owner to Mom Jorge, but me. Mom Jorge to owner. I love you. Owner to Mom Jorge. I'm going out at 8. Get dressed. I've given you since noon. Peace out, Boy Scout. Mom Jorge to owner. I'm coming over with a handle. I was helping Pop all day cut grass.
Bro.
Owner to Mom Jorge.
These are
You. Getting in the shower, then out. Bye-bye. Mom Jorge to
Sebastian,
owner.
I'll say this: it's not just legal vices. These are all very, very damning. Like, and the thing is, at this point, it's cumulative because there's so many of them. You know, the point is, there's so much here. The volume of it, the sheer fucking volume of this.
JP Ravenfire is absolutely
insane.
right. He never got angry, even through these attacks.
Even with a destroyed fucking birth certificate, right? Like, seriously. New poll. Hugs need, please. Okay, I got it. I'll give you your hug poll. Don't worry. We'll get your hug poll up. This is nuts.
Yes.
Okay. They're approaching the bench, so we'll fast forward here.
Hey to owner. Hello? Text from Anna to owner. You're rude as hell, but okay. Owner to Anna. Your dad is a
I feel like
POS,
most of her
but
text
okay.
messges are like angry
At
texts or
least you
drunk
know, and
texts,
we'll stop calling
or a
owner to
combination of
Anna.
both.
Futile. Anna to owner. CTFU, as you are a piece of shit, but that's God's business, not mine. Have a good day, coke whore. Since you like to switch it up, I'll do the same. Don't text me back either, fake ass.
Have a good day, Coke whore. Wait, hold on. Was that written to Spicer, Minnesota? Because I'm not sure. Let me wait. April, was that you?
Page 20 of 108, June 9th, 2019, from owner.
Suffer,
Philip.
April.
He's off the lease. The process has begun.
But nobody likes like home wrecking Coke whores. Like, you're not gonna have a lot of fanboys.
Page 22.
Mr. Man
June
for 5.
11th,
Mr. Torres,
2019.
salute to the king. Look, let me say this
Metadata
too, real
only.
quick, about George Jorge Torres. Like, bro, this man dealt with so much fucking abuse like a goddamn champion. And real talk, he died for, out of a situation which looks like learned helplessness, a situation of abuse, of control. And how many men are out there being put through similar situations by fucking psychos? This is a genuine problem in society. And the thing is, there's not a lot of people that stand up and say, you know what, this is not okay. And people like the Sarah Boones of the world need to be locked away, the same as a male abuser, right? Because I believe that male abusers who are beating the shit out of people and doing that, yeah, they should be locked up too. But the Sarah Boones of the world that try to exercise control, psychological torture, this is in many ways even worse. Some of the things she's doing to him are the same that you would do to like torture a prisoner, right? Stuff like sleep deprivation. Sleep deprivation is a legitimate torture tactic. That's what Sarah Boone would do. She's a fucking psycho, right? Absolute psycho.
Shows to Mom Jorge. You tell your son he's not welcome here, taken off the lease and bound, worthless. Don't show his ugly, fucked up face around here again. Police will be called. Ask him if it was worth it and ride my bike he has. Stay Hispanic. That's what you all are. And he can watch all the porn he wants from the phone Mom gave him.
Bro, he should be able to watch whatever porn he wants. Obviously you're not doing it for him. Christopher Candler said, justice for X videos in the hub. They provide a valuable community service. I know what channels you're subscribed to on Twitch, Chris. Mika and Echo and Mafu Mafu.
June 14th, 2019, 11:30 6 p.m. To Mom Jorge. Wow. Congrats. Blackouts and whoring. We wanted to see him. Hot house. 7 people. Mission to work on my bike. Repeat. Candy Crush. Fuck himself. Shit job. Repeat.
The great hub in the skies.
Same page, June 15th, 2019, 7:37 p.m., 48 seconds.
So true.
To Melissa.
100%.
Just an FYI, if my place gets effed up, I'm letting you know. He's in jail. Thanks for the prompts. I'm at my ex's house. Please don't let this reflect on me as a tenant. You said to call cops. I did. He's gone. We're both proud now. I consider you my friend. Melissa, why was he in your apartment?
Yeah, I love that. That's such a great contradiction. Amazing. Story time. Be a man, but then calling you toxically masculine. It's like, y'all need to pick a fucking lane because.
Page 38, notes.
Yeah, it's funny. Did you see that link I sent you in Discord? The war on sleep is speaking to that theory I gave about Sarah yesterday.
6:14, X videos, 10:03 a.m. Sarah Banks, 5-3 Bank, 6:13. Metro activation, 6:12. Skipping down. X videos, 6:2.
Is this his? Is this like his?
6:1.
Yeah, this is his search history.
X videos, 5:31, 9:56a.
X videos.
Christine, friend FB. Going to meet up? Question. Calling her beautiful? Question. Said she thought you were avoiding her when down here. Said no, I was not beautiful. FB-nonchalant Quay. Thanks for adding me. You are exquisite. Facebook messaging Camille 613.
Camille
42. Facebook or FB Pamela Erickson sending pictures of yourself, telling her good morning 7:14, 12:13 a.m. FB-Crystal, going to woo her, sweep her off her feet, going to change her mind, Luck is my middle name. Sent her pics, kiss emojis.
Kiss emojis.
Called
It's
her
done. It's
beautiful
over.
After returning to the convo.
It's over.
Said you had to pick up your brother. Sent pics of beer. Sent her struts. Could have been me.
Struts?
Sent her songs,
This
but not me.
is all a lot to
Message,
premeditation, I
funny
think.
kiss
Yeah,
emojis,
this shows it.
Convo. Sent puppy kiss emoji.
This is cheating.
Would
This
love
is what
to
she
take
calls
her out to
cheating.
see a movie.
I mean,
Told
and once
her
again,
about what we do in the shadows. Would love to watch Creed 2 with her. Want to snuggle with her and eat.
maybe, and once again, look, I agree. Emotional cheating can also be cheating, but it's going towards her state of mind. This is not like everything was cool and copacetic with her. She was clearly not cool with him, right? So the picture she's painting of herself is very false.
Popcorn. Sent heart hugging animal emoji. Want to play a board game with her.
When she
asked
was
to
sitting
FaceTime
on that
call her,
couch,
called her
these text
amazing,
messages were going through
messaging
her mind,
at
and those
7:30
thoughts and
a,
feelings.
6:14, 6:15, 2 days.
Chaos knows the assignment.
FB-Crystal liking all her posts. Quote, losing someone who doesn't respect or appreciate you is actually a gain, not a loss. Can't compare me to the next girl because there is no competition. I'm one of a kind and that's real.
Degenerates. But I agree, Anthony, if roles were reversed, George would be in an orange jumpsuit for sure.
You guys are degenerates.
Same note.
Sure.
I found everything on your phone, all your messenger texts, telling Christine you want to meet up with her when she's here, calling her beautiful, thanking nonchalant Quay for adding you and calling her exquisite, telling Pamela Erickson good morning and sending pictures at 12:38 a.m., messaging Camille, then the whole 2-day convo with Crystal. How dare you? And send pictures wearing my wedding ring. You're a cheating, lying scumbag. I will never trust you. Why don't you put your mugshot up, or I will, since I have your phone and login.
What?
Tell everyone why you were in jail for the 3rd time. Let them know you beat your wife and she put you there because she couldn't take it anymore.
Bro.
I want nothing to do with you ever again.
What a bitch.
I'm a different person since you've been gone, with less stress, anxiety, and worry. I feel safe, comfortable, happier.
That speaks to her delusion with the cops. She did not put him there in jail. The cops did.
After going through your
And
phone,
she did that to
thank you
get
for always
the
proving me
blackmail.
right. I knew when you told me your mom gave you one that you'd be back to your slimy ways. You will never change. I hope it was all worth it, all of it, including losing my debit card for the 3rd time to buy beer and cigarettes, which put you back where you belong. I know for a fact you were not worth any of it. I just can't believe after everything I've done for you, including all I did to get you out of jail, and you do this to me. This is cheating. Goes on to page 40, goes on to page 41, and ends with never truly yours.
My God, that was a huge text message. Oh, there's still more.
Page 42.
Oh, we
June
ain't done with the
26th,
schizo posting.
6 p.m., 16 seconds. Outgoing from owner to Mo. Just wanted to let you know to tell Jorge I found all his messages, kissy face heart emojis with Crystal and other bitches on FB, along with all his porn after he swore to me he wasn't doing any of that.
Bro, I wish they brought in like the bitches as witnesses. That'd be great. Crystal, are you the bitch?
Anymore. I'm not doing anything more for him, and he will try and keep him in jail as long as I can. Cheating snake weasel. Ask him all about it, or have your parents the next time they talk to him. I'm not
snake
anymore.
weasel emoji?
So hurtful after all I've done for him. He can rot in there for all I care. Going on to page 43, to Mo from owner. And I will be there for the hearing next week and his arraignment on both charges. Peace out, fucks, aka Torres.
Wow. Oh my God. Oh my God.
Same page 43, from owner to Mo, 6/26/2019, 9:59:14 p.m.
Brian is included in a lot of messages because he's
Begins.
just only responsible for
Hi, I
them.
was thinking if you could get out, I'd really love it if you take me to a movie Or we could snuggle like we do and watch Creed 2, get some popcorn and pretzels, maybe talk about what kind of other movies we like or find a fun board game to play together. I know your favorite is Avalon. What do you think? I was also thinking the other day about how much I miss you sending me pictures of yourself throughout the day, sending me songs you wanted to hear or thought I'd like. But what I really miss are the kissy love emojis you would send, just because I really miss those, especially the ones with hearts. They'd always make me smile. I knew you were
She
thinking
got
about me.
jealous
You do, Crystal, though. Even
of the
asked her
other
to
girl.
FaceTime. What would you do if you found me having this convo with Ben or John or anyone other than you? I'd be beaten to a bloody pulp. And don't do any of these things anymore, but yet you wear your wedding ring and mine around your neck and tell me how much you love me. But you're telling this woman who looks like TPT you want to snuggle with, take out to a movie, play board games with questions.
Agree.
Sending music, cutesy,
So
kissy love
delusional,
emojis to,
much
like
psycho.
you used to me. Telling her you
We
want
should
to
we should
woo her,
find those
sweep her off her
divorce
feet. How do you think that makes me
proceedings,
feel?
but see
Why
if we can
don't
do
you
that.
say that to me?
It would be interesting.
Going on through the rest of page 43, page 44, including on page 44, dirty cheat, enjoy your porn and jerking yourself off secretly so your parents don't see you and your ugly new girlfriends.
Wow.
I can't wait to finally be with a real man, Ben, who will and has taken care of me. Can't wait to see what he's like in bed. I already know he kisses. Hope it was all worth it. I'm free. As you told Crystal in your messenger text, you're single with a little cutesy dancing dinosaur. Wow. Now you really are. You're despicable. Next text is XOXO from Mo to owner.
Trying to find an actual copy, but I just linked to a YouTube video that apparently has Sarah Boone's divorce lawyer.
Page 50, 6/28, 2019, 10:55:47 p.m. from owner to Mo. Just know I can do so much more damage than all of you put together. Know that. Going on to
Threatening
page
them.
51. Try me.
LJ O'Rourke for 999 says, what in the dissertation? This is like like one of those confessions you get from a criminal, like a mass shooter or a psycho, like why I did it. Like, it's pretty nuts. Robin the Hood for 499 says, where I'm from, there's consequences for talking to my mother that way. Yeah. And understand, he was calm despite that. Another for 5 said only traits of NPD. But the thing is, Sarah chose her victims carefully. She chose George as a victim.
Page 72, July 20th, 2019, 11:34 p.m. From Janice to owner. No metadata, but from Janice. Sorry it's so late. I just read your text. He seemed fine when I saw him at your apartment this morning. He answered the door right away, but was quite bummed out that he overslept. But I was okay and told him, no problem, just get ready and come to work in about half an hour. Then I texted your phone and asked if he would rather work the afternoon shift and get some sleep, but he never answered, so I have no idea where he is or what he's doing. What happened last night, he had a black eye. He said it was new because I asked him and I told him to put makeup on it. He said he had that taken care of. Did you two get in it again? He acted like when I told him he had a black guy, at first he didn't know what I was talking about. I guess he kind of blacked out. You can call me back if you want. $11:30 p.m., 38 seconds.
We don't
To
know.
Mom Jorge.
Although
Janice
I
just
have
called me
a
looking for
fucking
Jorge,
sneaking
and she's
suspicion
pissed. Congrats.
that it was self-inflicted. That would be my suspicion. I think I'm right. This is the October surprise. Yeah. The fucking prosecution, I will say the one thing they did is they saved this strong evidence for last. So they're going to go into the room. Like, not obviously we have
Page
closings, but
82.
they're going to be thinking about this evidence. They did a good
8/21,
job with this.
August 21st, 2019. From Jorge to owner. I love you, my friend, my love, my queen, my everything.
See how he treats her? He got yeeted for calling her his queen, his everything.
Your Honor, that concludes everything I'm going to publish to the jury on this exhibit.
Judge, will we approach you?
Yes.
So like, Judge, prosecution is destroying our case. We got to object to this because they're really hurting us right now. We're not doing too well. Zed said, if you didn't notice, she emailed the brother, but CC'd her ex in on it. She wants to hurt his reputation in front of everyone she could. Exactly. And not only that, but she wants to make herself look good. And so part of it is she's making herself look good and make everybody else look bad, right? Make herself look innocent. It's nuts, actually. Let's fast forward here. Very long bench conference.
Short instruction to.
Here we go.
Members of the jury, thank you for your patience. I just have a short instruction to read to you. Members of the jury, the state showed you portions of what was entered into as State's Exhibit 21. It is not the entirety of State's Exhibit 21. The entirety of State's Exhibit 1 will go back to you into the deliberation room with a laptop for you to review all the exhibits and text messages and the total conversations over and above what was highlighted by the state. With that, State, do you have any other witnesses, evidence, or testimony to provide?
Your Honor, at this time, the state rests its rebuttal case.
All right.
Anything further?
That's it for the state. I like this. Objection, Your Honor. Not enough lube to fight the prosecution.
Approach.
Very good, Gigantor 068.
I think we have some issues outside the presence of the jury.
Okay.
I have one thought, though, that requires a quick vote.
Come on up.
Can we use some of Diddy's 1,000 bottles of baby oil?
Yeah, use the Diddy supplies. Crimson Splat, this is actually a very good observation. My suspicion is she's why he lost his job. I think so too. She's the type that anybody who doesn't pay attention to her, anything that takes away anything, family, friends, job that takes away from her attention, she doesn't like it. She wants to have total and complete control over this other human. This is a fucking sick individual. Locknov Livnok says, quick lesson.
Remember,
kid.
too, as well,
2%.
having a job also takes away that ammunition of being able to berate him for not having a job.
Exactly. It's a cycle of control because she's able to berate him and she's able to financially dominate him because he's got to use her debit card just buy basic stuff, right? So it's a cycle. It's crabs in a bucket and Sarah drags him to hell, right? Trish Chan for 5 says, it's not even that it is particularly well put together prosecution. It is. She just handed them over her conviction on a silver platter. Yep. You know, it'd be funny. And look at this. She's making notes to pass to the defense attorney. Very interesting. I wonder what's on those notes. Like, if we could enhance, that'd be great. Sigrid said,
Not gonna lie,
it back.
I absolutely love her notes and her letters. They're ridiculous.
They're psycho, though. It's Sigrid Eternia says, I take it back. I can't make her any worse. That's true. That's true. By the way, this is the gallery. These are the people watching the trial. This is not the jury. So I know it might seem like this is a view that looks at the jury. This is just the gallery. This is the people watching the trial because they're interested in what's going on, interested in the outcome. Some of these, I think, are family members, actually. I think behind the prosecution, this is the family members. I'm going to play the family video in a second. Christopher Candler says, Once this is over, Brian needs to take their 14-year-old son and get the hell out of the place. He's going to go live with the stigma. Yeah. I feel bad for the kid having have Sarah Boone as a fucking psycho mom. I mean, it's just absolutely insane. All right, let's fast forward here a little bit and get
for a couple minutes. I got some things. All right, members of the jury.
It'd be
We're gonna
funny
go ahead and
if each
excuse
note
you
was
for a couple
just you're
minutes. I got some
fired
things
over
I
and
have to
over
discuss
again.
with counsel outside of your presence. We'll bring you back in for additional instructions on where we think we're going to go after that. Similar instruction that I've given you over the last couple of days. Please do not conduct any independent research or investigation with regards to the persons, places, things, or charge involved in this case, and do not have any discussions amongst yourselves or anyone else about them. We'll bring you back in as promptly as possible. Thank you. Y'all can be seated. Thank you.
Lucky Limes, you said because I've done family
The
law
state
law
has
before. Why is it so
rested
hard for
Mr.
spouses who are
Owens.
so controlled and
Do you have
abused
any intention
by their
on
partner
putting
to
on a
leave?
SIR rebuttal in this
Humans
case?
are extremely
Yes, sir.
good at
Hold on. Yeah, go ahead. Go
acting,
ahead.
and we are more comfortable with what's familiar than what's unknown.
Correct. And a lot of times that's what we know versus what we don't know, right? So the question is, are they going to put on a SIR rebuttal, meaning another like rebuttal of the rebuttal case of the prosecution? This is an InstaLink 360
We did not intend to
camera.
put on
It's good.
Okay, thank you. All right, Ms. Boone, I've got a couple of questions to go over with you, ma'am. You were previously sworn this morning. You've had the opportunity to review and participate in the trial. You've had the opportunity to review the rebuttal case as provided by the state. You've had the opportunity to review and listen to that evidence and witness any cross-examinations as it relates to the state's witnesses in their rebuttal case. Are you satisfied with your attorney's representation of you in this matter?
Definitely.
And are you still on board with the strategy that has been utilized in your defense?
Yes.
Now, your lawyers yesterday told the court that they may want to put on a SIR rebuttal, which would be a limited rebuttal to the evidence presented by the state in their rebuttal of yesterday and today. Your lawyers have indicated that they do not intend on doing that. Similar to other conversations we've had, ma'am, I don't want to know specifics. I just want to know if you and your lawyers have had these conversations. Have you had a conversation with your attorneys about putting on a SIR rebuttal or a reply in response to the state's rebuttal?
Yes.
You had that conversation.
Yes.
Are you on board with the strategy employed by your lawyers that they are not seeking to put on a SIR rebuttal in this case?
I am.
Okay. All right. Is there anything else that we need to address? State.
Judge, you remember you were going to say?
Yes. Thank you, sir. Ms. Boone, at the conclusion of the state's presentation of State's Exhibit 21, Mr. Owens had approached and had advised the court of some objections, specifically with regard to the co-ownership or co-usage of the phone. The court is not permitted to comment on the evidence, and your lawyer was seeking an instruction from the court to advise our jury that both you and Mr. Torres had access to that cell phone. I am prohibited from commenting on the evidence. Now, that doesn't prevent your lawyer or the state from speaking about that in their closing arguments. Just as a matter of law, I am not able to advise the jury as to what that evidence is. The second request pertained to the state moving from place to place through those 108 pages, moving from timestamp to timestamp. The state chose to present that evidence in that manner, which is why I gave that instruction to the jury that not the entirety of Exhibit 21 was provided to them as to what the state produced, and they'll have to have the opportunity to review that in its entirety when they go to deliberate. Do you have any questions about that so far?
So far, no.
Okay. The last portion, ma'am, pertained to the cadence or tone in which you and Mr. Torres communicated with each other. I have no knowledge as to how you and Mr. Torres communicated in text form as to what the tone was behind those words. Your lawyer advised me that there was an objection and you had some concerns as to the way Mr. J may have read those text messages to the jury. I found that the way that he read them was benign, in a flat tone, and did not exacerbate or excite any of the language that was in there. He had read them in as a monotone way as possible in presenting to the jury, and I didn't notice any changes in his cadence or heightening or lowering in the volume or tense or tone utilized in presenting that information to the jury. Do you have any other questions for me, ma'am?
No.
Anything else we need to address, Mr. Owens?
No, sir.
You've been muted this whole time.
I'm muted that whole time. Oh my God. I fucking. Oh, God damn.
Look, here's the thing.
Fine. Listen,
I'm going to be honest with you. I'm kind of retarded.
No! No!
I'm sorry, guys. I'm sorry. We thought this would be a day without scuff. People were like, oh, he started without scuff. Oh, I'll start without
That was
scuff.
in the chat for the scuff.
Yeah. Professional streamer, guys. Professional streamer. Legal mindset. Holy fuck. I don't even know what the fuck I was going to talk about. Anyways, that was about... Bro, I'm gonna host the chat. Bro, what is this? What is this? Chat is revolting. No, you plebs, stop revolting. Stop, I'll put you down. Even my mods, I have a mod revolt on my hands right now. What the fuck?
Oh, please. I'm sorry. I didn't mean it. Wait.
That's it. I'm banning them all. I'm joking. Oh, god damn. Oh, wow. Holy shit. Okay. L with an extra L. Hold this L. Oh, god damn. Smug Elf is enjoying this. Ava's like, what is going on here? Okay, you know what? Fuck it. I was going to read some text messages for you and do it in a way that was actually emotive, right? But you know what? I'm going to have Ava do it. Ava, read this one here. This top one, the top one on the screen. You can see that, right?
Okay, yeah, I can see it. Let's see here. Yo, I like you all. He's a dick and the sheriff just left. Sorry, I couldn't expect. I'll always respect you all. Know that. He's not here anymore. And yes, I am a bitch. So are you.
That is reading it with emotion. That's not how he read this, right? Because if we go and we listen to how he read it.
Just left. Sorry I couldn't text back. I'll always respect you all. You know that. He's not here anymore. And yes, I am a bitch. So are you.
He read that as neutrally as possible. Like he was super flat. Come on. Like you're going to try to say that this guy was over here giving a biased presentation? No, fuck you.
If she'll let me. I don't know if it's at her as to that issue. I plan on communicating with the chief during the lunch hour as to that issue.
One more. Oh, sorry. I missed
communicating. Seek the norm. Yes.
How late are you going to keep them?
9 o'clock is the norm.
9 o'clock.
I may, because it's the weekend and it's Friday, I may seek special dispensation from the chief to stay longer.
Then 9 p.m.
Communicating with the chief during the lunch hour as to that issue.
I think that would be great.
If she'll let me. I don't know if it's at her.
They're
discretion.
deliberating today then.
I know I have
That
to
means
seek
that
approval
jury's
after
making
7.
a decision today.
I'm not worried about that. I know. And I would prefer them to work late into the evening if they're on board with doing that, rather than coming back Monday.
We're doing it today. We're doing it live, baby. We're going long,
give me a moment
baby.
so I can go back up to chambers,
Long,
get with Miss Barrios,
long
and I'll give paper
stream.
copies of everything from the revisions that we made this morning. Let's go ahead and bring back in our jury. And I agree with Mr. Owens. I'd rather us waiting on them than them waiting on us. So I think 1:30 is the way to fly. Let's go ahead and bring back in our jury.
A long, long stream. So I have some other stuff to play, like stuff that involves George's family, and there's also the Sarah Boone divorce court letter. I'm going to save all of that for when the jury is deliberating, because we need to fill a lot of dead time when that's happening. So I'm going to save that for that time. I don't think it'll take till 9, but it could. It depends how long the closing is. Bad News Badger says he's emotional as a fart in church.
Yeah, the defense really wanted deliberations to happen on Monday.
They were trying to delay.
They wanted a full weekend for everyone to calm down from what they saw.
Mark said they need to come back Monday for the state Bologna. No, I'm Mark. I would disagree with you, man. I think this should be done. Frankly, you shouldn't have to haul somebody back in to not get paid. Every day they're not working, they're not getting paid whatever they would,
State,
which
do
is
you
more
recognize
than
our
they
jury?
get from jury duty.
Defense, do you recognize our jury? I thank you. Y'all can be seated. Members of the jury number 2 in the back. He's ready. He gets it. All right. Can you raise those hands one more time?
And
for
see,
me? All right, record reflect. Hands have been raised. as
They
compliance
want
with
this to
regard the
move
court's
too.
Instructions.
The jury
Members
knows.
of the jury, all the evidence and testimony sought to be provided by the state and the defense have been provided
Yeah,
to
the
us over
jury
last
is
week.
antsy to get this
At this
through.
point in time, the state and the defense and I need to discuss the law to be given to you in instructions. That's going to take a little bit of time. So we're going to go ahead and excuse you at this point in time for a longer lunch break than what you've had previously. And we're going to ask you to come back here at 1:30. At that point in time, the court will begin to instruct you on the law that you are to apply in this case. Then the parties will begin with their closing arguments. The state will go first, then the defense. Then the state will have the opportunity to rebut any of the defense's arguments. After hearing the closing arguments, the court will provide you final instructions before releasing you to deliberate in this matter. We may work past 9 o'clock tonight. We may go late into the evening. So if there are any plans or things that you need to reach out to, as we discussed last week during jury selection, that we could work till late as 9, and we may work later than that this evening. If there's anyone that has any concerns as to working that late, please raise your hands at this time. Court sees no hands. I would also ask of you, if you could, please reach out to any family members or friends to, one, advise them that you're on the jury and will be deliberating this evening. And if there's any accommodations or issues with minor children or family that need to be taken care of, I would ask you that you take care of that during our lunch break.
And the emergency phone number, since they won't phone.
Yes, we will provide you. The court deputy will provide you the emergency phone number when we get back from lunch, so that you can provide that during a break that we'll have this afternoon to any friends or family or loved ones if they need to get in contact with you. I will give you a similar instruction that I've given you over the last couple of days. I know you're probably tired of it, but I got to give it to you one more time. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not you must not use phones, computers, or electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your attentiveness, service, and sacrifice, and we'll see you at 1:30. Juror number 2 in the back. Yes, sir.
Question. So
Answer.
for parking, we're gonna be here for some time. Can we leave and come back and get re-stamped with a new thing?
We will have you that answer when we come back.
Okay.
Madam Clerk's going to figure that out for you.
Okay.
All right. Thank you very much. Yeah.
This judge is so Orsa Flats here said, I like this judge, very fair, super fair, and efficient. What I like about him is he's efficient. He's run this trial.
Could you do that, Officer Jones?
Hyper efficient.
I've been advised by, you know what, rather than double speak, could you just tell me what it was? Say it for the record, what it was.
Judges approve that they are to go off campus or out of the courthouse garage, they can come back and get new stamps, cards.
So they can leave this point during lunchtime.
And I'll approve that. So, State, anything else we got to discuss?
I swear a case
Other than the jury
somebody needs to be done all the weird shit that happens in Florida. Yeah.
Okay.
Welcome to
Court's gonna run
Florida,
upstairs,
baby.
Put the finishing touches on what we agreed to this morning. I'll bring back paper copies for everyone, and then we can continue the charging conference. At that time, court's going to be in a short recess. We'll be back as promptly as possible. Thank you.
All right. So I'll take that off for a second. We're obviously going to fast forward because we're still behind, but let me catch up on all your comments. I hope the prosecution's closing is just standing up, playing the suitcase videos, saying nothing at all, and sitting back down. They don't have to do much more than that. Sometimes the most effective closings are very simple, are like playing the video. And also, you know, even going and just be like, play the video, say, Sarah says everything is going good, and then play some of that other video they played yesterday and, you know, show how she really is, and then end. Right? But they're definitely going to play the suitcase video. There's no fucking way they don't. Right?
Now,
There's
closing arguments rarely have objections, but I feel like Owens might be objected to because he's going to be trying to delay and filibuster.
Owens is going to object without a doubt. He's going to fucking find something to object to for sure. 100%. Yeah. Let's see. Someone asked if someone blind or deaf, will they be placed on a jury? Probably not. They'll be excused for that because it might prohibit them from properly assessing certain types of evidence, right? So you might argue that the person's not getting their due process. The criminal defendant's not getting the fair due process because the juror is not capable of that. However, if there's a way to mitigate that, maybe, but typically that might be a reason to have somebody reasonably excluded.
You can object to closing statements, but it's rare and usually only under the most egregious violations on behalf of counsel.
If they wanted to delay this, why didn't they do a rebuttal? There's probably not much to rebut. And remember, whenever they do that, it can end up hurting their case too. And Sarah does have some control over her case. She could say, hey, listen, I don't want to do that, right? Because what are they going to do? Put Sarah on the stand in order to counteract some of this information? Like, that's not going to go well. That's going to go fucking horribly. Baloney Bong said, defense, Your Honor, help. Cry me a river, Andrew. Poor jurors. Look, listen, man. I do feel bad for them. They're not. It's a required. Yes, you're required to do it. It's your civic duty and all that stuff. But they're not being paid, and people in the U.S. don't get, like, normal average people which serve on a jury, like, don't get paid enough to offset that. I do feel bad for them. I do. King Lucius gifted 5 legal mindset memberships. Thank you so much. Yes. Zergling said, any chance of voluntary or first degree? No, they cannot increase your charge. We're getting second degree and we're getting manslaughter. So they can decide that it's not second degree and go with manslaughter, which doesn't require any, and I mean any, it doesn't require any sort of intent, right? So you're just dealing with a level of kind of criminal recklessness at that point, right? Manslaughter. So it's, and let me get the actual statute in Florida here. Manslaughter, if we're getting just regular manslaughter, right? There's no intent to kill, so there's no malice aforethought, right? And yeah, they're going to be able to get that. They're going to be able to get that there. Intentionally or culpably negligent. That's the word. Intentionally or culpably negligent conduct. Yes. So culpably negligent does not require intent. Pro streamer, pro scuffer, more like. Indeed. Drisbin, L Eagle, disciple of Wah for 2,000 dong, says, it's scuffing time. William Barnes says, Your Honor, when we go back to deliberate, does the first of us have to wait for the last one to get in, or can we all start coming back out? That's fucked up. Coding Light says, regardless of who you're voting for, one thing we can all agree on, no more political ads. Yes. You know what? Just for that, I'm going to do a test. I'm going to manually run a YouTube ad. Okay, I'm going to put up a poll here. Tell me when I run this ad, if you get an ad, is the ad a political ad? Okay, yes, no, or I'm going to put I have premium, all your base are belong. I'll just put all your base because that won't fit. Right? Okay. So I'm going to run an ad. Tell me if it's political. Actually, I'm going to run a second ad. Tell me if it's political. You have ad block. Okay, yeah. Okay, if you have ad blocker, you can select the premium option. It's effectively the thing. Laughs and ad block. Oh, good for the premium. There's a lot of premium people. Good. I mean, I have premium too. I'm a fucking YouTuber, and so I watch God knows how many YouTube videos. Brave Browser W. Got you. Yeah, I'm happy though to see no more political ads. Even abroad, I get them because I get these weird. They're usually, and I'm just going to be honest, they're usually left-leaning organizations that are encouraging foreigners or expats to vote, and they're really fucking weird, creepy messages. So I'm hoping to stop getting them as well. Anthony,
you know
for
what's
$5.
interesting?
So go ahead.
In Mexico, there's a lot of right-winged political ads for America.
Really? In Mexico?
Yeah, I was down in America for 2 years, and I started seeing a lot, and it was paid for by Republican foundations. They weren't leftist foundations. Just a weird difference because other countries, you're correct, it's usually left-leaning, but not down in Mexico.
That's very interesting. Maybe they're like targeting that very specifically. Like, it's very, very interesting. Some Mexicans are extremely based. So, very possible. King Lucia says, this is good ASMR to sleep and wake up to. For sure. Calling it now. If they don't return a verdict in the first hour, they're going to get a free dinner. Let Sarah stew and then put her away. They'll probably get some food regardless. Anthony says, should come work for the post office. We get normal pay while we... Oh, that's good. Well, that's specific to your job. Most people don't. But if you're working as a fucking, I don't know, a bartender or a waiter or sales staff, you're not getting anything. Especially if you're like a commission job, you're really getting fucked. For Fred says, I listen to 7 streams at the same time, legal. I'm not accepting any ads. Oh, damn. You're like a fucking stockbroker of streams, for Fred. You're out there with the fucking command center. I've actually got a giant monitor here that is in the Airbnb, but I didn't want to fuck with trying to set it up. I think is it just what type of connection is this? I think it's just an HDMI. Yeah, it's just an HDMI. So I think this laptop has an HDMI somewhere. If not, I'm gonna have to get a fucking adapter. But it's Korea. We have the technology. We can do this. Yeah, we'll get an adapter. We get an adapter. I can find an adapter because I don't think this one has an HDMI. Now this laptop does not have an HDMI slot, so I have to get an adapter. I'll go find one. But yeah. And I think that's everybody. Let me make sure locals is good. Vegehan says, I have locals, all your base. That's true. And I think I caught up. Yes, caught up the locals too. Okay, cool. Awesome. Wuten von Puta says, Ellen from Seinfeld keeps telling me to vote. That's weird. That's fucking weird. All right, let's go back. And let's fast forward to when they're back.
For the state.
Dave Ketchner on behalf of the state. William J. for the state.
Defense?
Tony Henderson for Sarah Boone.
Kevin back on behalf of Sarah Boone, Your Honor.
Okay. Where might Mr. Owens be?
Judge, Mr. Owens is doing some preparation. I am.
Okay. If the state and the defense can approach, I have paper copies of the revised jury instruction. You'll see on the bottom of each page is a file and path name. That's just for my own edification of where I've stored them. So then we make additional changes. The revisions that we discussed earlier today have already been made. There's still a couple cleanups.
Yeah, this is like the Kamala of the defense
Oh,
taking
it
over
says
the
enters into
administration.
preparation
but all
chamber.
the revisions
He's
that we
currently
spoke about
praying
this
for
morning
this
have been
closing
included.
statement.
With that,
He's applying
I think that
Diddy's
takes
baby
us
oil to his anus.
Page 9 of 28 in the 3.6F instruction. I also have the defendant's revised portions as to 3.6. Just for the court's clarification, is what is in page 9 of 28 of what was provided to the parties, is that the same as the separate defense 3.6F instruction?
Yes, Your Honor, it was only provided for more convenience for you to copy and paste them.
Got it. Okay, so should we be relying on the 3.6F instruction you, Ms. Henderson, sent last night?
Yes, sir.
Okay, all right. State, do you have that?
I have a digital copy of mine.
Okay, all right. Tell me when you have it pulled up in front of you, sir, and then we'll.
It's pulled up and I sent everybody the state's digital copy as well.
Okay, very good. All right. Let me pull up the digital copy that I have. Give me a moment.
Yes, sir.
Okay. All right, the court has the 3.6F instruction as provided by the defense. As to the first paragraph, it is a defense to the crime, bracket S bracket, of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of or threatened use of deadly force. What say the state as to this instruction? And should not manslaughter be included?
It should be second-degree murder, manslaughter, and culpable negligence, even though culpable negligence doesn't involve an intentional act. But I'm not going to fight with that.
Okay. Any objection to that addition?
No, Your Honor.
Okay.
Judge?
Yes, sir.
Can I interrupt for just a minute? Because there's a special instruction that the state is requesting on causation.
Yes.
And that goes, it's going to come before the self-defense.
When it was used in the previous case that I cited, that I used it in 12 years ago, it's part of the instructions in second-degree murder. Yes, is where I would be requesting it.
And this is just so that we're all on the same page. Forgive me. This is the state's request for special jury instruction on causation.
Yes, sir. I suggest we table that for now and just get to the self-defense.
Okay. All right. So we'll revisit the state's request at that point in time. So is the second or the first full paragraph is read, is that acceptable to the defense?
Yes, Your Honor.
Okay. Moving now to the deadly force definition. That seems to track the language of the proposed jury instruction completely. Any revisions to that state?
No, sir.
Defense. It's your instruction, so I'm assuming you've got no quarrel with it.
No, Your Honor.
Moving to the next paragraph, I also believe that that's from the Form 3.6 instruction. State, any issue with the third full paragraph?
So in my request, I struck through or threatening to use each time because the evidence doesn't support that. What the evidence supports is she did actually use force. It wasn't a threat of force. So I think it's unnecessary and confusing and not supported by the evidence to have that clause in each of the paragraphs where it's mentioned.
Response, defense.
Judge, I have no problem with that. I was just, when I put it in, I just was throwing out some statements that the state had made and different arguments. So.
Would the judge stop defense counsel if they unironically
Okay.
tried to make the
So just so that
Chewbacca
I'm
defense?
clear, you've got no objection to the removal of that language.
They,
So the
they
third
allow them to do a
paragraph
lot of
would now
ridiculous
read,
shit.
Sarah Boone does not have the burden
The
of
judge
proving
wouldn't, the
that she was
prosecutor might get
justified
object.
in justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. Is that correct, state? Is that correct, defense?
Yes.
All right, very good. Yes, sir.
To make it quicker,
And Mr. Henderson, you don't need to stand up every time, sir. I appreciate it.
I'm sorry, but it's old.
I get it.
But it's out of habit. Judge, every time that comes up,
You lose it?
yes.
Understood. So then just let's go back to the title then. Can we revise the title to 3.6F, justifiable use of deadly force, and remove that bracketed or threatened use language?
It should just be used.
Okay, very good. All right. The next sentence, the law on the justifiable use of deadly force is as follows. Is that acceptable? State.
Just the strike through.
As I read it, yes. Is that acceptable defense?
Yes, Your Honor.
Moving now, Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent A, imminent death or great bodily harm to herself. Is that acceptable to the state?
It's acceptable, just confirm that they don't want to be.
Yes, confirmed, only what would be read would be A.
That's correct.
Okay, all right. Is that acceptable, state, with that understanding?
Yes, sir.
Okay, moving now to the next portion.
Mechanicus
Boone
Golden Gear. They are bent over right now.
had no duty to retreat before using deadly force. I mean, my review of the case law, and I don't recall which one it is that if you're on your own home, you don't have to retreat.
Yes, that's true.
My understanding.
Welcome to Florida, baby.
She used force first by zipping him up in the suitcase and doing so that, one, she could make him feel like he had made her feel in the past for choking and cheating on her, and two, to give her a platform to be able to speak to him as a captive audience, and he would have to listen. Because she took the actions of an initial aggressor, it is our position that there is a duty to retreat caused by the initial aggression, as that is addressed lower in the jury instructions.
Response, defense.
Judge, I have a different view of the evidence. I
No
think
shit.
what the evidence has said about the initial in the suitcase is that Mr. Torres was getting into the suitcase and positioning himself into the suitcase when Miss Boone came down. There was laughter between the two of them. The suitcase was zipped, and it was a consensual deal. It was a consensual thing. She didn't use any threat or use of force at that time to zip him in the suitcase. Furthermore, during the demonstration and when they were demonstrating the suitcase and the zipping ability, I know time has passed, but I hadn't seen anything different to keep someone in there who didn't want to be in there. If someone didn't want to be in there, it would be almost literally impossible to zip that suitcase.
Impossible.
That's how much force it took to zip that suitcase. So the evidence doesn't support it.
You didn't prove that.
Doesn't support.
You didn't show
the
that
duty
at
to
all.
Retreat.
Correct, because what they're saying.
They didn't see that. Here's the thing. Even if he's right, they didn't at trial bring in a zipper expert. They didn't bring in somebody that proved that what he's saying is true. He's just making a fucking observation that was never presented at trial and trying to force this into the jury instructions. It's actually kind of nuts.
Going back, even before we had stand your ground, just going back to the castle doctrine, there was never a duty to retreat from your home.
So then if I understand your argument, you are not seeking to have this included then?
I am seeking.
Because if you're saying
He
she
doesn't
had
know
no
what
duty
he's
to
seeking.
retreat,
That's correct.
this talks about hang on, let me just reread it. Okay, so I think I follow your argument. Okay.
What I'm saying is that it should be no duty to treat, that Sarah Boone had no duty to retreat. That's what we're requesting. I believe the state's objecting to that and saying that it is a dispute. So they want the next paragraph as to the court. But there is nothing that showed at that time, because the state's arguing that she forcefully put him in the suitcase.
Response.
That's a straw man argument. That is not the state's argument. We know what the evidence in this case is. The evidence that she provided was he got into that suitcase by himself and they were playing hide and seek, and he was inside but not completely hidden. The lid was flapping over him. She came over and zipped it shut to whether it's 100% or near 100% shut. And it was all in fun and jest at first, but he did indicate, and we saw it on the video, image IMG_1062, Sarah, I can't breathe, Sarah, I can't breathe. He was being held against his will in that suitcase. That there's no requirement that she initially forced him into it or not. It's no different than two people wrestling and play fighting, and one person has another person in a headlock, and then there comes a point in time where I'm tapping out. Jorge Torres was tapping out, and that's on video, and it's in her testimony. It's uncontroverted. There is sufficient evidence for there to be a dispute as to whether or not she was the initial aggressor, and whether that generates a duty to retreat. Quite frankly, it's undisputed evidence because it's uniquely only her testimony coupled with the video. She restrained him in that suitcase on purpose and intentionally. And if you look at the elements of aggravated assault in our proposal,
This procedural victory would be a huge one.
that is exactly what was going on. She intended for him to feel fearful of an inability to breathe, to make it feel like he had made her feel when he had choked her. An aggravated assault is defined as follows: Sarah Boone intentionally and unlawfully threatened, either by word or act, to do violence to George Torres. She would not let him out. She would not release the headlock when he indicated he could not breathe. At the time, Sarah Boone appeared to have the ability to carry out the threat. Well, the video evidence is res ipsa loquitur.
Ooh, res ipsa. I love it.
He could not get out on his own at 11:12 in the first movie. He could not get out on his own at 11:23 in the second movie. And quite frankly, he couldn't get out at 11:03 during the still photo as well. Element 3. The act of Sarah Boone created in the mind of George Torres a well-founded fear that violence was about to take place. Absolutely. Sarah, I can't breathe. Babe, I can't fucking breathe. Sarah, shh, go fuck yourself. The assault was made with a deadly weapon, element 4. An object not designed to inflict bodily harm may nevertheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Well, ladies and gentlemen, it did cause death. So that's not a dispute. So it's our position that she was the initial aggressor based on her testimony that we received in court, and that is going to put into play a duty to retreat, and that the parties can argue about that.
Anything further, Mr. Henderson?
Yes, Judge. I want to clarify this because the initial thing in getting into the suitcase, the act is zipping the suitcase up. That act of zipping the suitcase up was not done forcefully. The testimony was he agreed. He was in the suitcase. He was the one who got into the suitcase to begin with. He agreed. The suitcase was zipped up, and there was no argument at that time. All right. And just by the demonstration that they gave, you could see somebody to get in that suitcase or not get out of it at that time wanted to be in that suitcase. And there's nothing to dispute what she says, that he agreed, she zipped the suitcase, and they both laughed and thought it was funny. Now, the next thing that the state goes to is an omission. It is not an act. It is an omission at that point in time where she's saying, when they say, oh, he can't breathe, well, she doesn't go let him out. So they're saying, so they're trying to make that an act when it is not, when she just did not let him out. It's different. And what we're talking about is just the duty to retreat at this time. We're not even talking about the other parts as the thing, but as to the duty to retreat, she's in her home. And at that point in time, when that act took place, she had no duty to retreat.
Here's
She
what the
could've.
form instruction says.
She could have.
If it is undisputed by the parties that the defendant had no duty to retreat, give the following sentence.
It's not.
Defendant had no duty to retreat before using or threatening to use deadly force. Instruction goes on to read, if the parties dispute whether the defendant had a duty to retreat, give the following paragraph. Sounds like both of y'all, are disputing whether or not there's a duty to retreat.
Yes.
So I think I have to,
They're
based on what
disputing
the
it.
Florida Supreme Court's instruction to me is to give that second paragraph.
Yes.
State,
Yes. Do it.
anything further?
No, thank you.
Defense, anything further?
Just note the objection. But
Yeah, you're
Okay. All right.
okay.
So the
like always, you're fucking objecting for no reason.
the
Congratulations.
language
This guy's just
in-
as bad as Owens. Just as fucking
the
bad.
red line from the defense as to Sarah Boone had no duty to retreat before using deadly force will be removed. And I will add in the state's proposed language, which tracks the form instruction. Is there any objection? Do you want me to read that to you, Mr. Henderson?
No, I'll read it.
Can you read?
Okay.
I don't know.
And I just want to make sure we're all on the same page. That's the state's proposed revisions to the 3.6F on the top of page 2 of 7.
Yeah.
The judge checked him well.
Sure. Okay. If Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter okay, I will add that. Thank you. For which, so it'll read, if Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter or culpable negligence for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had a right to be, then the defendant had no duty to retreat before using deadly force. On the other hand, 1, if at the time Sarah Boone used deadly force, she was committing an aggravated assault, or if at the time Sarah Boone used deadly force, she was not in a place where she had a right to be, then the defendant had a duty to retreat. The duty to retreat means the defendant had the legal obligation to use every reasonable means to avoid any danger before using deadly force. The law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm or imminent danger of the commission of parentheses applicable forcible felony end parentheses against herself, and it would have increased her own danger to retreat, or if retreat would have been futile. But if the defendant had a duty to retreat, and if she could have safely retreated but did not do so, then her use of deadly force was not justifiable. I do have a question as to the applicable forcible felony portion of that.
A, B. That's for her, for the A and B that very previously discussed, not for the.
That is correct. So then that sentence would be revised to, the law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm, and it would have increased her own danger to retreat. What say you, Mr. Henderson?
Judge, I enter objection as to the instruction, as the state has included to get this instruction, an aggravated assault, which is not charged in the information.
State response.
Judge, I'm happy to hop into that one as well.
Okay.
I understand what Martinez versus State says, and I'm sure we've all read the opinion. It's in my motions, and I understand what it
I'll get all the chats after they finish with
it
it.
says all throughout the opinion is there needs to be an independent forcible felony. And then at the very, very end of the opinion, then it says there needs to be an independent felony charged. Why I'm asking for a special jury instruction, and I made that request in writing, is because under the standard jury instruction that we are going through right now, it says, according to Martinez versus State, that the independent forcible felony needs to be charged. The whole purpose of this is you can't engage into a circular logic argument that defeats Ms. Boone's right to self-defense. So it would be preposterous to include in this jury instruction, Ms. Boone did not have a right to use justifiable use of deadly force by committing second-degree murder against the victim when that's the charged offense. Because she, of course, would have the right to use deadly force to defend herself against the victim, and that would be correct. But what we have in this case, and what the state has alerted the court and the defendant to well before trial, was the evidence shows that she committed a separate aggravated assault. She, at the time that she had already zipped him shut in there, and again, just because she releases that quote-unquote chokehold by sitting on the couch, she is exerting that force through distance because she's the one that zipped him shut. So she, in using that force, is the one who did that on purpose to make him feel like he was choking and make him feel like he had made her feel like when she was getting cheated on, and to intentionally confine him in a place so that she could speak to him about her thoughts. As I already outlined, it's the state's position, and the evidence does support that this is an aggravated assault. She intentionally put him in fear of death, and she relished it. She relished it for that 2-minute video. That is prior to when she says, well, now he's sticking his fingers out and I get scared by that action. And by that action, it's George Torres just trying to exert the will to live and to survive and be on this earth. That now that action, if his attempt to escape out of the suitcase that she has left him zipped up in, is this independent threat of great bodily harm and death to her. She testifies if he gets out, it's her belief that he will beat her up, kill her, disfigure her, so on and so forth. And her testimony at trial, I believe she said was, he said that I will end you. So what we have here is they, by their own admissions, through the testimony that she provided, that there is a separate and distinct independent forcible felony from what ends up being the second-degree murder. What ends up now being the second-degree murder is at this point in time when she says, well, he's trying to get out. I'm afraid if he gets out, I'm going to get disfigured or killed. And so that is why Ms. Boone makes the decision, and I'm not even going down the aggravated battery path, but she batters him with a bat on the hands and batters him, pokes him while he's in the suitcase, and basically beats him into submission so that he stops trying to escape. That's what the testimony was. And then she makes the decision to now leave him and go upstairs and go to sleep without having relieved him from the force that she exerted earlier committing aggravated assault. So like the example I gave you earlier, this is absolutely no different than me pointing a gun at you, Judge, and putting you in fear of your life that I'm going to shoot you and a projectile is going to enter your body and kill you or give you great bodily harm. And you, in turn, after having been placed in fear by me pointing a gun at you, you begin to defend yourself and exert your right to live on this earth by pulling your own firearm. And now, do I, as the initial aggressor, the initial person who committed the forcible felony of aggravated assault on you, under the law, I don't have the right now to defend myself against you. I need to retreat. I need to make it clear. Sorry, man, my bad.
This is about the jury instructions, guys.
That is what is the law. 776041 is a very short
Lawyer battle.
and very, very simple statute.
Yeah,
It has not
the
changed.
defense is being really petty.
This has been the law. This was the law.
And
at the
this
time.
guy is doing a good
This
job
is
of pretending he's
2020.
Owens.
776041 provides the justification described in the
Orso
proceeding
Flats, I
sections
agree.
of
You're
this
all wrong.
chapter
Owens is
not
enrolling in
available
This is
to
Lawyer
persons who,
Mon.
one, is attempting to committing, or
Defense.
escaping the commission
Me
of a
petty.
forcible felony. So taking away the firearm example,
Use your
it's a
petty
chokehold.
objection attack.
His cause
It's
of
not
death,
very
according to the
effective.
medical examiner, was asphyxiation by position and environmental suffocation caused by her not releasing a chokehold on him when he indicated, "Babe, I can't
Will Spain,
breathe. Sarah, help."
this is just lawyers
That is
talking
an independent
shit about other
forcible
lawyers.
felony,
Uh-oh,
separate and
judge is
distinct
using
now from
fury.
What she says is the victim.
Yeah, we're
like
not
you
even at closing yet.
pulling a gun to defend yourself from me pulling a gun on you. Now, the threatened use of force that the victim is exerting is sticking his hands out and saying, "I'm going to end you." That is the distinct break between the aggravated assault and now.
Yes, this is the real
her
lawfare.
continuing to use this unlawful force, which she's not entitled to do because she started it. She was the initial aggressor in committing this aggravated assault. And she ends up just leaving him to die and never releasing the chokehold.
And the unlawful threat is what's on the video in your realm.
Yes.
Okay.
Okay,
And-
I'm asking
and
you
any
guys
facts that support
because
that
this is what
should
they're arguing
cause
about.
this
Who do you
jury
guys think who
instruction
started
given.
this? Do you think
The
Sarah or
absolute
George?
only hang up about whether or not this jury instruction should be given is because Martinez slightly overstates what is necessary to prevent this circular logic, which is not going to occur in this case. There is not going to be any arguments by the
Blades.
state.
Objection, I'm a clown,
that
Your
she
Honor.
does not have the right to defend herself if she is in imminent fear or death of great bodily harm by the victim. She testified that him sticking his hands out of the suitcase and saying, "I'm going to end you," put her in fear of imminent death and great bodily harm. And in turn, what she did was she decided to not let him out. And he ended up dying. And that is second-degree murder. That is separate than what preceded that. What preceded that was her not letting him out when you can see him pushing up on the suitcase in the video, begging to get let out, and she doesn't because she is doing this out of anger, hatred, ill will, and spite to teach him a lesson and put him in fear of death or great bodily harm. That's an aggravated assault. I would absolutely charge her with aggravated assault and aggravated battery, separate independent forcible felonies, if I could. But I did not learn this information until after the statute of limitations had passed. That is through no fault of the states. So we absolutely would, if we could. And
They
we are
charged
not
her with
gonna
as
make
many
the
things as they
argument
could,
to
yes.
defeat her defense of second-degree murder by saying, "Well, you can't defend yourself with second." I understand what they're getting at in Martinez. That's not this case, though. It's broken down into those parts.
Can I have the citation for Martinez? Because unless I missed it in your motions, I didn't see Martinez cited in the motions.
Yeah,
And forgive me if
Andrew
I-
now has
That's been
a
in
AI assisted
previous,
camera.
motions.
Because you cited a cologne with regard to the Miranda issue.
No, I'm referring to, there's a pleading entitled State's Request for Forcible Felony Instruction and Request for Initial Aggressor Instruction, which we've kind of hopped into now since aggravated assault is being mentioned in this paragraph. In paragraph,
Oh, there it is. I apologize.
yeah, paragraphs 12 through 31 are the legal analysis, and Martinez is cited in there at paragraph 19 at 981 Southern 2nd 449 Florida 2008.
Sometimes it goes.
And more importantly,
Your
what
microphone was in
Martinez
the way.
doesn't say is that there's like
If you're
some
wondering why I wasn't
requirement
following
that
you.
the verdicts
Probably
would be
trying to track about
interlocking.
this.
Like there's no requirement that second degree murder be count 1 and aggravated assault be count 2, and then if they return a not guilty verdict on aggravated assault, then there has to be a not guilty verdict on the second degree murder. That's not the case because there's so many different prongs to the self-defense instructions. So it's not required to be charged for some reason of an interlocking verdict. And the whole spirit of that opinion is that it is to make sure that we do not defeat her self-defense argument that she's entitled to make about why she committed second degree murder. All we're saying is you're not entitled to defend yourself in that manner if you committed an aggravated assault to start this. And that's what the facts show. It's a little complicated, and there's another special jury instruction related to this force by distance. It's like tying somebody to some train tracks and walking away. I mean, are you still choking the person? No, but are they restrained in a manner that if a train comes, they will die? Yes. So the special circumstances of this case and the facts are going to warrant, in the state's estimation, the forcible felony paragraph, and then that language being placed into this initial paragraph that we're talking about.
Just reading Martinez. Give me a moment.
Yes, sir.
Fucking Chad Judge who's reading the whole case in 2 seconds. Let me read some of these. Chris Candler for 2 says, once you say stop, no, or consent is withdrawn.
For the record, the three
I agree.
prongs for a special jury instruction, which I cited in a couple of my other pleadings. A special jury instruction is warranted when A, the special instruction is supported by
By the way, under the poll, 95% of you think Sarah started it. Only 5% of you think George started
standard
it.
instruction
95% of
cover
you.
the legal theory it is meant to.
But also, guys, smash a like button. We only have 396 likes, and there's 1,000 people watching. So please, let's get those likes up.
Of the law and not misleading.
Let's get those likes
That
up.
is also the case. Stevens, STEPHENS.
You know, we still have that lawyer Big Iron parody if we reach 1,000 likes during stream.
During the
I think
stream.
it's 7:55 is the pinpoint. Yeah, I reviewed that already. Thank you. Response.
Response is clear, Judge. They're trying to make exceptions for the law. That doesn't work here. Simply this, what the requirement is under Martinez to get the aggressor is this. It's only applicable and only in cases where the defendant was charged with either an independent forcible felony, that's Martinez, or B, felony murder. That's a different case. In Martinez, they have not charged an independent forcible felony. So it doesn't apply. It tells us right there. That's the standard jury instruction. For him to come back here and say, well, really, Judge, they overstated Martinez. Martinez is still good law. It has not been changed. That's the rule.
We don't
That's the requirement.
We don't change here since 1922.
But this is relying. Martinez's opinion states, indeed, consistent with this case law in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. That doesn't seem to be what the new instruction says, unless I'm missing something.
Like the stream.
I'm sorry, can you?
Because I like the Spike Man.
The sentence says, indeed, consistent with this case law, in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. And unless I'm missing something, a 3.6F instruction doesn't say that now. The form instruction.
Judge, when it comes to the aggressor in the standard jury instructions, when it comes to aggressor, and they're talking about under 776.041 sub 1, it's to only be given if and only in cases where the defendant is charged with either an independent forcible felony. You cannot give this instruction unless there's an independent forcible felony that Ms. Boone has been charged with, and there just isn't one.
But where does it say that in the form instruction?
And this may be a genuine procedural weirdness of the law.
776.041 Friend 1, Florida statute, give if applicable and only in cases. where the
Sarah's lawyer
defendant
can't keep up. Nobody
commit
knows,
an
cares about how
intent
George got in the
felony
suitcase. The problem is she didn't let him out. Yeah.
2008, or the felon. And we're acknowledging that.
And thank you for the memberships. Thank you, Orsa Platts, for 20. And thank you, Anonymous Nobody. If you received a gift membership, please say thank you to Orsa Platts and Anonymous Nobody. I'll play a clip once it goes to break, but thank you guys. Thank you guys.
She committed an aggravated assault. After that, the defendant is saying the victim placed her in fear of imminent harm or death by trying to escape her aggravated assault, by sticking his fingers out, and by saying, as he's trying to escape, I'm going to end you.
But isn't that in the giving the aggressor definition? I mean, is that, but unless I missed something, that's not what we're talking about right now.
I agree, but I think it cohabitates together.
Okay.
And it's our position, we absolutely would charge her. And it's a legal technicality in part of this standard instruction that we can't because of the statute of limitations. We all know, all of us here together as attorneys know that those facts, if believed by the jury, support that she violated Chapter 776041, Friend 1. She should not be able to get away with murder because of a statute of limitations technicality.
Very good one there.
That was through no fault of the state's own. The purpose and spirit of Martinez is to make sure that we're not up there arguing, ladies and gentlemen of the jury, she had no right to defend herself from an imminent threat of harm by killing somebody. That's not what we're going to say. We understand that. What we are going to say is, ladies and gentlemen of the jury, she had no right to leave him in that suitcase out of fear and great bodily harm or imminent death because she committed an aggravated assault to put him in that predicament. That's the evidence in the case. That's the arguments that's going to be made. That's why we're making a special instruction request based on the unique facts and circumstances of this particular case.
Give me a second.
All right, while he does that, let me see if I can read here. Bilson Saban says, every job I've worked is normal paying during jury duty, although only for 2 weeks. Not every job is like that. Your job is like that, but not every job is like that. Sigrid Eterna says, what is the over-under that Boone is an outburst in the case of an unfavorable verdict? I would love it. It'd be good TV, but we'll see. She's been calm so far. I got to look, I'm not going to make shit up. She hasn't had any outbursts, but we'll see when she loses. If she loses, because of course you never know how it could come out. It could be a hung jury. Who knows? For Fred says consensual. I remember someone doing a joke to me and laughing while hoping it wasn't true. Fortunately, in my case, it wasn't. Anthony said, if she sat on the case, good luck forcing yourself out of that suitcase before she zips it. It is difficult to lift with someone of the same size. And he was emaciated and bent over. Yeah, no, I don't think so either. Brandon the Anime Guy said, Andrew, for 5, says, Andrew, I've been busy with work. How's the judge been? He's been great. How bad is the defense? Fucking horrible. Clown college. Also, get 1 year deeper into midlife this weekend. Oh, well, congratulations. Pre-happy birthday, Brandon. Bald Eagle 1787 says, Daryl Brooks used grounds. It's not effective. Bad News Badger said, Sarah is definitely guilty of ignoring the safe word for 20 Danish krona. Charlie Spurs said, I only like if bribe with boba.
Language in
Hold
the
on,
instruction
Charlie.
in pertinent part says he or
I'll
she
get
was
you
committing
later.
an act. Insert the defendant's criminal activity that the defendant act, but the criminal activity cannot be the charged crimes for which the defendant is claiming self-defense or the defense of others. The charged crime, second-degree murder. So I'm struggling with understanding as the other crime is because I'm not hearing any argument as to the applicability of aggravated assault.
Judge, because, and I didn't make any argument about aggravated assault applying because they can't get over the first hurdle. The first hurdle is it has to be charged. It's not charged. That's what the case law says. I mean, this is pretty clear to me unless I'm looking at it wrong when it says this is not to be given if there isn't an independent forcible felony charge.
Any other response, State?
Nikki P for 5 says the Adeptus Administratum is really shining right now. Hell yeah.
Is manifestly unjust.
Hell yeah. Shout out to the Administratum for the Emperor.
Technicality of no import. There is no interlocking verdict required. If we were able to charge aggravated assault, there's no requirement.
This judge is excellent. I really respect him a lot. Despite being a Seminole,
Go ahead.
I respect
hear
him.
this instruction and find her not guilty of aggravated assault and still convict her of second-degree murder because of
Yes.
all the plethora of.
If not for me, smash the like for the Emperor.
But in Martinez, the underlying charge was attempted murder and aggravated battery, both of which were charged, and we don't have that.
I'll tell you guys a really good FSU joke, a Seminole joke after the break, when it goes to break.
Going to the one act and those facts. We are talking about separate, clearly distinct facts here that support there's an aggravated assault that separately gets committed first, and then in response to the victim responding to that aggravated assault, she leaves him in the chokehold to die because if she lets him out, it's her belief she's going to face death or great bodily harm because she committed a forcible felony against him. This is purely a legal technicality. The entire opinion on Martinez, until the very last paragraph, uses this language.
King Luja gets it. The happy fluids mill produce. Close enough. Close enough. That's what they're guzzling up there in Tallahassee. Except for this guy. He's based. Charlie Spurs said, it's a suitcase from the dark age of technology. Oh, no. We're going to have to send in everybody.
They use language like the underlying facts of the present case demonstrate why it would be illogical to conclude that section 776041 paren 1 applies where there is no independent forcible felony. It doesn't say where there is no independent forcible felony charged. It goes on and uses that same language all throughout the opinion. And then in the very last paragraph in the conclusion, it changes to, in conclusion, we hold that it is error for a trial court to read the forcible felony instruction to the jury where the defendant is not charged with an independent forcible felony. But there is an independent forcible felony.
A legal STC.
There is a statute that says that Ms. Boone should not be able to get the avoid the girth of this jury instruction. She violated, according to the facts that she gave us, she violated 776041 paren 1. She was committing an independent forcible felony and therefore should not.
Why did he have to say girth? Sarah Boone can't take that kind of girth.
This instruction not being given because the technicality that the state can't charge a case or can't charge a count that is not.
Sarah Boone's hentai tag was not hashtag BBC.
Thank you.
Also, I like the Spike Mints. As a Nebraskan, please don't associate Tim Walz with our state. We have cooler things. We aren't making a bowl game, are we? No, listen, I'm not going to celebrate that that turbo cuck with your state. Don't worry. I associate him with being a fucking weirdo who shouldn't be allowed within 500 feet
Footnote
of a
4
daycare,
provides,
a school, or a church.
Explanation in the Martinez opinion is to certain circumstances and whether or not in that hypothetical that the Supreme Court gave, whether the robbery is a separate and independent forcible felony and the forcible felony instruction is applicable. But the conclusion seems to state that it has to be charged, that it is an error for the trial court to read the forcible felony instruction to the jury where the defendant is not charged with the independent forcible felony. Anything else, Mr. J?
No, sir.
Then how do we want to accomplish this? Because I don't know how I can read the proposed language by the state. And there's a disagreement as to whether there's a duty to retreat. It's not undisputed. It is, in fact, disputed.
Well, their complaint is in the sentence, on the other hand, if at the time Sarah Boone used deadly force, she was, and I just think we strike through committing an aggravated assault. Go to, at the time, Sarah Boone used the deadly force. Okay.
Yeah, well, he's trying to figure the solution to this because this is a procedural clusterfuck. This is a procedural clusterfuck. James, how do you know? All right, I'll tell the joke real quick. So, what would they call Gatorade if it was invented at FSU in Tallahassee instead of Gainesville at UF? Do you know, Ava? Do you know the answer? Knock knock. Who's there?
Well, I
3 seconds.
know that Gatorade was made for the Gators. I'm not sure who the other team is, though.
They're the Seminoles. So the joke is, if it was made in Tallahassee for the Seminoles, they call it seminal fluid. Seminal fluid. Yeah. Seminal fluid. Seminal fluid.
Seminal fluid. Oh no!
Yeah. Also, real quick, because Charlie Spurs said he only liked if bribed with Boba. So have some like Ace Attorney lawyer Boba. That's for your likes. I'm a man of the chat. I give the chat what they want. Okay. Give the chat what they want. Also, real quick, Orsa Platts and Anonymous Nobody, for your gifts. Thank you so much. Appreciate it. Yes. Now back to our regular scheduled court case.
I'm defendant used, unless you just want to go to 2. On the other hand, if at the time defendant used deadly force, she was not in a place where she had a right to be, then the defendant had an obligation to, then the defendant had a duty to retreat. Just excise 1 completely. I don't know what else to do.
But she has the right to be there.
Right. Under the Castle Doctrine and the case law.
Okay, then I think we go with the first paragraph and then we just deal with the initial.
Ava's been the one initiating a lot of the dirty jokes. I don't know if you guys have been catching that.
Okay, so then Sarah Boone had no duty to retreat before using deadly force.
Yes.
Okay, is that acceptable to the defense?
Yes.
I think it puts us back in the
I
position.
plead the fifth. He is entirely wrong.
Okay, all right.
Anthony says definitely for 5 says definitely a time when statute of limitation is a downside. Should have been charged with assault. Yeah.
I just object for the record in case some assistant attorney general wants to.
And also, let me just point out, if this was a sexual crime, a lot of states are waiving the statute of limitations on sexual crimes. So if it had been sexual assault, they probably could have added it. But because it's regular aggravated assault, they can't add it, right? This is like, we've gotten into this kind of bizarro world where certain times statute of limitations doesn't apply.
Objection noted. It looks like the next parts of the form instruction, if the defendant was in a dwelling, was excised, the give A, B, or C was excised. Are you on board with that state?
Yes.
Then the next paragraph, a person is not justified in using force to resist an arrest. Clearly, that's not applicable. I don't think that's at odds. However, if an officer used excessive, I also don't believe that's applicable based on the facts. We then proceed to the give in all cases language. Any objection to this language state? Sure. It's the bottom of page 2 of the defendant's 3.6.
Degenerate, Charlie. Degenerate.
I'm just finding where it's
On the form instruction, it's the bottom of page 3 of 7. Given all cases, right after Jackson v. State.
yeah, just the agreed upon strike throughs of or threatened use. So just being deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time.
Any objection?
No objection to that, Judge.
We'll excise the threatened use, so it'll all read use of deadly force in that paragraph. All right. Now we have a proposed instruction, I believe, from the defense regarding battered spouse.
battered spouse proposed instructions since both parties have that?
Sure. Moving now to the presumption of fear, that's been struck out by both parties and agreed to. Moving to the exceptions of presumption of fear, that's been struck out by both parties and not necessary. That takes us to a person who unlawfully by force enters or attempts to enter, that's not applicable. Definition of dwelling is not applicable. Residence and vehicle are not applicable. That takes us now to the aggressor language.
No additional arguments as to why the facts show she was the initial aggressor, and thankfully for the state, there's no requirement under this provision that there be independent forcible violence.
Okay. Looks like we have a disagreement between the parties as to the application of the aggressor instruction. It's struck out on the defense's side and not in the state side. What say you, Mr. Henderson?
Give me 1 second.
Sure.
Please.
Yes, sir.
Tatsumi says, and you could say my pun is bad. I moved to call Judge Legal Mindset to recuse himself. I'm pretty bad. I'm pretty bad with that. Drisbin says she has just been reading them from the chat. It's true. Sigrid Eternia says, I'd pay money to watch Ace Attorney joke trial, Ava versus Andrew in a turnabout of dirty jokes. We can make it happen. I mean, I've got my PNG in a suit already, so I can make that happen.
It had to be members only, and it'd be immediately demonetized.
Well, yeah. Yeah, there's that. I mean, that's the whole point of members only.
Are we on 776.041 sub 2?
Yes, sir.
Objection.
Okay. If I could have one more.
Yes, sir.
You don't want to diss track battle me. I'm actually somewhat decent at rap.
What?
Judge, my argument would be that the only evidence, well, the evidence from Sarah Boone stated that she did not do anything forcefully wise until after Mr. Torres had made verbal threats and was coming out of the suitcase. So that's my objection is based on that. No other legal argument.
Any other argument, state?
Just judge, it's play wrestling and not releasing the chokehold when your buddy taps out.
And I mean, isn't there evidence as to what Ms. Boone had told the experts, which seems to be at odds with that issue? And it's really a factual issue and a determination for the jury to make that determination on what the real facts are.
I can't disagree with that.
Okay. Then with regard to the proposed language as the 776.041 sub 2 instruction. However, the use of deadly force is not justified if you find that Sarah Boone was attempting to committing, or escaping after the commission of aggravated assault. An aggravated assault is defined.
No.
No.
Yes.
Am I on the wrong section? I apologize. I am at the wrong section. Forgive me. So it is the, however.
With my strike throughs is, however, the use of deadly force
is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself unless, one, the threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George, that's spelled incorrectly, Torres, or two, in good faith, Sarah Boone withdrew from physical contact with George Torres as clear and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed threatened use of force.
Yes.
What's your, just for clarification purposes, anything else as to that instruction, defense?
Just one thing I need to put on the record, Judge.
Yes, sir.
The force at that time, as testified to, was the poking of the bat on the outside of the suitcase. There was one strike when the hand was outside. These were bruises. I think there was something that came to the injury to the head area, though. The injury to the head could be serious, but in this instruction, it's talking about deadly force. And none of those, as to the testimony from the medical examiner, none of those injuries caused the death.
But the continued restraint on him that he did not undo is the force that we're talking about. It's just like in the cases that I cited in my special state's request for special jury instruction regarding withdrawing from physical contact. Batteries don't need to be skin to skin. You can commit a battery on somebody while driving your car and striking their car. A false imprisonment does not mean you have to choke somebody. You can falsely imprison somebody by barricading them into a room with a grocery cart. She unlawfully exerted that force and did not withdraw from using that force when her wrestling partner, so to speak, tapped out.
Yes, a bat is deadly force. So whoever's mentioned that in the chat, a bat is 100% deadly
instructions
force.
for
Even a
now.
kid's bat, because it can kill you.
The next paragraph reads, if you find that Sarah Boone, who, because of prior threats or difficulties, all right, that'll be included. The next paragraph, if you find that at the time of
This
the
is all jury
alleged
instruction.
aggravated assault
So-
and or criminal mischief,
Yeah, there just needs to be secondary murder, manslaughter, or culpable negligence, and we don't object. There were specific acts put in evidence.
any objection to changing the beginning of that sentence, defense, if you find that at the time of the alleged murder in the second degree, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act.
Yes.
Okay, thank you.
And we requested the strike through at the end, or threatened to use.
Agreed.
Give me a moment. So that sentence would now, or that section would now read, if you find that at the time of the alleged second degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Acceptable?
Yes, sir. I just don't know that we use Junior after his name anywhere else.
Give me a moment. Yeah, Junior's not used anywhere else, so I'll excise that. Is that acceptable to you, Mr. Henderson?
Yes, sure.
All right, moving to the next line. If you consider that George Torres, removing Junior, had a reputation for being a violent and dangerous person. I don't know, did we hear evidence of reputation?
The state's position is going to be there's no reputation evidence. Ms. Boone offered an opinion, but as everybody knows, reputation evidence has to come from a broad enough aspect of the community, whether it be a church or a neighborhood or perhaps even a large family. But
Defense?
I'm rethinking that, Judge.
No worries, take your time.
I know generally, and reputation evidence, generally, it has to be something that is known based on a community standard, and that was the community. I know the only thing that I can relate to is the fact that individually, she experienced certain things that could build that reputation, but that's on her. I think there's evidence, though, from people, at least that they knew about it or were told about it. Most of that was stopped. But I could go to at least the one situation on a text message that was introduced earlier today that talked about him beating his former wife or ex-wife.
How's that reputation? That sounds like that's a specific instance based on that text message.
I agree.
Okay, so in agreeing, we're going to excise the reputation section, correct? Okay, thank you. The court will excise that.
State agrees to the physical abilities that the man requires.
What about the one that precedes that? If you find that George Torres had a reputation, well, also that reputation would be removed as well, correct, Mr. Henderson? If you find that George Torres Jr. had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor.
That's correct.
Okay, so that'll be excised as well. State has no objection to the physical ability section. I'll just remove the word junior after Torres. Any other questions with regard to the 3.6F instruction?
Your Honor, state doesn't object to what we have produced as the final product. I'm impressed we did it so quickly. We just note our objection for the record to preserve a challenge to Martinez.
Understood. Do the parties, well, let me ask this question. Mr. Henderson, anything else we need to address with regard to the 3.6F instruction?
No, sir, I'd just like to preserve the objections that I made during this conference.
Objections preserved. Do the parties wish the court to reread the 3.6F instruction that we just went through, just to make sure we're all on the same page?
Can we do it at a time where it
is in final form? Yeah, absolutely. Okay.
Perhaps a written copy that we take during snack time.
Sure, absolutely. All right. Where does that take us now? Does that take us to the 3.6G instruction?
I believe so.
Okay, give me a moment. I have the state's proposed 3G instruction. I have the form instruction from the Supreme Court. And I have the defense's proposed revisions. Just move everything around here. Give me a second. Okay.
We're at 553 likes. Come on, guys. 1,000. And we're getting Ava doing a big iron cover. Owens is putting on his clown makeup for the fucking, he's literally applying the clown makeup for the closing.
All right. As to the title, I believe that based on what we've discussed, the or threatened use should be removed. Is that correct?
That's correct.
All right. As to the first sentence, it is a defense to the crimes of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of threatened or, I'm sorry, threatened use is
in
removing
South Korea, wrote a
justifiable use
lawyer
of
one fine
non-deadly
day.
force. Would be removing threatening, and we would
that's
also
so
be
good.
including manslaughter, correct?
That's correct.
State?
Yes, sir. It is a defense to the crime of second-degree murder, manslaughter, in Oxford, or culpable negligence if the actions of Sarah Boone constitute the justifiable use of non-deadly force.
I too am a big fan of the Oxford comma. So the defense would, or the instruction would now read, it is a defense to the crimes of second-degree murder, comma, manslaughter, comma, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Acceptable state.
Yes, sir.
Acceptable defense.
Yes, sure.
Definition of non-deadly force is not at issue. Next paragraph. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. Acceptable state.
Yes, sir.
Defense.
Yeah, sure.
The law on justifiable use of non-deadly force is as follows. Sarah Boone was justified in using non-deadly force against George Torres, excising Jr., and
Yeah,
had
the
no
jury
duty to retreat if
instructions
she
are what, 34 to 36
reasonably
pages long, I
believed
believe?
that such conduct was necessary to defend herself against A, George Torres, excising Jr., imminent use of unlawful force. Is
Come on,
that
chat.
instruction acceptable?
Big iron cover. Smash a like. Thank you, Ursula. Ursula.
If we're not using the B, I would just suggest you make one sentence.
Any objection?
No objection.
Any other issues with the instruction as read so far? State.
No, sir. Thank you.
Defense.
None, Your Honor.
Okay. Looks like there are several agreements.
Here we go.
with
We're
the
about to get
balance of this
600. Come on.
instruction As to
60% complete.
defense of property is not applicable.
go.
The 776.0134 dwelling and residence and vehicle and force with regard to law enforcement, all of which is not applicable in the instant case. That takes us to the give in all cases. We would be removing the threatened use of non-deadly force in that section. Any other changes is to the give in all cases section.
Nothing to say. Thank you.
Defense.
None, Judge. No objection.
Let's table the proposed instruction on the battered spouse for the moment.
Then the state will be making its request for the forcible felony instruction.
Under Martinez.
Yes, and we understand the court's ruling, and we're sending a strongly worded disagreement to the court's report.
Received and understood, but based on what the court said earlier as to the conclusion in the Martinez section, I'm disinclined to add your proposed instruction.
I understand why.
That takes us now to the 776.0412 section. Looks like we have a little bit of a disagreement here. Is it the same arguments that we received in the 3.6F instruction?
It's the same fact.
Any other additional arguments, sir?
No, Your Honor.
All right, for the reasons previously identified, the court will accept the state's proposed portion as to the 776.0412 instruction.
Tatsubi says, imagine a lawyer comes
Then it
back for
takes us
closing
to the
arguments
prior
and starts
threats.
with, I was raised in a middle-class family.
That's in 3.6F from the state, sir.
Oh, man.
For the end of the instruction.
I agree that it should track with the.
Forgive me. Other than reputation, what were the other issues?
Prior threats should come in.
Mhm.
Specific acts should come in.
Okay, thank you. Reputation should be excised.
The two paragraphs of reputation excised, and then physical abilities gets read in all cases.
Agreed?
Correct.
Okay,
Agree.
all right. And then we'll remove the threaten language in there, correct?
Yes, that's correct.
Your Honor, I'm
Okay.
a humble Yale.
Any
student.
other
Yeah.
questions with regard to the 3.6G instruction state?
Smash a like for the
Defense.
lolly nudes.
Okay.
And by
I
that,
believe
we mean
that-
unfiltered court records.
Double check on
Yeah.
those.
You know this judge gets off on the Oxford comma.
Are
I
they
believe that
are they
addresses
unredacted?
those issues based on what we did not discuss this morning in the charging conference. And I think that now takes us to the state's requests and the defense's request for special instructions.
Can we do the battered spouse one first, since they're conflicting requests?
Yes. Specifically, we're making reference to the state's request for special jury instruction regarding battered spouse syndrome filed. I believe it's not dated, but I think it was either the 23rd or the 24th that you filed these, Mr. J, and the court record will speak for itself as to when they were filed. Okay. Courts reviewed that motion and reviewed the proposed instruction by the defense.
I
State, let me
respect
hear
her
from you first.
authority.
With their instruction, I think the problem with it is that it kind of blurs the subjectivity component versus the objective reasonable person standard. So if we make this change to their instruction.
Look,
then
unredacted court records can get pretty lewd.
what I would suggest.
You guys got to understand.
Very lewd. Very.
If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by the victim, no junior. I don't know if it's necessary with the date. That makes it clear, because that's what the case law says. The case law makes it very clear it's about the objective component.
I agree with you.
And then I would just ask for my last sentence, which is like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse.
What say the defense? And if necessary, I can read.
Yes, could you do that?
So it looks like there's no, first of all, just so the record's very clear.
Oh
Stevens
yeah,
v.
we
State
could do
identifies the special
1.27 if you
instruction
want. If this is going
circumstances.
all slow.
Special instruction is supported by the evidence.
Let's
in this
do,
case.
yeah,
Yes,
good point.
absolutely. The standard instruction did not adequately cover the legal theory it is meant to. There is no standard instruction on battered spouse over and above what's included in the self-defense
1.5.
instruction. The special instruction was a correct statement of law and not misleading or confusing. We're addressing that third prong of Stevens at this time. The proposed instruction would read, you have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. It would then go on to read, like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered
This
spouse
actually is pretty good.
Okay. Appreciate y'all working together on that. Give me a moment to finalize this.
I can actually understand this.
As such, the third prong of Stevens has been made, and the court will give the special instruction as identified on the record. Now, the only question
I'll go down to
also have
1.25.
is, do we want this as its own instruction, or do we want this included where it currently is in the 3.6F and 3.6G instruction state?
I would suggest it be 3.65, right after the Boone instruction about use of force.
I agree with that.
Okay. Do we want to label it or just have it as special instruction and then read it? Do we want to have the title special instruction on battered spouse? I welcome.
I'm fine with.
Because remember, guys, we're still behind. We're not
Okay, so
caught
it'll
up
be
yet.
special instruction on battered spouse syndrome. Is that acceptable?
Yes, sir.
Is that acceptable?
I would like to.
Thank
I would
you.
like to catch up before closing starts.
And that will follow after the 3.6G instruction, correct?
Yes, sir.
Acceptable, Mr. Henderson?
Yes, sir.
All right, that takes care of that. Move-
All that you left. Oh, go
Yes,
ahead.
I'm sorry, sir.
I'm sorry. I think we might be required to read it both times after each one.
Yeah, professional gentleman just joined as a mod. We're going through
This applies to both
jury instructions, brother.
deadly force and non-deadly force.
That's fixed.
Okay. Where, gentlemen, do you want that?
After the big paragraph that ends with George Torres and before like any other witness.
Sure. Okay, so let's go over that language one more time so that we're all on the same page. Mr. J, what is it that you propose?
To put between the paragraph that ends with Jorge Torres and before the paragraph of like other witnesses, whatever I said, you can consider this testimony and evidence in the applicability or the use of whatever word people agree on, of both deadly force, non-deadly force instructions, something to that effect. If that's too convoluted, I'm fine if it just needs repeated.
I tell you what, I'd rather just repeat it.
I think so.
That gets way complicated. I'd rather just repeat it under
Oh,
3.6F
is that what it
and
is, legal
3.6G.
mindset? Is that Thai
Is that what worked for you,
menthol
Mr. Anderson?
sniffing
Fine,
habits?
thank you, sir.
It's not menthol. Well, it's got several herbs and spices. They really it really opens
Okay.
up your airways.
Moving now to the state's request for special instruction regarding withdrawing from physical contact, filed October
No,
23,
it's not in English.
2024.
I'm not gonna.
Court has
read this
reviewed it.
well.
I guess the first question is, what say? Is there proposed
Herbal and
language?
They're right. They're
Trying to
quite
see if
good.
I'd actually put that in.
It's
there.
just a bunch of herbs on the
I
inside.
don't know that I see it, Mr. J.
Oh, paragraph 15. Physical contact includes any restraint on George Torres, apostrophe, movement.
Yep. Yep. I'm gone full rackets. That's
This
it.
would
It's
be
over.
after the initial aggressor portion in the 3.6F and 3.6G, correct?
Nose
What say
looking
you?
good. You guys know what the penalty for that is in Korea? They throw you in like
Yes,
severe
of course.
jail. It's not like Rackets jail where he gets out after a day. Like in Korea, they really jail you for that. Never go full Rackets.
They deport you to North Korea if you get found with that in South Korea.
Yeah, the booger sugar, you don't play with booger sugar in East Asia. China, Korea, Japan, don't fuck around. No booger sugar. Drugs are super serious. And you know, here weed is illegal in Korea, Japan, China, so yeah. Unlike marijuana and mushrooms are legal in Thailand, they're not legal in Korea. Yeah, deport to
I'm
North
currently
Korea.
enjoying the only good thing about California as we speak.
There we go. Ava's proving that elves really do like it greener.
You know what's funny? On my other model's outfit, I actually have a joint smoking emote. It's pretty funny.
Can you not that you can't have that on your does that demonetize you on YouTube? Probably does.
It probably would, which is why I don't use it on YouTube.
The Gandalf like pipe might be able to get away with that. It's a VTuber, so yeah. Yeah, all the platforms hate VTubers.
Yeah, if I just say it's what is it in
Therefore, at the conclusion of the two paragraphs regarding initial aggressor, it should come
Lord of the Rings? What is the pipeweed? I think it's called.
Pipe weed or something like that, or yeah.
Yeah, in the 3.6F instruction, references to initial aggressor have been removed.
Yes. So now is the state asking for it to come in as the initially provoked.
Unless I missed something.
My understanding was that the two paragraphs about aggressor are coming in. What's not coming in is the Martinez forcible felony.
There's a big argument on Reddit whether pipe weed is cannabis
the
or
language
tobacco.
you said at the
Apparently
conclusion of the
people
paragraph
believe it's
regarding
cannabis.
initial aggressor. The words initial aggressor don't appear in the 3.6F. It's only after that. However, the use of deadly force is not justified if you find Sarah
It is
Boone
cannabis.
used force to initially
It is
provoke the
objectively
threatened use of
cannabis.
force
Think
against
about the
yourself
time that
unless,
Tolkien wrote
and then
the
it's
book.
paragraphs 1 and 2. Is that where you're asking it to
Yeah,
be?
yeah.
Sure.
So in 3.6F,
Mhm.
it should be, however, the use of deadly force is
It
not
can
justified
be what
if
you
finds
want it to
Sarah
be.
Boone used force to initially provoke
It's your story.
the
That's what I
threatened
have.
use of force against herself unless
Did Tolkien say it was
after two,
tobacco?
as an explanation for
Okay.
what is listed in Pren 2 as from physical
I mean,
contact, just that elaboration.
you can lace it, right?
What we're talking about.
I got it.
Because the unique circumstances of this case, the remote force.
Okay, I got it. I just want to make sure we're all on the same page as to where. What say you as to the proposed language of physical contact includes any restraint on George Torres's movement as that portion of 3.6F and,
Yes.
and 3.6G.
Some Asian countries can
Okay,
death
all right,
penalty
so,
you for just owning
court's
for
gonna
drugs.
Grant the state's request for special instruction
That's
regarding
very
withdrawing from
accurate.
physical contact. And the language of physical contact includes any restraint on George Torres's movement will be included after the, however, the use of deadly force language after paragraph 2 in the 3.6F instruction, and in the 3.6G instruction, it will be at the end after the physical abilities section. Also, it's George is spelled incorrectly. That will be remedied.
I thought the two paragraphs about aggressor were being mirrored in 3.6G. It shouldn't go after physical abilities. It should go after.
Oh, I'm sorry. You're correct. I apologize.
No problem.
Okay, got it. That takes us now to the state's request for special jury instructions on causation, filed October 23, 2024. I have reviewed it and the proposed instruction on paragraph 3 therein.
Judge, the reason we're bringing this up is just during the cross-examination of Dr. Z, or Zadovich, you know, we poked the bear a little bit about his cardiovascular condition. My memory of the testimony was that she's emphatic that that was not the cause of his death. But because of that, and because of now the request of culpable negligence at misdemeanor for a lesser, I feel it might be warranted to give this explanation of causation in the second-degree murder and manslaughter instructions.
Defense, what say you?
Judge, I would object. I believe that just the instruction, the proposed instruction that I have.
This is true, Coding Light. A lot of people can't get their ADHD drugs. It is true. In Japan specifically.
That was caused.
Other countries, it's fine, but that's just Japan.
That's what they're required to prove. This language, to me, would lessen that requirement by saying, but for the defendant's criminal acts. Then the second part, when it goes up to George Torres' death, was not beyond the scope of any fair assessment of the danger created by the defendant's criminal act. I think that's covered, Judge, in the fact that the state does not have to prove that Ms. Boone had the intent to kill George Torres. So that makes it confusing to me when the standard instruction basically simplifies it in my mind, and it keeps them right where they're supposed to be with that instruction. They don't have to prove that she had the intent. Then as to the third part.
I'll withdraw my request for that.
Okay.
If heart disease gets brought up in closing.
All right, fine. So withdrawn. Court takes no action on the state's request for special jury instruction on causation. That leaves us now with the state's request for forcible felony instruction and request for initial aggressor instruction. That's already been addressed, has it not?
I was just reading this as special jury instruction for my argument.
Understood. All right, are there any other instructions sought by the state at this time?
I believe we've concluded the section.
Defense. All right, here's what I'm going to do. I'm going to take all this upstairs. I'm going to re-review it. I'm going to merge it all into one document, and I will send it to all the parties. Let's plan on being back here at 1:30, and we'll address any other concerns of the jury instructions at that point in time. State, anything else we need to address?
125.
Let's make it 1:20.
All right, thank you.
Defense.
Nothing else.
All right, we'll see you all at 1:20. Thank you.
Cool. Back to normal speed. And I think we're about to catch up. Let me just go here. I think if we go live, we're still not. So we're there waiting for closing them to come back, and then we'll have closing arguments. So awesome. We did it, boys. We caught up. Which is great. I've got some stuff for us to watch in the interim, but first, I like the Spike Man with 5
Those
legal.
text messages were damning.
Yes, very damning, very damning. But thank you very much for that.
Yes.
Appreciate you, Spike Man. But yes, let me get these and we'll talk about it. Utsukiya says, just like Ava's Tom with all the queens he invites to the boat while she's away. Wait, what? Okay. Will H says, well, Andrew is retarded. That's why we love him. Hey, listen, I can't help it. Just
All right, explain this to me like I'm retarded.
That won't be that hard.
it is what it is. JP Ravenfire dropping 5 Legal Mindset memberships, and Doug Diaz coming through for 1. But more than that, I want to say a special thank you to both these fine gentlemen because they both gave very, very based donations, Doug and JP. Thank you for those gift memberships, and please say thank you in the chat. But I want to say they gave very, very, very good donations over here on my Ko-Fi. We're 45% of the way there. We're almost there to the goal, so I can get that capture cam and start moving towards being a VTuber, right? So that's the next one. Obviously, you guys helped out. The first thing I bought was this. I took what you guys have given me so far, and I got the webcam, which you can see when it decides to wake up. The tracking on it is pretty awesome. It's able to follow me around the room. Really good stuff. Really good for traveling. Much better than my Logitech Brio. As you can see, I'll show you my Brio. It was kind of old and busted. It's my Brio. It's seen some shit. This Brio has seen some shit, right? So it was about the time to put that one around back and old yeller it. So thank you, everybody who's donated over there. I really want to appreciate that. And special thank you to JP and Doug because I want to give them some love. All right. So I caught up. I got all that good stuff. Also, I was laughing my ass off at these Twitter posts. I have to share them. And this is about Ava. So Misato Katsuragi Red Pill posted new channel icon for Ava, that one. But then down here, we got Ava right now. Ava right now, currently. Just the base the base IL. Very nice. Very nice. Eric H gifted 20.
I did a joint smoking emote, but I don't want to get Andrew demonetized.
I mean, we're over 2 hours. YouTube probably won't see it. You could chance it. It'd probably be all right. I'll allow it. Judge Andrew will allow it. There you go. There you go. There you go. There you go. Clip it, guys. Thank you so much, Eric H. Appreciate you. Thank you. Really appreciate the support. Let's see. I want to do another reaction here. Which one haven't I done in a while? Oh, yeah. Let me do this.
Oh, yeah. That's what I like to see. Oh, yeah.
Since we're missing the paralegals feet today, we didn't get a lot of paralegal feet. So I got to give the feet people something or they get too rabid. But thank you so much, Eric H. Thanks, everybody, for supporting the channel. I really do appreciate it. All right. So, I got
if they don't get enough feet, they go after grandmas.
It's either feet or the gram mussy, and I'd rather give them the feet stuff. I'd rather feed them the feet stuff than get the grand mussy. Repton94 for $1 says, since we're speaking of greener, roses are red, this grass is greener. When I think about you, I play with my wiener. I won't say who. Don't stop gooning to me, Repton. I'm really offended by it. I'm offended by your aggressive gooning. This camera actually has a gooning setting, which they call desk view. But the desk view, if I hit the desk view, it literally focuses on your crotch. So yeah, it has that. Very interesting. Very interesting. All right. So we're caught up. We're waiting for them. So what I'm going to do is I'm going to play. I've got 2 videos here, one of which is the family. So before we start talking more about the text messages, this is George Torres's family. So let's hear from them. They were, the media went and talked to them.
Very special voices for the victim in the suitcase murder trial for George Torres. Prosecutors say that he was murdered by his longtime girlfriend, Sarah Boone, who had him trapped inside of a suitcase, beat him, and left him to die. The defense is saying that Sarah Boone was acting in self-defense. Now, George Torres' family is speaking out this morning, saying that he's being unfairly depicted as an abuser and that it was Sarah Boone who was the real aggressor. Now, since early in this case, we've seen evidence of Boone's problems with Torres' family.
To know what we're here, what we're investigating, and that they're going to think I killed him.
Why would they think that?
They always have said that. They've always have said that.
What have they
I told you it's because I'm the blue-eyed white dragon. That's what they call me. Because they don't want him with me. So he's basically...
Hold on. Did she make a fucking Yu-Gi-Oh reference? Did she say blue eyes, white dragon?
She's the blue-eyed white dragon. Yes, yes. She just says she's the blue-eyed white dragon. Holy shit.
I mean, this is Sarah Boone. Is Sarah Boone making the reference? Because I mean, like, that's very niche. For those who don't remember, real quick, we'll throw it
Sarah
out
Boone's
here.
apparently Seto Kaiba.
Yeah, we've got 3,000 attack, 2,500 defense. The legendary dragon is a powerful engine of destruction, virtually invincible. Very
That's
few
Sarah
have faced
Boone,
this awesome
right there.
creature and lived to. You know what? That's
Sarah
actually true. Very few have faced her and lived to tell that. Put some pink shorts on this bad boy. Somebody out there, edit this, and you've got Sarah Boone. Just put her face up there and put some pink shorts on it. It's on the mark.
Put pink shorts on it. Put freaking pink shorts on it.
All right, let's finish that video. Where was it? There it is.
Basically just not really been around his family because he chooses me over them.
I want to welcome in our special guests now. We have George Torres's oldest daughter, Ana Victoria Torres, with us. We also have Dolores Ortiz with us, who is George Torres's first wife, and she also brought with her this morning her youngest daughter, Destiny. First of all, my heart goes out to all of you, and for all of us here at Court TV, we are so sorry for your loss. Thank you for coming on the show. And I know that you really want to clear the air. And Ana Victoria, I know you've wanted to kind of be the family spokesperson. So I want to start with you, please. The way that your dad has been depicted as being an abuser in this trial, I know that it has upset you and you felt it's very unfair. Tell us why.
Story, and unfortunately we are the voices now, and the way the trial has gone and the way things have taken place have nobody has ever contacted us to hear our story or ask us questions in regards to our father, his character, or the relationship between him and Sarah Boone. Me and my siblings actually spoke to our father that night, and we have a lot of experiences with Ms. Boone that do not speak to what the media is stating she is, a victim or a gentle individual. I'm sure she's loved over there at jail due to the fact that Sarah Boone is very, very calculated. She by no means is a kind and sweet, soft-spoken woman. She is very calculated, very devious, very conniving. My father was sheltered and berated. He was kept from us. He was the real victim in this situation. Unfortunately, again, as stated, he is not here to tell his story, but we are here to give his side the best we can from the view that we were able to see things.
Sure. Ana Victoria, in one of the videos that we've all seen, Sarah Boone told police that George's family didn't like her and that they referred to her as the blue-eyed white dragon. Would you talk about where that nickname came from?
Please, if someone says Yu-Gi-Oh, I'm gonna fucking lose it. If someone says Yu-Gi-Oh.
And if it's true that you all didn't like her, and in particular, why?
This is amazing. This is amazing. I love with Boomer.
I can definitely answer that. As far as the nickname is concerned, that was created all through Sarah's little brain. Other than that, she was definitely correct as far as us not liking her. And she should have stated that she didn't like us either, because that is very much correct as well. She, like I stated, is very evil. And what she is acting out there on the stand and within that courtroom is baffling to me, because that is not the real Sarah Boone at all. But yeah, she was correct. We don't like her. We didn't like her. That will never change. Unfortunately, I do feel bad for her and I wish her the best. But what I do wish is that my father receives his justice and she gets the time that she deserves. And a slap on the wrist is not it. Other than that, as far as a relationship with Sarah, one that was a good one, there wasn't one. We tried, we definitely tried, but she did not.
And Victoria, thank you for sharing all of that. I want to go to your mom now. Dolores, you were married to George for 14 years. I have three beautiful children with him. Two of them are here with us today, Destiny and Anna Victoria. We understand that at one point, Sarah Boone tried to fight you. Tell us about that.
Not per se fight me, because we've only, I want to say that we've had one engagement, which was for my children's birthday party that they attended later in the evening. So I really have never had like a confrontation. It was made verbal over the phone. She had threatened me a couple times to come over and that she would dust her doormat for myself and my daughters. But it was basically verbal threats that she would give every time that George would call his children, any chance that he had, that he was able to call his children to speak, and I was present. It was a problem for George. She was very much jealous of me for what reason I'm not aware of, but we never had physical, altercations.
Well, and that's a very good thing. Tell us, Dolores, during your marriage to George, was he ever violent with you or any of your kids?
He was never violent with my children. We would have normal husband and wife family spats here and there, but never to the point where police were ever involved, DHS was ever involved. We were never that type.
And this is very and from my experience, and Ava, please tell me, but like when you deal with somebody who's violent, like that's pretty much consistent through their relationships, usually all of their relationships, right? Not like, oh, it's only with me. If you looked at Amber Heard when you saw Johnny Depp and they called, was it Kate Moss?
Every relationship in almost every capacity. I mean, serial divorcers will very often be have that same pattern. You'll have like it's kind of like the Johnny Depp case where it's like this is a Me Too without another person saying Me Too. Same here. Their past relationships don't reflect the abuser that Sarah is trying to make George out to be.
Right. And in fact, now you're hearing from them that they got in a physical altercation with Sarah, right? Which speaks volumes.
Type of family. I can't relate to Sarah and the abuse that she so-called claims that she's received from George, because I never received abuse like that. I want to say the only thing that I can say about George is that he was a ladies' man.
Gotcha. Okay.
So okay, he's a ladies' man, right? And that's a relationship problem for sure, right? That's definitely a relationship problem. But just because you are a playboy doesn't mean you're an abuser, right? Trying to string those things together is, that's different.
And so just to be very clear here, did anything physical ever take place in terms of physical violence that he inflicted on you?
No.
And thank you for that. I know these are very personal questions, but we really want to get everything out here and get your side of all this, as everyone in the courtroom isn't hearing it. Destiny, we're so happy to have you here. You were a surprise this morning. We knew Anna Victoria was coming on and your mom, and we're so glad to see you too. What would you like to say about your dad, the kind of person that he was? What would you like the world to know about him?
I had no idea he had a daughter.
My dad was an amazing person. He was my best friend. Nobody's perfect.
He had two
but
kids, so 2 daughters.
My dad was very loving. Everybody loved him back. He didn't deserve what happened to him. I don't think anybody deserves to die like that. I was 15 when it happened. I ended up being very depressed and going through suicidal thoughts and things of that nature. Yeah, we're just really trying to get my dad justice.
We know you are. We know you are. And Anna Victoria, back to you really quickly. You said that no one has reached out to you. Has the prosecutor's office reached out to your family?
As far as my father's mother, his father, his siblings are concerned, they have been communicated with due to the fact that they do live in Orlando. I live in Philadelphia, but nonetheless, I have communicated with the attorneys. The only thing I would say is I've never been contacted in regards to who my father was. I'm not sure if Sarah Boone deleted the calls or anything like that, but I'm sure those things were able to be, brought back up. But my siblings and I spoke to our father that night, and I do think that our encounter and what took place over the phone is very valuable to the case, as well as what their relationship was like and what Ms. Boone's plans may have been that night. Again, whether they have been premeditated or not, in my opinion, they very much were, due to the character of Sarah and all the experiences that we've had with her. But
what did your dad say on the phone?
If we were
Anna
contacted,
Victoria?
things could have been much better. So nothing in specific, but we talked on the phone for months at a time, every so often. I would say that I spoke to my father at least 3 times a week, maybe more. And we would stay on the phone as long as he possibly could stay on the phone with me, without Sarah getting agitated or whatever the case may be. I can't really put into words the way she would act.
Yeah, you all got to know a different Sarah Boone.
Just talk all
That's
the
for
time,
sure.
and my father that day seemed very uneasy.
Yeah. Well, again, we are so sorry for your loss, and would love to continue the conversation with you as we're getting close to the jury getting the case.
So there we go. There we have their perspective. Sigrun said, "Don't discourage my girl, booed like that, man." And then Sigrun says, "Ladies man at 5 foot tall and 100 pounds plus X." And I want to follow up because, okay, I know that you think that. Autoclock says you can be a ladies man no matter your shape or size, how successful you are. Yeah, and look, I've got a friend who is he's mixed background, part Bangladeshi, right? So for all the black pillars out there, like, oh, you're 5 foot, you're lost. Nope, he cleans up. 5 foot tall, but he's really confident. He's in good shape, right? The height doesn't do anything. Now, I think George was cleaning up with like 2s and 3s, but that's my personal opinion on that. We'll leave that. We'll leave that out there. If Sarah was his average like target audience,
Look, women love a man who can fit in a suitcase.
We're gonna go back to the court footage now. Thank you, Ava. All right. So let's see. Did they speak about anything here? Hold on.
We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone.
Owens has his clown
Any
makeup
appearances
back
for
on.
the state, please.
Dave Cashcore on behalf of the state. Will J. for the state.
Defense.
James Owens for Ms. Boone.
Tony Henderson for Sarah Boone. Coming back over there.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. I apologize for my lateness. I realized that there were some typos after I'd sent this to print and needed to take them all apart to fix it. So thank you for your patience as we work through that. State.
We noticed that in the non-deadly force,
Page 12.
there was a couple strike-throughs with the use.
I saw.
However, there was also a mistake with leaving a paragraph about reputation in at the very end of 3.6G, and that should have been a mirror of the relative physical capabilities of the parties.
I do see that.
Other than that, I saw the he, she bracketed still.
I fixed that on page 16.
Then it's just that one, I think that Mr. Henderson and I noticed.
Okay. All right. I can have Madam Clerk start fixing them here.
Yeah, I think we should proceed and get going if we can.
But they will have nothing in their hands.
All right. Well,
That's the issue.
all right. Let's face that one. Dude.
Sorry. All right. Thank you. Just give us a minute to fix all this.
Get on it, Madam Clerk. Get on it. Yeah. All right. So let's see. Let's fast forward this real quick. Ba, 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 ba.
As to that 2 line referring to,
Yes, so that should be physical capability.
pull back up to 3. So that paragraph should be.
Are we caught up here? Okay. Let's go live. Let's see. Okay, we're live and they're still dicking around. Okay. So we're fully caught up. And they're still dicking. All right. So I will mute this until they start getting going here. But Ava, the text messages. Do you think that was the straw that broke their back, or do you think that was like just additional evidence that's going to bury Sarah? Like, how do you feel the jury took that evidence? Where would
I
we
think the jury forgot all about how bad of a job the state did on their first cross, the Versera Boones. And I now understand why they didn't waste much time on cross against Boone, because they had all of that and they had their best hammer for last. And for me, it's hit it home.
Yeah, I agree. I absolutely agree. The way you structure everything, honestly, people pay attention to what you say in the beginning and they pay attention to what you say at the end. So the beginning and the end are always what's most important. And allowing that evidence to speak for itself, not having to qualify it, it was already entered into evidence. So all they had to do was read it. And they're going to be able to go through those text messages on a laptop by themselves. That's going to be massive. It's going to be huge. And then they're going to look at that. They're going to line it up with, the Snapchat video and say, this woman is just a fucking mean, vindictive, controlling person. And at no point does it look like George was ever an angry person or making death threats, etc. Yes, there were injuries, but also, how were those injuries caused? Were any of them self-inflicted? Were they George defending himself against her attacks, right? Or defending himself when she shoves the camera in his face, right? Very, very interesting. Yeah, Owens the clown is back. Yes. He's back from clown college. He's done juggling.
I mean, if I'm the jury, basically I'm thinking of everything I saw yesterday, including all that circular arrest, protective order violation weirdness that was going on. It will happen like 5 or 6 times in a row. And then the text messages from today. Anything that the defense might have managed to claw towards themselves, they lost with the last 2 days.
Yeah, for sure. Looks like we'll have a little update on our favorite crack I mean, cocaine loving lawyer. There's a little bit of a legal update, so we'll do that over the break once we get past the.
We got some rickety.
We got some rickety
rickety-crickety.
crackets. We got some crackets updates, some crackcata updates. Oh man, oh man, oh man. Good stuff. Good stuff. Talk asked, do you think we'll get a verdict today or we have to wait for money today? That's why they're
Can
making them
somebody
stay.
please Photoshop Rickety Cricket and like have Nick's face on Rickety Cricket during one of his crazy stuff from Sunny in Philadelphia?
Someone wants me to unmute this. Okay, I'll unmute it. It's muted for us. See, it's on. So we're unmuted, but see that's the stream. See, it's unmuted, but they're muted on their side. Cool. Okay, so that's there. Altir gifted 1 legal mindset membership. Thank you. I don't want to do something else and then they go over, but I feel like they're pretty close here with the jury instructions. Because once they get these jury instructions done, it's literally print them out, hand them to the jury, so the jury is holding them, right? And then they go through the closings. So pretty good stuff. Also, my Ko-Fi bot's actually working. We're at 49% of the goal. God bless the goal. And thank you, JP Ravenfire, for donating. I really, really, really appreciate that. Thank you. Almost halfway there, guys. Almost halfway there. But appreciate all that support from you guys. Thank you. Sarah just turned 47. Damn. Mark says, yo, Hannah.
Latrina VR says, are you surprised the FIST didn't officer rebuttal? And I say no, because the only way they could really challenge what was offered in State's rebuttal is putting Sarah back up, and I don't want to put her back up.
Mm-hmm. Exactly. The only way to challenge that is to bring Sarah. Yes, and that would be a fucking nightmare. I mean, try to bring Sarah up. Mark says, yo, Hannah, can we present evidentiary that Boone is a woman so the jury knows what level of evil she can be? Oh, man. That's if it was Darrell Brooks' trial. Like, merge Sarah Boone and Darrell Brooks as trials, and that'd be insane. That'd be insane. All right. Let's see. I'm going to keep this video up.
Your Honor, can we present evidence that Boone is a woman so the jury knows what level evil she be?
Yeah. Let's see here. Okay, I want to show this, but I think we got to wait. Okay. Gonna wait here. Let's. Are they leaving? Wait, hold on. Are they stepping out? Also, Fox Kilsa with 50 legal mindset memberships. Holy
Yes. Long
The girl is me right now. The girl is me. Thank you so much for that. For the base gifts, please say thank you to Fox Kilsa. Thank you. And he's dropping the welcome here in the chat. Thank you for the support of the channel. Much appreciated. I'll play this one too.
State, are you ready to proceed? Defense, are you ready to proceed?
All right, here we go. We're going to get some closing arguments. Strap in, guys. And once again, thank you. Strap in. We are going into closing arguments.
We're ready, Judge.
Let's go ahead and bring in our jury. Huh? Yeah, that would be fabulous.
I love how that's like ASMR, judicial ASMR. Will you cover the cover release soon? Yeah, I'm gonna cover the if we have time, I may even do it on the stream. The letter from the Japan Fair Trade Commission to Cover Corporation. I may do that. Depends how long we have to wait. If we look during the waiting for the jury period, I'd rather just cover other news and do other news updates because I have time, and then I'll clip those out and make them separate videos. But we have time to just talk about stuff. So I might as well do a news show. You know, if I can do a news show, I'd rather just put it in here, especially if we're going to wait for over an hour. I have time to present news. So I might as well cover news, you know. Is this the last and final trial of Sarah Boone? She only gets one. I mean, she can appeal it, but
State to recognize our jury.
Appeals are an uphill battle.
To recognize our jury.
Yes.
Everyone can be seated. Thank you. Members of the jury, thank you for your patience. We had a long conversation about the jury instructions, and I missed a typo or two after I had printed everything, and took us a while to print everything out. I'm going to ask the courtroom deputy to come forward and pass these out to you. If you can, please raise your hands to confirm that you complied with the court's instructions during the break. All right, record reflect all hands have been raised. Members of the jury, we are at the conclusion of the evidence and testimony in this case. The court is now going to instruct you on the law. Courtroom deputy is providing you copies of the jury instructions. Like I said at the beginning, you're going to be able to take these back with you into the deliberation room. There's not going to be a quiz or a test at the end. You don't need to memorize anything. If you'd like to read along, you can. If you just want to listen, you can. It's completely up to you. Court's going to read most of the instructions and then turn it over to the lawyers for their closing arguments. The state will go first as they have the burden. Then the defense will go. And then the state will have the opportunity to rebut. Then I will conclude the instructions and release you for your deliberations. After the state's closing, we're going to take our afternoon recess. At that point in time, I'll have the courtroom deputy provide you that emergency number. So if you need to reach out into your family or loved ones to let them know that you are on the jury and are deliberating, you can do that at that time. With that, members of the jury, the court's going to go ahead and begin reading you the jury instructions. Instruction 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. 3.2, Statement of the Charge. Sarah Boone, the defendant in this case, has been accused of the crime of second-degree murder. 7.1, Introduction to Homicide. Sarah Boone is accused of second-degree murder. Murder in the second degree includes the lesser crime of manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find George Torres was killed by Sarah Boone, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual, ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. I now instruct you on the circumstances that must be proved before Sarah Boone may be found guilty of second-degree murder or any lesser included crime. 7.4, murder, second degree. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, George Torres is dead. 2, the death was caused by the criminal act of Sarah Boone. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. 3.4, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is charged, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of second-degree murder is manslaughter, culpable negligence. 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, George Torres is dead. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Yes? I apologize. Or, thank you for that clarification. Sarah Boone I'll reread those for you. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. Or B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Capable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. 8.9, culpable negligence. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Sarah Boone exposed George Torres Jr. to a personal injury. 2, she did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence.
She's so fucked at least on that.
Failure to use
At
ordinary
least on
care
that.
for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such indifference to the rights of others as is equivalent to an intentional violation of such rights. 3.6D, as in Delta, voluntary intoxication. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime.
Boom.
A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication.
She was definitely
Voluntary
knowingly
intoxication
drinking.
is not a defense to second
Can't
degree
blame it on
murder,
the
manslaughter,
alcohol.
culpable negligence.
That's it.
3.6F, as in Foxtrot. Justifiable use
Foxtrot.
of
All
deadly
right.
force.
How
It is
about
a defense to the
F as in
crimes of
Fox
second-degree
Girl?
murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use, deadly force, is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat before using deadly force. In deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself, unless 1. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. Please silence your cell phones.
Bro, turn your shitty ringtone off.
And had it exhausted every...
Bro.
Out. Whoever phone is on, get out right now.
Daddy is angry.
Members of the jury, I apologize. I'm going to read that over for you for the beginning. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm, and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed the threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
Judge, I'm missing page 10 and 11.
I am too.
Okay. We will remedy that. Thank you, sir. Is it just your copy, Mr. Owens?
Anybody else missing 10 and 11?
Mr. Owens, approach, sir. Yes, sir. Thank you. We'll bring it to you, sir.
Just me says my money on is a very quick return to the jury, not judging.
We'll wait till
Just saying. No, I agree.
Thank you.
I think once they've been read it, they can be like, we all know what's going on here. Like, let's just get out of here, right? I mean, they're all raising their hands immediately when they come in. They know that they know the fucking assignment.
Page 11.
They know the fucking
Special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a
And
person
because he's
in
reading
Sarah
it,
Boone's
they may not
circumstances
reread it.
would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.6G, justifiable use of non-deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. The law on the justifiable use of non-deadly is as follows. Sarah Boone was justified in using non-deadly force against George Torres and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against George Torres's imminent use of unlawful force. In deciding whether Sarah Boone was justified in the use of non-deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of non-deadly force was necessary. Moreover, a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. However, the use of non-deadly force is not justified if you find that Sarah Boone used force to initially provoke or threatened use of force against herself, unless one, the threatened force asserted towards Sarah Boone was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on George Torres. Or two, in good faith, Sarah Boone withdrew from physical contact with George Torres and indicated clearly to George Torres that she wanted to withdraw and stop the use of non-deadly force. But George Torres continued or resumed or threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who, because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres Jr., you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder and/or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.7, plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules.
Oh, God damn it. I'm muting
consideration of
myself.
her testimony.
Okay, sorry. Let me say that one more time. They have to give that instruction because, God damn it. All right. Fucking boomer everything. Because they had to give that instruction because some of the expert witnesses were not actually qualified as experts, right? So the defense fucked up about as bad as I did unmuting my mic with qualifying certain people as experts. Good explanation. Also, Halmir 23 says she, like Nikki the Nose, should just take the plea. Too late now. Too fucking late now.
That you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9 Bravo. Defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. 3.10, Rules for Deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this matter. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision, in this case.
Real talk, though, it always does, right? Like real talk, you're not supposed to. You're not supposed to. But when you see one side that's been fucking around, playing tricks, yeah, they absolutely, you're not supposed to. Yes, I agree with the law.
Sending you in and out of the courtroom all day for an entire day.
Yeah, exactly. Natasha says that happens when you get older, boomer. Yeah, it's very true. Also, let me get this one. Doctrine D for 10 says legal mindset, more like legal mute, sucker. That'll be clipped. All right, let's continue here.
5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. 3.11,
Come on
cautionary
back here,
instruction.
city boy. Sweet.
Deciding a verdict is exclusively
sweet.
your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. 2.7, closing argument. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. With that, state, you may proceed.
Okay. New poll in the chat.
This is a box. This is the box where George Torres was killed. It's a small box, 28 by 20 by 8 7/8 inches. George Torres was zipped up in this box. George Torres took his last panicked breaths in this box. The medical examiner explained to us that with each breath George Torres took in, there was less oxygen in this box. George Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. First section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So as we start out here on Introduction to Homicide, we come to the first section on justifiable homicide. And it reads, killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because George Torres was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have.
I like that line. He couldn't scratch his own head.
He's showing him how to rule. He's like, just this is what you do when you get back there. It's going to be quick, I think.
It reads,
If it's guilty.
Killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident and in misfortune, doing any lawful act by lawful means, usual, ordinary caution, and without any unlawful intent. Well, the problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when George Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could feel her grievances. Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution. And that is not applicable in this circumstance. Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. George Torres couldn't provoke anything from his circumstance. George Torres was confined to this box. Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used, the killing is not done in a cruel and unusual manner. This fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking and we're all having fun when she decides that it's going to get a little extra real for George Torres. And it fails on the 2nd count because George Torres was killed in a cruel and unusual manner. Next, we turn to our main charge of 2nd degree murder. And the law informs us that to prove the crime of 2nd degree murder, the state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of 2nd degree murder to be for the defendant to be found guilty in this case. We've been hearing all kinds of facts for almost 2 weeks now of trial, but these are the 3 facts that had to have been met by the reasonable doubt standard in order to be found guilty. Ladies and gentlemen, I submit to you that the state has proven 2nd degree murder beyond all doubt. And the proof of that guilt is overwhelming. But I will cite for each element just one fact that conclusively proves each of those elements beyond all doubt. As to the first fact, that George Torres is dead, well, we have stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another in demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. It's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another in demonstrating a depraved mind if it is an act or a series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays an indifference to human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you. ING 1062, states 17. Mr. J, may you publish states 17?
Sarah. For everything you've done to me. Sarah. For everything you've done to me. Sarah. Fuck you. Sarah. Fuck you. Sarah. Stupid. Sarah. That's my name. Don't wear it out. I can't fucking believe it.
Evil.
Yeah, that's when you do me, choke me, Cheryl.
This motherfucker interrupted that by saying it's too loud. What a bitch, trying to interrupt their best evidence. You know what they should do? Rewind it and play it again. Fuck you, Owen. You're not supposed to be able to object on closing. It's a rare thing. And of course, they found a way. Oh, I guess they didn't want to watch. They couldn't watch. Oh. Come on. That might have been the family. That's George's family. They might have been crying or something. I don't know. So maybe they were crying and like the Owen.
No, I was just
objected to
saying,
the
yeah,
mimic.
that was George's family. They couldn't handle that.
Mm. They've seen it before, I'm sure, many times. Yeah, I think he did object to them. The mom was crying. I think that's probably what it was. Yeah. Understandable, but yeah.
Your Honor, strike the crying from the jury's memory.
And Sarah's like, oh yeah, that was fun.
You may continue.
That was all fun.
Sarah. Sarah. Sarah, I can't breathe, baby. That's on you. Sarah, I can't breathe. It's on you. Sarah. Real ransom. Now you want to give it for it extra. Because I got it. Sarah. Real ransom. Sarah, I can't breathe, babe. Oh. That's what I feel like when you string on me. Sarah. Fuck you. Please, Sarah. Yeah. You should probably shut the fuck up.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions.
Yep. I agree, Tom.
We know from the evidence that this was not the first time she had considered killing George Torres. We know from the evidence that on January 13th, 2020, approximately 1 month prior to George Torres's murder, the defendant
She made both claims in that video.
Please do something with yourself, Sarah. God bless you. Bless you and all of you too. I'll get rid of him. Then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death.
He's doing a good job of it. Thank you, Cast Master 2.
Next. We turn I'm gonna bypass the lesser included offenses.
Yeah, I was gonna say it might not be the state's job to do that for murder too, but he's doing a damn good job.
The law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the
Really?
night that George Torres was murdered,
Thank you, not an
and that
FBI for two.
maybe somehow that would excuse the conduct or be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime.
Feet sniffer intent
Evidence of a defendant's voluntary intoxication
is not needed here.
may not be taken into consideration to show that she lacked the specific intent to commit any crime.
That's the case law.
A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's
It would have been way more difficult.
evidence
Possible, but
of
difficult.
the defendant's intoxication from
Thanks, Clint.
watching her on the public surveillance, buying the bottles of wine with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise, and he is going to show you this. And this. And this. And he's going to talk in this as well about the list of grievances that Sarah Boone
Preempting their
had
argument.
for George Torres.
Cutting off its balls.
He's going to talk to you about curtain rods. to talk to you about black eyes. He's going to talk to you about what an awful, awful boyfriend George Torres was.
Using his own Kinko's shit against him.
And ladies and gentlemen, at the end,
Handling
of all
them like
of
they're
that,
trash.
it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because
Yup. Good
as
job.
we continue to read this instruction, it tells us in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box,
Good argument.
who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it. Hide and go seek time. George gets into the suitcase.
Her life is like a silly rom-com, guys.
But we're still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, George Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen.
Yes!
She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. He couldn't exert anything, ladies and gentlemen. George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his...
Judge, I object.
Approach.
See, this is wildly inappropriate. I knew Owens was going to try to pull this bullshit, but this is crap. This is complete crap. He probably got 2 hours of sleep prepping for this. Yeah, he's got as little sleep as I have. So
Yeah,
smash
if you
the
guys
like
check
button.
back in the stream, we both pretty much predicted that this would happen.
Yeah, we said he's going to object, and he did. He did. Because he's going to try to, you're not supposed to do it. It's unprofessional, and honestly, it's going to be overruled no matter what. Like, this motherfucker's got nothing here, right? Mark Reality said, I went through the whole trial and didn't notice the court reporter until now. I worked too fucking much. They've been there. Mark, the degenerates in the chat have been commenting about her feet the entire time. Come on, man. Get it together. Feet Sniffer for 5 said, the poll is bugged. How do I select Ava? Detective Mommy won for best witness. We'll have a poll with Ava in it later. Don't worry. Don't worry. It'll come around. Sigrid Attorney said, would you be interested in a character AI case that happened recently? Yeah, sure. Send it to me. Email it to me, and I'll check it out. And I try to group the cases and the things I cover together. So if I find some other
Objection
AI
overruled.
cases, I'll cover it. Yeah, see, overruled. We called it.
No help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, George Torres never got a chance to do anything. George Torres never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us, again, you find that Sarah Boone, because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now, we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the special instruction.
Anonymous
on
nobody.
battered spouse.
Both of those statements can be true.
You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we heard from 3 experts in the areas of battered spouse in this case. And I think at the outset, it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche.
Good.
Battered spouse is not a license to kill.
Very good.
The fact that George Torres at points mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean
Very good
that
argument.
because he did
This is such a strong
these
closing.
awful bad things, that now through the rest of time she's a battered spouse and she just has the right to kill him or to make him suffer or to punish him or to make him feel uncomfortable or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does, it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brannon's testimony that was very critical. Dr. Brannon talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brannon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. In her opinion,
Dr. Harper. Oh my
was
God.
much more straightforward. Remember, Dr. Brandon did not render an opinion as to whether or not she suffered from battered spouse.
Yep.
Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brandon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on meant that the trigger was not domestic violence or some threat. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because George Torres never got out of that box. He never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
Yeah, this case is so old. Trump was president. Yeah. It's an old case. He's doing a great job.
Yeah, he was self-filtering his own words in the videos that we do have. You're right.
Here we go. Yeah, good selection. Good.
I'm going to go to court and I'm going to tell the judge, listen, my fiance has nothing to do with it. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She will stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other, we both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She especially.
Especially her. So please, if you can,
Dismiss.
dismiss this case.
Closed.
Drop it. She is not the type of person.
Good person.
Great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet.
What?
And they could.
I love you. What else you want me to say? God will prevail and He will take us out of this situation.
It's sad. Lucifer was an angel once.
Clearly, George Torres is dominating the defendant. Clearly, George Torres is the one telling the defendant what to do. Clearly, George Torres is the one calling the shots at 4748 France Lane. Ladies and gentlemen, are we so sure that George Torres wasn't the person suffering from battered spouse syndrome? Next, we're going to come to the justifiable use of non-deadly force. The language and the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed that the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. George Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took torturing George Torres to her follow-up video at 11:23 after she had moved the suitcase. Mr. J, you published from States 17, IMG 1063. It was a short video. Well, what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later from the time that started, you see that the makeshift coffin that he's in has been moved. And his voice
Makeshift coffin.
now is soft.
What a line. What a line.
The life is draining from George.
That was a
Perez.
great line. My God.
Evidence
He's sitting at
in
home.
that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only George Torres in this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. George Torres and Sarah Boone. But only Sarah Boone ever walked out of that front door alive. Did the witness seem to have an accurate
Mark of
memory?
reality, are we to count
This is an
them
emphatic
reading
no.
verbatim the jury instructions in full? Because that's going
And
to take some time. Or is it a
The
total?
litany
It's
of
got to
her
be a total. We can't break that down.
intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not George Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events.
You got 70 minutes. I got 80 minutes. Let's see who wins.
On the body cameras, on her first
Mark said
interview
26.
with law enforcement, and then you hear her in her next interview the next day with Detective Copsell and Detective Lowen, and more details come out. Things change. First, she was never intoxicated, then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt when she described using that baseball bat to hit George Torres's fingers back in the suitcase when he attempted to save his life? Do you have any doubt when she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of George Torres being murdered and her laughing about it and talking about the fact that he cheated on her? Do you have any doubt after reading the text messages from her phone, after seeing the videos of how she controlled and manipulated George Torres? And if you say, Mr. Cacciatore, I still have a doubt, well, then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt.
Yes!
It's a doubt born from the imagination of Sarah Boone. it is not a reasonable doubt.
Yes!
But if you find yourself
Fucking epic.
back in that deliberation room, and you are just trying to think of some way
Absolutely based.
in which the defendant
It's
is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second degree murder.
Woo! Good one. Oh, man. Well, I'm going to pause that there before we go anywhere. Ava, comments, because I want to give a little bit of ability to comment before we go ahead and we'll catch
That
up on
was a great closer. That was an absolutely great closer.
Yeah, I mean, that is probably like in the textbook how you fucking do it. You present the jury instructions, you go over how you want them to rule when they go out to deliberate. You prove the basic elements of your case.
Do you get a time on that too? Nice and short and sweet. Don't get
Exactly.
overly wordy with your closing.
That was under an hour, easily under an hour, right? And the thing is that he took their strongest arguments, those fucking shitty boomer Kinko's blow-ups, and he fucking dismissed them. He says, yeah, you're going to see them. They're going to want to. It doesn't fucking matter. His shit doesn't matter. He called out Sarah Boone. He literally pulled the when he's talking about Sarah Boone, right? You know,
Nice argument, Senator. Why don't you back it up with a source?
My source is that I made it the fuck up.
she made this the fuck up. She did not. All of this BWS, pointing at and saying it's in her head. Beautiful, beautiful. I mean, that was textbook. I have no critiques for that really at all whatsoever. Ava, do you have anything that you would even critique
By
on
the
that?
way, the best line is the makeshift coffin line. Cold as hell.
Yep. Mark says objection, Martinez versus State. They already covered that reality. Well, you weren't gone with the Martinez. They already handled that. Mechanist versus Golden Gear. State used Rotor-Roller. It was super effective. Real Character says claps in the chat for the closing. Savage, very much so. Tatsumi says, Your Honor, my client has obtained a get out of jail free card. She is free to walk. Nope. Bad news badge for 20 unintentionally. Yeah, the drinking doesn't matter. The drinking does not matter at all. Utsahia says objection, sarcasm from Owens. You knew we called it. Both Ava and I said he's going to object, and he did. Zinth for 5 says this lawyer is on the team specifically for the strength of his closing. I'd put money on it. Evidence helps, but he's delivering well. No, and look, it's fine if you have strong evidence, but if you can't deliver a convincing argument orally, you're done. And I know a joke, make all the oral jokes, blah, ha, ha. But seriously, if you cannot get up there and speak and make it in a verbal way, convincing to the jury, you're going to lose. Even if you have all the evidence in the world, you have to finish strong. And he did that. And it's not over, by the way. He's going to get a rebuttal as well. So he's going to be back up, right? Him or his partner, although I think they'll put him. But his skills are definitely there. So yeah, we guessed, Ava guessed 80, I guessed 70, Mark guessed 26. A lot of y'all were guessing in the chat. I think it's going to be relatively short, one way or another. But I'm pretty set on the way I think it's going to go. Natasha said, Owen, but wait, there's more. Word salad while grasping at straws. Yeah, exactly. That's what he's been doing with his objections for the longest time, is just fucking word salad. So without further ado, let's get into defense. And they're going to start their closing arguments.
Members of the jury, it is 4:04. As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before, please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. Do not have any discussions among yourselves or anyone else. We'll bring it
How
back
long
in
do you
about
think
15 minutes.
defense's
Thank you very much.
closing is going to be?
Longer. So let's fast forward here.
Okay, may proceed.
Oh, they're gonna.
Boone's entitled to a fair trial. I think that right's been compromised.
Oh, he's gonna try to make a motion
Who's scheduled to put the two detectives on the front row
for
his
mistrial.
family of the victim. But they had to have known to tell them that the suitcase video, which has been around for 4.5 years, was going to be played during opening statement. And the state attorney's office or the sheriff's department had to advise them, or the victim.
He's trying to move for. He's gonna
had
motion
to
for a
advise
mistrial.
them that if they couldn't take it in front of a jury
Based
trying
on
to
the
decide
mom
case,
crying.
they needed to get out of the courtroom. Now, what happened here today should not ever happen. There should be safeguards in place. There's no room for this after 2 weeks of murder trial for something like that to happen.
He's objecting to
One
the
of the
mother,
Torres
mom
members
crying.
of the family audibly during the 2 minutes.
This is a Hail Mary.
Expressed some kind of emotional reaction. I look back, he or she were bent over in agony, physical pain.
This guy's a fucking piece of shit.
The physical pain followed the audible announcement.
Yeah, I'm
can't unring that
disgusted
bell.
with Owens.
That's their responsibility to ensure that kind of thing doesn't happen.
Just because Sarah Boone doesn't have any fucking emotions doesn't mean other people have to live that life.
And especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim's family has the right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not
They'd have rights to be there. Yep.
she clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the court. But again, to say this is intentional sabotage and all the accusations that continuously get made are unsubstantiated. And it does not warrant a mistrial. People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors. So the motion should be denied.
Motion's denied.
It's the suck it, Owens. Oh, suffer.
Jury's going to be back
Suffer,
in
Owens.
about
Oh,
14 minutes,
sorry.
counsel. So we'll reconvene at that point in time.
Get friggin' wrecked, boomer.
Yeah, can we clean the well from the state's materials, please? Thank you.
Oh, go get fucked, Owens. Piece of shit. Like the fucking mom's having an emotional reaction. You know, it's been out there 4 years. Yeah, guess what? If you watched your child dying,
I'm
you'd
sorry.
probably have an
He's
emotional
objected
reaction.
multiple
no matter
times during closing, and he's making a mistrial based on that. So disgusting.
It's really ridiculous. It's fucking ridiculous. Suffer. All right. Another says for 5, objection, chicken cacciatore is an Italian dish, not a prosecutor. Yeah. Somebody said that somebody got confused and thought the prosecutor's name was Owens. Owens is the defense guy. He's the boomer. Right. Patrick Stewart for 2 said, I think we just witnessed a second murder. Triple J26 said, error 404, defense not found closing. Oof. Captain Spire for 2 said, this is how Freddy Krueger got a mistrial. Oh, man. Chaos Smash for 2 says, virgin defender and Chad prosecutor. Yeah. Sparky's text quarter said, and the juror was there to watch it all. They watched the fucking murder. And Cheryl Morin for 20 says, yes, Judge. Hell yeah.
Yes, yes.
closing is gonna.
Yes. Okay. Sorry, Ava. That I interrupted you. Go ahead about the defense closing. Do it.
Oh, you're good. Yeah, I don't think. I mean, he's been this wild outside, like in the jury's presence. I think his closing is gonna be pretty wild too.
Yeah,
He's been pretty bold.
There may even be some objectionable stuff in his closing, but we'll see. We'll see what happens there. Okay, I'm gonna catch up live here. Let's go live. Okay, so we just caught up, so we're now fully caught up. We're live, so it's still on break. We got some time here. What's the over under on the defense arguing jury? You cannot argue jury nullification. You cannot argue jury nullification. You can just tell them to, vote, and it's like based on reasonable doubt, I guess. I mean, you can make other sort of arguments, but you can't straight up say nullify this verdict, right? No, you cannot say that. So I don't think that's gonna happen. I think they're gonna make the woe is me, Sarah argument, and I think they're gonna pull up the photos and talk about what a piece of shit George was. And that she had a fear for her life, and that's what the experts testified to, etc. Sarah's a fucking angel. She ain't do nothing wrong. She excels at everything in her life. My baby didn't do nothing wrong. We're gonna definitely get some of that for sure. The attorney is coping and seething. Yeah, release the Kranek. Denied over there on locals. Let's see here. The coffin thing. I thought the coffin reference was beautiful. Now, I know Tom said people got a little bit annoyed when he first referenced it as a box, but he kind of saw that coming with the coffin. That was actually beautiful to use that as a frame of reference to say it's effectively a coffin, right? I thought that was a smart move. Can the judge hold Owen when in contempt without having to reset the trial? Yeah, they could. I mean, it's happened in there's been cases before where attorneys have been held in contempt. They've been even sent to jail. We saw that in one of the Young Thug case, right? Remember where the attorney got sent to jail, literally, because they refused to break attorney-client privilege. So the fucking judge sent them to jail like a gangster. Judge can do what they want. Yeah. So we'll see. But I know they're going to get wild in the defense closing. But I think it'll be within the parameters of what we've seen in the arguments we've seen. Obviously, Sarah's had some input, and I'm sure she's told him some things that she wants to bring up. So, yeah. Let's see here. Frostbit says, just woke up, and the first thing I see is the boomer being a weirdo again. Yeah, exactly. Thanks, Frostbit, for the 5. And also, I want to say thank you to everybody who went and supported my Ko-Fi, because I now have 54% of my goal. So thank you so much for that, guys. It's been really awesome. A special thank you to Eric H., Doug Diaz, JP Ravenfire, Tamada, and Orsa Platz, who gave very generously in the last couple hours. So thank you so much for it, guys. Appreciate that. Thank you as you help me improve my operations here, right? As you can see, the camera is already working pretty well, although sometimes I have to like wake it up. It kind of goes into like sleep mode. So like kind of like a boomer.
Guys,
So
we have to get Inciting and do his VTuber form.
Yes. My final form is VTuber. All right. Then people will really not know what they're watching. Now they're like, okay, we're watching a lawyer, like we're watching a 3D lawyer in 2D anime, and then it's just to be all 2D. All right. Let's see. Lawyer that actively argues nullification is lawyer that loses their license and maybe sanctions. Yeah. I mean, if you want to quit the practice of law, you can argue jury nullification. If you want to, if that's your last thing you're going to do, sure, absolutely. Also, get those likes up. We have 1,200 people and 780 likes. Remember, 200 more likes, 216 more likes, and we get Ava making a cover of Big Iron. Right, so I'm pretty excited about that. Definitely want to hear her doing a cover of Big Iron. So get those likes up. Just 200 more. You guys can do it. Like it hard. Is Iron a prequel to Rust? Oh, no, no, no. I really do think it'll be a shorter deliberation because here's the other thing too. The judge read out the instructions to them. So they'll probably go in there and you see how they all have their hands
No
up.
one dared to ask his business, no one dared to make a slip, for the lawyer there among them had a suitcase on his hip.
Oh, so good. All right. But yeah, I think how the jury is right now is they're all ready whenever they come in. They got their hands up. They're all ready to go. They want to get out of here. They want to be efficient. It's the weekend. They have better shit to do, right? They want to go back to their lives. And I think that they are going to walk in and look at each other and be like, does anybody not think this bitch is guilty? Okay, we're check. I mean, they may have to read through it, but that's effectively what I think will happen. That's my most likely scenario. Now, if there's one juror who's a holdout, then it goes very long, right? Then it'll go long. Although I see a decision being made tonight one way or another. Nikki P says, I can't like the video anymore. Smash that like button. We need the cover. Thank you, Nikki. Tomahawk PWPT says, genuine question. How does the defense successfully defend a case like this without outing themselves like Owens here? What does good defense look like? A good defense looks like, look, Owens could have made an argument for a mistrial because you're allowed to make those arguments and they routinely make them in a way in which was focused on presentation of the evidence maybe, or focused on something that was more procedural, right? That's one thing. Also, you could just make good faith motions, right? I'm sorry, but just because you can make a motion doesn't mean you have to make a motion or need to make a motion. And we've gotten into an era where they feel like they have to make these motions, right? Even though it's a may, right? They're like, oh, we have to go for a mistrial, even though there's no grounds for a mistrial. How about you don't make the motion if you don't have to, or if you don't have solid grounds, right? It's weird to me. It's weird to me. Charlie Spurs said 12 jurors go in, 1 hold out, 11 come out.
Yeah, there is a difference between may and must.
1 stays in the suitcase. Yeah, and that's a big point. And I think that, attorneys should keep that in mind. Look, there's zealous advocacy, but also we have a duty of candor to the court, which means you're not supposed to fucking lie. So if you're going in there or standing up in court and you're lying, it's not good. Mark Riata said, I don't know who wants a jury nullification argument, but I think we should bring up the good old the gold fringe on the flag and the defunct Articles of Confederation too. Yeah, because really court is admiralty court, right? Let's make those sovereign citizen arguments, right? We're just traveling, right? You have no right to stop me because we're traveling. And this is admiralty court. It's all a big ship. That's why there's a ship in the Seal of Florida. That's a nod to admiralty court. This is all really admiralty court, guys. It's what you don't know. The more you know, the more you learn. And here on the Legal Mindset, we're going to teach you. Let's see. Did I have anything over on my locals? Oh, I did actually here. Invader Talk on locals says the defense is coping and seething. Thanks for that, Invader Talk. Appreciate that. In fact, while we're waiting here, let's play the Ava cover.
You are coping and seething. You just can't accept what you see. Yes, you're coping and seething. The truth, it is scalding, and now you are molding and coping.
We are back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Jay for the Florida, State of Florida.
Ava thought I was just going to play that once. It's now in my reactions.
Tony Henderson, Sarah Boone.
Ms. Boone is still seated at counsel's table wearing the same clothing from this morning. Are we ready to bring in our jury for the defense closing at this time? State. Defense.
Judge, I would like you to give the audience an instruction, and then if you would, instruct the state attorney to instruct whatever family members or friends of George Torres may not be in here and may not be able to hear the instruction, but may come in during the trial so that we can try to get some order.
Are there any other members of Mr. Torres's family that may be outside that may be joining us? Okay. All right. So she's left. She's no longer here. Okay, that's what I just asked. Is there anyone outside? Okay. Okay, all right. So, members of our gallery, good afternoon. I'm going to please ask you to please contain yourself and not to have any emotional outbursts. We had a minor one, and the person, whoever it was, had a small outburst, then hid next to another family member, and then excused herself during the last during the closing. It seemed to be minor in nature. However, I'm advising everyone that at this time, if you believe that you cannot control yourself or your emotional responses during the defense's closing argument or any rebuttal by the state, I'm going to politely ask you to excuse yourselves at this time. All right, thank you very much. Mr. Owens, anything else, sir?
No, sir.
All right, state. All right, let's bring back in our panel.
Repton says, thoughts on Judge Fleischer. Didn't that guy get sanctioned? Isn't it? That's the weird Texas judge, right? Also, RGX Dare for 10 says this may be early, but it's great
to do that. Thank you.
It's great having another law tuber. Glad to have Elfie here as a co-host. Great coverage on this, Andrew. Very informative and entertaining. Thank you so much. I'm so happy that I feel like trial streaming is back, baby. You know, we don't need the Baldo to do trial stream. We can do it ourselves here, and it's also great to bring other people in. I'm so glad Ava came in and we brought her, and I kind of indoctrinated her into this because it's great to have an attorney as well who can look with an attorney's eye on the case, and an elvish eye as well. You know, they're known to have keen eyes, so it's good to have her here. I'm very happy she was able to join for the entire trial and kind of stay through it. It's been awesome.
We got dark vision.
Also, Detective Mommy was there. Oh yeah. Okay, so I've done this Potato King. Any chance you could do a watch on good old trials? So okay, I'm gonna spoil my content for the future, but I thought, like, if I, when, not if, when I'm VTuber mode, I will do that as like a reoccurring thing, like maybe watch some old trials or maybe watch clips from trials, right? Because maybe the entire trial is boring. I tried to do that with, for example, the case of Casey Anthony, and it was too boring. So I think what we might do is just watch stuff like closings or openings or stuff that's more punchy, right? Or depositions, etc. Stuff that's got more meat to it. Because I think that's a little bit better. But yes, if there's a great trial, we may look at it. But I know that, for example, Vices did OJ, and yeah, for parts of it, it gets watched, it gets some airtime. But most people like to know trials when they're happening kind of contemporaneously. But yeah, also I like it. Lawpub, I made you. Yeah, no. Sigrid Eternia says, if Boone jumps the podium like that one guy did, I'm losing it. That'd be funny, but I doubt she's got the vert. Troubleshoot for €2 says, get a dwarf next time. Oh no, dwarves and elves. What is this, a Gimli Legolas combo? That'd be too much. Also, I love who said it here in the chat.
You know what? It's really messed up for snow elves because dwarves mutated snow elves, and so that's super messed up, man.
It's fucked up. Sneedar says Owen should go for €5. Says Owen should go full Francis E. Tech on the closing. I want to see what happens. I think it's going to be pretty wild. But yeah, sorry, I was going to do the imitation. Shaster lawyer. There you go. I love imitations. Charlie Spurs said, I need Casey Anthony's lawyer and her judge. Well, Jose Baez is definitely well known in Central Florida. His law firm made its name off that case, and he does very well for himself. Frostbit said, I swear to God, if I have to sit through a trial like this when I have jury duty in November, I'm a suitcase myself in a courtroom. Frostbit, you better pray you get a trial like this. This one is relatively efficient and effective. You could get one that's run way worse than this. Now, I will say most trials are just like driving while license suspended or some minor pot charge or some other bullshit. So they're usually quicker and there's less things you need to present, but still. Like, for example, Nick Rekieta's trial, and we're going to talk about Nick Rekieta a little bit later while we're waiting for the verdict, because we've got a Nick Rekieta crack pope update. But for example, his trial will be very quick. I mean, the whole thing could be done in one day. Like literally the whole trial could be done in one day because there's not many witnesses, not much evidence, maybe 2 max, but trials can be done in a single day. It's very possible. Many trials are done in one day. So did Ava just casually drop Elder Scrolls lore? Ava? Elder Scrolls?
I totally did. I totally did.
She fucking did it, guys. She fucking did it. Wolfsbane says, why is elf considered a slur? Wait, what?
Excuse me, sir. What is your ethnicity? I am interested in calling you a slur.
Thank you for Eagle for getting me that clip there. That was a really good one from my clipper Eagle. Also, shout out Eagles in the chat for Eagle. He's going to be really busy clipping. He's going to clip out the closing, so I'll have those separated out. He's also going to clip out the segment I do on Nickety Crackets once I get to that. We're not there yet, though. So shout out to my clipper Eagle. He's always very hardworking. He's on top of stuff. Really, really good guy. And I really appreciate him helping me out. I couldn't do this without him. And I couldn't also do this without you guys, chat, because you guys make it happen. Still waiting on this. So I'm going to update the banner here. So let's get the defense closing. Okay. Coping and seething imminent. Okay. Cool. Also for the likes, what are we at right now? Is that true? 855, 145. And we're got the cover of Big Iron. We are almost there, guys. We're almost there. Frostbit says it's juvenile court in Michigan. You never know. Okay. But still would be a little weird, though, Frostbit. Still be a little weird. Ann Banbridge says, at least no gun for Boomer at the point at the jury. Oh, yeah. Like Binger in the Rittenhouse case, you could tell that Binger never held a gun in his life. He didn't know how to place it properly on his shoulder. How he was holding the gun was like he was holding a Baldo. Like he was like, the guy was absolutely weird about it. It was the most embarrassing thing ever, seeing that guy holding a weapon. Right. And if I recall, he pointed it straight at the jury. Like he covered the jury. Right. He pointed it at the fucking jury, which is like basic gun safety 101. I don't care if it's not loaded or not. You don't do that, period. Right. It also is an apparent threat. Yeah, he pointed at the jury. Yeah, that was a felony. Yeah, he literally committed a felony. Yeah, he handled it like he handled his phone going through Grindr. And that's not even a joke because for real, he was Fluffer Boy 69 or whatever the fuck it was. Elves are known to be extremely racist. Well, you know, they're not wrong about their stereotyping of the other fantasy species. They're not wrong. Listen, the second orcs move in the neighborhood.
Look, normal elves, but snow elves, we're kind, we're isolated, and I would akin my, like, lore-wise, I would akin my village's culture closer to, like, Nordic culture, like Norwegian culture.
But for real, though, the dwarf smell don't let them in. And the dwarvish cooking gets on everything. I'm just saying. Stay away from the dwarves. Free Rin Supremacy. Oh, yeah. Yeah, well, I think we bonded over that in the chat. I love Free Rin. Free Rin's a great series. Season 2 of Free Rin is approved, by the way. Super excited about that one. Great series. By the way, I think if you want to get somebody into anime who's not into anime, Free Rin is actually a really good series to do that. It's one of the newer ones. Other than stuff like Cowboy Bebop and the classics, I think Free Rin is...
Free Rin is an amazing series, and I love their different approach to the fantasy genre.
And it's not about like a power fantasy story or whatever. It's about like literally thinking about your life, what you've done, the people you've lost, going back and reliving.
You're not
that.
dealing with the hero's journey. You're dealing with what happened afterward.
You're right. After the hero's journey, right? Because they never show that. They're like, well, what happens to the heroes after they win, right? Coffee Bot, we're at 64%. God bless the goal. We're there. Thank you so much, JP Ravenfire. Thank you so much for the support. Appreciate that. Appreciate that. You guys have been very, very generous with Ko-fi, so appreciate that. Helping me out with that capture card, getting me closer and closer to my legal plans, right? My legal and illegal plans, which are going to definitely come into fruition. I'm buying a lot of stuff in December. That's like my Christmas present to myself is a new PC build. So capture card is part of that. Thank you so much. Sigrun says Binger with the gun felt like a transparent attempt to scare the jury to get them to be scared and therefore vote guilty. Yeah, it was. And they did so many unethical things in that trial. Look, Owens is like kind of scummy, and he's clearly like kind of stupid too and pedantic, but I don't think he does it as maliciously. I just think he's like a cantankerous old coot. I think, like, literally, I just think that's his personality. Binger was malicious. He did it with malice. And the fact that he was there with Lunchbox, his like morbidly obese, balding friend who, was always trying to take a snack break. It was like the picture perfect image of injustice in the American justice system. It was great. Charlie Spur said, Your Honor, this is Admiralty Court, and you have yet to prove subject matter jurisdiction for the record. Subject matter jurisdiction. Yes. We got to prove it. Anthony for 2 says, but them dwarven women, though. Well, only if they're rings of power compliant. I don't like anything before rings of power. It really was not as up with the quota of diversity we need to see. So, we got to have all types of dwarven women and maybe men too, because the race of dwarves was totally able to be propagated by all men. What's wrong with that? Invader Talk said, modded Skyrim is best Skyrim. Vanilla Skyrim still better than vanilla Starfield, though. Well, it's not a stretch. Let's see over here on locals. The locals is fapping to Detective Mommy. Got it. Oh, also, I'm going to put the simple. So who do you simp for the most? Okay. Got Ava, Judge. Okay, we'll get LM in here. Or Detective Mommy. See, I'm about to get felted in my own poll, but it is what it is. All right, there we go. Polls up, because the simps in the chat wanted this. You guys want this? I deliver it. It's like feed picks.
Okay.
I don't know if that is allowed by the court or
anything.
They just unmuted.
I started practicing in 1997.
If you want to split up your closing between the two of y'all, that's fine by me.
Well, I intended on doing the closing, but when I finish, Mr. Henderson wants to say something. I may ask you to.
I've never seen it done that way. I've understood the sandwich can be broken. I've never, ever seen a single closing argument split by another.
I need like a confused toggle.
Neither have I.
Weird.
You pick an attorney and that guy makes it. You don't fucking split it. Now, what you could do is you could have one attorney. No, well, not for the defense though. Like I couldn't. That's just weird.
If it's a discretionary issue, I'll leave it up to you, sir, on what you want to do and how you want to present your closing.
The entire closing himself, and then the other lawyer wants to say something. It's weird.
Yeah. Thank you so much, Bald Eagle 1787. Holy shit, gonna meet at 85% on Ko-Fi. Thank you so much. Appreciate that. Wow. And Bald Eagle saying, I expect your VTuber to encompass degeneracy and autism. That is chat. Listen. You have my promise that I will be just as degenerate as chat. I will be just as degenerate.
It's VTubing. There's nothing but autism and degeneracy.
Yes. I mean, once you get behind the model, it's mask off, right? It's mask off. Let's see here. Natasha says grounds. Wolf's Pain for $1.99 says dwarven short stacks or goblin short stacks, bro. How about neither?
Who would be objecting during rebuttal?
Mr. Owens.
Okay, there you go.
Chaos Smash says, why is this baguette standing up? Because they're trying to decide what the fuck they're going to do and they're confused. They're very confused. Yes. But thank you guys. Really, really appreciate it. Very, very kind. I'm very, very much looking forward to making that move. In fact, I'll be putting in.
You know, Russ, we need assets like from Phoenix Wright Ace Attorney where you can push a button and it says objection.
Objection.
Hold it.
Objection. And let's see. So, guys, I will say this too. I honestly, I've said it once, I'll say it again. This is putting my faith back into trial streaming. I was a little bit jaded because the Murdaugh trial and how fucking boring that was. It kind of shell shocked me for a while. But this has been a very relatively interesting trial to cover, and where, yes, there have been moments of boredom, but overall, the tempo has been exciting. And there's been a new kind of face to every day. There was one day where the prosecution sucked, with the cross of Sarah Boone. But then the next day they came back and killed it. And the following day they did even better. There's been days when it was largely witnesses or attorney battles, right? Which ended up being kind of fun too. So, I mean, this one's really put my faith back into it. Now, of course, the topics would have to be good and it'd have to be televised, right? But if it's televised and the topic's good, I'm more open to it. I've still got Courtney Clinty whenever that goes. I'll do that one for sure. But if you guys find other really good trials, really good ones that are televised, you can let me know, right? So, for example, something like the Diddy trial is not going to be televised. It's federal, right? So there may be good trials that people want to see. They ain't going to be televised. Shabusiness was all right. Shabusiness was okay. Halderson was horrible. Brooks was great. Yeah, if only Diddy was, but no. Diddy's the diddler is gonna be behind closed doors. But also, we need a break from trial streams. And, it gets very taxing to do this. I can't do this every single month. I mean, maybe once a month I can do it, but not more than that. I will also be streaming the trial of Nick Rekieta, assuming that's televised. I will stream it.
Yeah, I was going to say maybe once every 2 or 3.
Yeah, once every 2 months.
Nicholas Rekieta, oh my gosh, I'd be there for that one.
Yeah, and honestly, it's great to have a video.
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. Y'all may be seated. Members, jury, for one of the last times, if you could, please raise your hands to confirm.
One of the last times, baby.
All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens,
along with Tony Henderson.
Now, if only we could
And
1.25 on this guy,
we're all
right?
From Milton. I think y'all figured
Yeah,
that
we're
out.
already live, so we
Santa
can't
Rosa County,
go faster.
Northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The team, the defense team, is here, and we're here to represent Miss Sarah Bennett. And we feel confident that we're going to be able to show you why she's not dead. Okay? And I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that we're going to show you. And then we got a couple of videos at the end. Okay? And we're going to try our best to help you make the right decision. Okay? But yeah, Milton's a small town.
Objection.
Overruled.
I'll tell you how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. Very small town. We didn't know what to expect coming down here to Orlando. Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it, but I wanted to say.
Yeah,
a
it's
small town.
irrelevant shit.
We've been down here 3 weeks. We didn't know what to expect. We've been surprised. From
Objection.
Yeah, believe it or not, because if he tries to filibuster and move this out to where it's pushed to Monday,
He's trying to make like a personal story. Like yeah. Someone said it. I'm a simple country lawyer. We're just here. Well, we don't know what's going on. I'm just here for the biscuits and gravy.
I was just born a simple country lawyer in 1945, a log cabin I built on my own 2 hands. Before I was born, I do declare, yes, sir, I do.
I was down here during the Labor Day hurricane that blew away the Flagler Railroad.
all I wanted to say is just since we've been here, we've been treated with respect and hospitality, and just like we've been at home. We appreciate that.
Move the fuck on. Get into it,
I'm gonna do
bitch.
some reading, and then I'm gonna do some talking. But ultimately, this is about justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us from potential attack.
Prosecution ambushed me, so I'm going to ambush you in closing.
We're
How
the only
about that?
ones, in this case, because Sarah Bennett was arrested, it's going to be able to look at it critically and objectively. Objectively. Not like the state attorney.
Objection. Proper argument.
Overruled.
Objectively. And the law in Florida gives y'all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial and some of the things they said.
Objection. Objection.
Yes.
Yeah, he's getting pretty fucking uppity. He's getting pretty uppity, and he is moving towards grift and slander. Yeah, he's moving towards that direction. Yep. All I hear is Owen say blah blah blah. Yeah. Southern Belle Ava is good when you need to use it more. Yeah. Hey, Sparky, make a Southern Belle Ava AI cover. Right? That'll be good.
Oh, and somebody here, it's going the right way for the smack bottom.
That too. Tatsumi says, it's for €5. Says, it's bad when my joke has come true. It's so true. The Chewbacca defense is like really happening here. The blonde is a paralegal for, or like, I think she's also the daughter of Owen's daughter. So I think that's Owen's daughter or somebody related to him. Anyways, yeah. It's just once again, the distraction. Don't let them distract you, bros. Don't let them distract you, bros. Yes. Don't get distracted by the Botox, bros. Stay based. Keep it we're not in November, but there'll be no nuts to be had here. Let's see. What is this? Sorry, Locals is fucking savaging them. What is this? The keynote for the Rotary Club dinner? Speaking of simple, Ava is winning out of Legal Mindset, the judge, or Detective Mommy. Ava's winning with 56%. Detective Mommy 22, Judge 15, and Legal Mindset 7. Only 7% of you are sitting for me. Fuck you guys.
May proceed.
I quit
Objections
streaming. It's over. Fuck. How am I getting beat by Mommy?
They got their side.
Ban the chat.
position,
Ban
we
the
got
whole
our side.
chat.
So we're going to talk about that. But, and we're going to talk about justifiable use of deadly force and non-deadly force. But either way, however you rule, it still justifies her behavior. And the result is not good. Now, I don't believe there's anybody.
Proper argument?
Overruled.
Objective approach?
Yes.
Bro, they're really going with the objections here, which is interesting. Nikki P says, sorry, Legal Mindset. I can't say no to smug elf girls. I know it's hard. It's hard to say no. It's hard to say no. Bad News Badger for 20 Danish Krona says, them two birds have distracted me. Hold on. Them two birds have distracted me all trial with their opa and their jiggling bits. Sigrid Eternia says, get belted, lawyer man. You can't ban us all. Watch me try. Anthony says, yay, Legal Mindset quits. Ava, time to take over. Yeah, I'm just gonna like walk out and go. Ava's gonna take over my stream. Change the name to Ava Mindset. Elfelted. Elfed. Elfed. Elfed.
I think
Elfed.
you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a Newton.
I like this one.
That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is George Torres.
Here we go.
The reason for the trauma is George.
It's all his fault. Their whole case. Everything.
From the positive things about the man that we've seen on video to the positive things Sarah Boone has testified about, to the violent monster he becomes. And I mean monster, because it was repeatedly. And what happens the next day? Man, I don't remember.
My God. Oh my, his pausing is going to start getting on my nerves.
I don't remember. That's the gaslighting. That this young woman, vulnerable woman with nobody, just starving for love, starving for attention.
Sarah Boone is 42 years old. She is not young. I repeat,
good.
she is not young.
But every day was on the balance. She measured every day, depending on how it started and then how it ended. And that's the way she had to live her life, day in and day out, day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony, but she spoke about some of the veterans that had been in the war in Iraq, you know, and people in war a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people in wartime or police officers.
This comparison to soldier is disgusting. I fucking hate this. And we all have established this
And a
before,
lot of
but I
them
have to
come
say it
in, the
again.
males come in. with
It's
this
fucked
Shell
up.
shock and battle fatigue.
Yeah.
Yeah,
I'm with you.
and it's an absolutely, yeah, we have. It's absolutely
Talking about the
disgusting.
veterans, that's what they'll do.
She's not a
But you gotta
fucking
spend
veteran.
time
No,
with
and I said that with respect to veterans. This is
just can't be one
disrespectful to
session.
veterans.
And you've got to run post-traumatic stress testing, which tells whether they really have post-traumatic stress. And we all probably have experienced some trauma. All of us have lost some loved ones. And
Oh, this lawyer has no heart. He tried to throw a mistrial
You're in
because
shock.
the mother cried when the video played.
you can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time, right? Time heals, right? These veterans that come back from a deployment, they get back, they get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals.
Objection relevant. I'm getting so agitated. He's still on about it.
Overcoming a divorce, overcoming a death, whatever trauma. Sarah Boone had no break. No break. Learned helplessness.
No break. She
Just
literally had him
giving up.
arrested. She had him arrested.
Giving up. I can't get out of this situation.
She had total control of it.
She go about 2 days. She go about 2 days. Texting and calling. Just learned helplessness. And it's, in the manual. Battered spouse syndrome is not, but what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind, and it's repeating itself. It's repeating itself again and again, day in and day out. And when you look at this law, that's what you have to apply. Someone in Sarah Boone's shoes, when you're deciding whether her conduct was reasonable.
You know what? This guy's reminding me of when Dwight was trying to buy time for Jim and Pam to get back from the hospital. Just talking for talking's sake.
Well, he's got to say something, right?
That was something I wanted to read.
Bro, he's literally can't even remember what he wants to do. How do you trust a person who can't fucking remember to get his shit together? He left his common sense in 1984. God damn.
Is this an? Oh, this is what is this?
Stalling.
Sarah Boone's long-term exposure to abuse created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm. under her state of mind. George Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute suitcase video, is a trauma response.
Did he say
Sarah Boone
he
acted
endured
out
or
of a
she endured?
sense
I could have sworn I
of preservation.
heard
While tragic,
him say there
it
was a
not
he.
driven by malice, but a mind ravaged by abuse. And I'm going to ask you to try to understand. Try to understand. Sarah Boone being emotionally and psychologically broken, whose actions may have been misguided attempts at survival but not murder. Imminent danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence.
Permission
He
to
spent a
ion
lot of
cannon
time.
granted.
Dr. Brandon, you remember him. He was the first
Permission
expert
granted,
on
Orson.
trauma. Took some notes. Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think. He talked about the trauma that you cannot escape from the abuse, so you develop coping skills. to
Banner
protect
updated.
yourself,
Coping and
knowing
seeding in
that
progress.
bad things will happen to me.
Defense currently coping and
changes your
seething.
behavior. Not
Oh,
only
he
your
just
behavior, but your
said
thinking.
coping skills. No.
Your subjective thinking about fear and what to do. And if you remember, Dr. Brandon said it's all about that person's perception. Okay? A lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time.
Yep.
He falls asleep, passes out. You fall asleep, passes.
May.
It may turn
May.
by depending on his mood. I don't know if you could tell. She would try to placate him.
No, we actually can't tell.
Dr. Brandon said, you know, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in the abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at. What a reasonable person would do under their perception of danger. Now, I want to go on. Trauma experts explain how victims' reactions in moments of stress are the product of the damaged psyche. Her actions, although tragic, and it was a tragedy, George Torres lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect. Sarah Boone would argue with
Sebastian Mueller for Danish
talk
Quota
down to
500.
him.
Stage rebuttal. Everything that guy said was bullshit.
Some would say was someone
Facts.
abusive to him.
Facts. Thanks, Sebastian. Appreciate that, brother.
Sarah's not charged with that. Sarah Boone is not charged with that.
That's so true.
And I want to read you something.
I would love my
Oh,
cousin
that's
Vinny rebuttal.
On locals, they say Repton for $1 says the only trauma Sarah has is trauma nuts in her mouth,
Essentially-
and the fact she's not getting out of this. Thanks, Repton.
Okay, I don't know where it's at. But I'm gonna have to come back to it.
Oh my God, no!
What it said was,
He's losing more shit.
essentially what it said was eventually,
Owens, show me what you got.
Oh my God.
in a 2-week trial.
Disqualified.
Trying to get this right. I know it's important. What I wanted to say was someone can be mean and angry and hateful, intoxicated.
He just called
and
a
still be
1-week
abused.
trial, 2-week trial, by the way.
Yeah.
They're not
Noticed that.
mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has committed verbal abuse, it is important to remember that they, Sarah Boone, are the victim and have been pulled into an extremely vicious cycle where they are trying to survive. Sarah Boone intentionally left George Torres in the suitcase. What's the act of a battered spouse syndrome woman? She went up to her room, she fell asleep or passed out. These actions are disconnected. Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do. That's real fear, that's real trauma that she was experiencing at that time. Now, I talked to you about force being used, and I think I talked to you about blocking an attack using a physical restraint like the suitcase to block somebody's attack. And the example I give, I got a couple of examples that may or may not apply. Let's say you're at a bar and you got
LJ
your
O'Rourke.
buddies and the other guys.
What, you gonna
Damn.
block an attack by putting him in a suitcase? What?
Realize that these two are fixing to get in.
The dementia's
One
hitting him
goes
hard right now,
to the
yeah.
other side and grabs the guy before he's able to strike him, right? So you're committing an offense on this guy, but it's a restraint. It's a restraint where you grab him by the neck and try to get him out the bar. So yeah, you're committing an act, but it's designed to.
Can he stop with the emoting? I don't like it. He's making me
Well,
nervous.
let's say you have a situation where you have a police officer and he's on patrol. You know, he's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he goes to a call where there's a suspect that may be armed.
What are you doing?
A suspect that
I'm
may be armed.
kicking my own ass. Do you
So
mind?
he gets there, he gets out of the squad car, he's walking around. Of course, he's taking out his gun because he realizes he may be armed. And eventually he sees the suspect, and the suspect reaches for his waist. Now, in that moment in time, that officer has to make a decision. Am I going home with my family tonight? And I asked Dr. Werner about this Vaseline thing it's called fear response or fight or flight. You know, those decisions are made, it's instinctive based on your set of circumstances. she instinctively reacted.
Whoa, Ko-Fi just said 100% your goal has been reached.
Save her life.
Legal mindset, based
Or save
mindset,
herself from
base chat.
another.
Thank you so much. Thank you.
one
Thank
of
you. Thank
these.
you. Yes, we hit it. We hit
I'm
the
63.
goal. Thank you, Stevis. Thank you. Thank you. Much more bass than old Boomer here.
That? I can't imagine that. Her father's not around. I need to talk about the case a little bit. And if you remember, I'll get back to it.
Welcome, Cypher.
If you'll remember, lost my place here.
I'm waiting for the cane to pull this guy off stage. This is Sigrid for 2. Oh my God. Ask Marlon for 5. Says, Your Honor, I can't find my argument.
Let's start with the witnesses, and then I'll talk about Sarah. But the first witness out of the box for the state, if you remember, was Juan Torres, the brother. Remember that? It was some time ago. I know it's been a while. Y'all taking notes. You may have to go back. Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us. Remember Tony Henderson did the cross-examine of Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me. Mr. Henderson said, did that surprise you? Juan Torres said no. That family knew what was going on.
Can this lawyer follow his client's example and zip this case up? Corthus for 5. Damn, bro.
The police knew what was going on.
Oof.
But he wants to throw a tantrum too. Let me do the
neighbors
two-step.
knew what was going on. Pearl Walker came in here, 80-something years old, in a wheelchair. Kevin Beck called her up. She saw it. Is there any doubt? Is there any doubt? I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Owens. She suffers from battered spouse syndrome. Wouldn't admit it on direct. Well, maybe I don't really know. I hadn't had enough time to really see her. You hadn't seen the pictures? You hadn't seen the 2-minute video? You've seen her one time earlier this month. One time. And she's going to start testifying about stuff she's never said before until she showed up in court? About, well, based on what she told me, I don't think she was in imminent fear? Come on. This is a courtroom. This is a courtroom. Good thing y'all are here. We thank you. But it gets even worse than that. It gets even worse than that here in this courtroom. The state attorney referred to these pictures that I was going to rise up and
Overruled.
show these pictures to you.
Overruled. You may proceed.
That I was gonna rise up and show these pictures to you. Well, yeah.
Like the video. Don't like the defense closing,
They put her
but
on
like
trial
the
for
video.
murder. But what did they say? And I gotta turn to this. Make sure I get this exactly like they said it. 'Cause I took a bunch of notes. Let me make sure I got this quote.
Regina Sharp for 10 says, I figured out the glasses thing. Originally, he just wore them for dramatic effect, but now he actually needs them, so he keeps forgetting to put them back on when he wipes them off. Bro.
Can't even find it, but it was something to the effect.
Oh, no.
Maybe George Torres is the battered spouse. Can you believe it?
Yes. Yes.
Can you believe that?
Yes, we can.
Now you know why we're here. Now you know why we're here. Little boys learn early on that girls are different.
He's going to use a sexist argument?
You do not put your hands on a girl.
What the fuck?
You can't.
What
wrestle
the
with them,
fuck?
You can't punch him. You can't kick him. You can't.
He's
treat
using this
women
fucking
that way.
1920s argument?
Is this actually happening right now? Is
Holy
this actually
shit.
When you
happening?
become adults,
We're
I
doing
don't care
this?
what she does to you. I don't care what she says to you.
What
She gets in your
the
face,
fuck?
Whatever she does, you do not have a right to hit a woman.
He's going to use a misandrous
No,
argument.
sir.
This is ridiculous. We're in 2024. Equal rights, equal less,
Hey,
motherfucker.
if
That's
you
the
as a
law.
husband come home and your wife has killed 2 of your children, has a third with a
What is
knife
the
in them,
state attorney trying to do?
can I hit her then?
Sustained.
What have they
Sustained.
done? What evidence have they tried to put on?
Overruled.
What evidence have they tried to paint Sarah as?
Holy
Whatever.
fuck. Holy shit.
Controlled and manipulated were the words they used.
I cannot believe this.
This man isn't even a boomer. This guy is older than a boomer.
That's like caveman logic. Like, we're going to go there?
This ain't the 1900s. This is 2024.
You're acting like it's the 1900s! You just did the thing! You
It's
just
all
did.
these text messages. Why is that?
Oh, oh my God.
What are they trying to claim?
Oh, God.
She provoked his violence?
Yeah, that's possible, you
She
know?
provoked his violence. Isn't that what they've done here in this trial?
Proper argument.
Sustained.
This guy's in. This is good. You guys are knocking on him good. Objection, new owner. We can in fact believe it's like Naruto. Out of Eloman.
Abraham
Professional
Marino.
Alt 40. I'll Joe for 2. Professional Alt F4.
Remember him?
Kid Loco for 2. No fucking way. Yeah, way. No fucking way.
Abraham Marino changed his statement. They took a statement from Abraham Marino. In which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out, and some neighbors were coming around, and there were 2 or 3 neighbors sitting around. He said Sarah came out and stated it was.
No,
an
he's not lying to the jury. He's
Okay.
just trying to flip the
Well,
like
then-
picture to put it on Sarah as if she's the
Exactly.
victim because she's a woman.
Abraham Marino knew George Torres. and Philip.
It's a fraudulent framing.
Okay, they were friends. They would talk either at the complex or if Marino went to Hall's Ace Hardware or Ace Hardware, what it's called. The state attorney to fives.
Judge, I'm going to object to reading from things that are not in evidence.
Approach.
Man, this fucking Alex Stelmeyer says, guys, get 69, so 669. I see what we did there. Guys, it's the current year. Chaos Smash 64 for 2 said, this guy in a boomer, he's the crypt keeper. Sigrun Eternia said the man was in a coffin. He couldn't throw hands with her even if he wanted to. What is he going to do? Roll over her in a suitcase? Yeah, exactly. What's he going to do? Crush her from inside the suitcase? That's not how it works. It's anime physics. Malthus for 5. It's just laughing the hell out of him. Tech the Blooded said, how bad would it be if some of the Dre started acting like they were falling asleep? They're allowed to do that. They're allowed to not pay attention, to act however they want to act. I mean, they can't snore or be rude, but they can not pay attention. That's true. Utsahia says, are those bagpipes I hear for Owen's career by chance? LJ Rook for 99 says, my nephew has better arguments than this loser. An Oath says, surprised his notes aren't etched in stone. What was that? Bad News Badger said, I heard toddlers speak more coherent than this closing argument. And Tatsumi says, you are taught the discipline to not hurt others from dad, which was what Sarah was now deprived of George's children. Yeah, it's crazy. It's fucking crazy. Let's see. Ava's dead. That's what it is. Ava died. Maltha said, holy shit, just think how much more capable all the lawyers were that she ground through before this. Their ages wouldn't even equate to his. And Eric H said, defense lawyer, I can't think of any good arguments, so I'm going to go with this. If the suitcase doesn't fit, you must acquit. That's almost the Chewbacca defense of this case. Let's see here. Sigrun says, also, she testified she can move a 200-pound dresser. She can probably survive 105 pounds of man in suitcase on top of her for at least a few moments. Exactly. If she can move a 200-pound dresser, she can move a suitcase. Eric H for 5 said, lawyer, I know the facts of the case look kind of bad, but a not guilty here would be really great for my career. So if you could... Troubleshooter said, dear members of the jury, I ask you think outside the box, unlike George. Trish Chan said, I figured out what's happening here. The prosecution predicted his closing so accurately, he has to ad-lib it not to look like an idiot. Exactly. And the second he starts to show those pictures, he's going to look silly. Right? Osan says, and Nasir's copper is of higher quality than the lawyer's closing arguments. Regina Sharp says, ladies and gentlemen of the jury, you need to acquit my client because she indeed is in possession of a vagina. That's the argument. And it's a sexist fucking argument. It's sexist as hell. And we've heard repeatedly how that's not the case anymore. We don't live in that world. Even the medical professionals and the psychological professionals said both men and women can abuse each other. And he's trying to make that fucking argument. It's super improper.
Beck, I'm so sorry. I was laughing so hard I literally cramped up really bad, and I had to get up and walk it off.
Okay. Completely understand. Sebastian Mueller said even Brooks was a better defense lawyer than this, and that says a lot. And Brooks was fucking pro se. CE Chat says, I'm confident. Oh boy. Regina Sharp says, ladies and gentlemen of the jury, you need to acquit my client because she indeed was in possession of vagina. Oh, sorry, I got that one. We have to be considerate that Miss Boone sprained her ankle while beating her boyfriend's corpse with a bat.
So for 4.5 years, Marino says, all I heard Sarah say that afternoon was it was an accident. And then he came in here today, or this week.
And yes, I got destroyed in that poll.
Things got out of hand.
Not guilty, got more votes than I did, CS. Thank you.
4.5 years later, we know he's friends.
Kid Loco, we're on closings. Closings right now.
We heard it here. Now, I want to talk to you about the two boys that live right next door. You remember Vincent Battaglia and Brandon Motes? Remember those guys?
They're not really
Remember,
relevant.
It came out in testimony, you know, this event happened on February 23rd of 2020. But it came out in the testimony that Sarah had said George Torres, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs in my apartment from top to bottom, which is consistent with what they were saying happened, remember? But they got their dates wrong. And remember, Mr. Henderson called Deputy Copsel or Detective Copsel up in our case, and she had to say, yeah, I didn't take their two statements until the 27th, February the 27th, remember? So they're remembering back, and they both had similar stories. Of course, they had time to talk by then, the 27th. I think the only recorded interviews they got that the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone, right? So they came back following up on the 27th. That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound. You remember Sarah testifying, you know? That was the night before. I complained about that, and I think one of them had testified. Yes, she had said something about being drugged down the night before. It may have been, can't remember now who it was, one of them. And, you know, it looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think we didn't hear anything more of that. Remember? And then this photograph, which we introduced, which shows the bottom of the stairs, as you can see, there's Lucas's bookshelf right here. This is where Sarah Boone stored Lucas's stuff. And you can see it's not disturbed at all. Anyway, I want to get back to Sarah. I want to talk a little bit about that, but let me talk a little bit about the law on justifiable use of force. Is legal and lawful if you reasonably believe, I think we all probably already understand it by now, you reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations. By acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. If you're facing, in your mind, a reasonable, imminent threat, you don't have to wait. Let's talk about Sarah Boone and this unconventional form of physical restraint to block the attack of George Torres. What did she say? Salt tape. Now, you got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking. And you got to think about the fact that it was all fun and games for a while. And I think the biggest thing to know is that George Torres chose to get in the suitcase. He's a grown man. That was his choice. She didn't force him in at gunpoint to get into that suitcase. He voluntarily got into that suitcase because they were drunk and being silly and stupid and playing hide and seek. Which I guess when
You could flip the argument and just be like, he's drunk. He can't consent. He
It's
doesn't
just
know
a
what he's
silly little game.
zipped him up. They're laughing, carrying on. And as you know, Sarah likes to videotape a lot.
Yeah, she likes to videotape for fucking blackmail.
But I think the evidence shows that when George is being
Sorry,
videotaped,
the fucking name Lich just makes me laugh.
when George is being
Get on with it, you
videotaped,
sorry excuse
that's
for a
like her
lich.
power. You know, Dr. Harper said that Sarah's words are her power.
Yes, he's
Sarah's
condescending.
words are her power. Physically, she's no match for George. Physically, she's no match. But that's her power, is her words. When she gets a chance, to have some control, that's what she does. And she videotapes because she knows when she's videotaping, she can tell it like it is. I can tell him what I want to tell him. A couple of these videos, she's telling him like it is. But she's got that video camera on, and George knows he's being videoed. We've got one that we will show you in a little bit, where he loses it just a little bit, right at the end. And of course, we got the TV.
Yeah.
But they're kidding around, playing around.
He's talking down to them.
Sarah realizes, okay, this is my chance to say something to him. So she sits down, she turns on the phone, and you've seen the tape. You've seen the tape.
Yeah, play it again.
For everything you've done to me, are the first words out of Sarah's mouth when the video begins. There's a lot packed into those words. Think about that. For everything you've done to me. This is how it feels when you choke me. Now that's in direct response and the result of the abuse that she has suffered at the hands of George Thorne.
Yep.
She wants him.
The video is so bad, he can't even show it. He has to read it. That's how you know it's bad.
To feel, for him to feel how she feels.
This isn't about feeling, it's about fucking dying.
Lack of control that she feels when George is violent with her.
Piece of shit.
Just for a moment, she won't be able to feel it. If you can imagine.
No, we can't.
Approach.
Yeah, you can't put them in the foot of the victim or the person. That's called the golden
I
rule.
think from the evidence, you can determine she was crazy. She was crazy.
No, we cannot. She was not the one crazy about him.
You know, of course, it's a syndrome.
She was just crazy.
She felt like she couldn't do without it.
Read the text messages, you'll see.
And
it's clear.
Let's say she videotapes it, and then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9, but I think if you count 2 of the others, it's not. But there's 9 minutes that we don't have video. But what did Sarah say? Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe.
2 bodies, 1 soul.
If you're talking, you can breathe. That doesn't mean you have air. You can run out of air.
That it's going to end the way it ends.
But here's my twin flame. He's breathing through me.
It's a canvas. All she knows is an old canvas suitcase that she's got some, the 2 zippers removed or spread out a little bit so he can. So she thinks he's not being serious.
It's fucking closed because she closed it.
She gets angry. He gets angry. He says words to her, and then his hand starts to come out of the suitcase. She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend.
Through
girlfriend.
the fabric, not the zipper. Out of
You know
the
what I'm talking about.
suitcase.
We've got a way of talking.
He's
to
an
people.
extra dimensional
We've
demon.
got a way, your wife, your husband, you know each other. You know when they come in from work, what kind of mood they're in. Just by a couple of things, the way you just sense it, right? Well, especially somebody as hypervigilant as Sarah and as hypervigilant as a battered spouse woman would realize that he can flip the switch at any time.
You mean she can flip
When
the
I
switch
get out of
at
here,
any
I'm going
time?
to end you. And he realizes he's getting out. He got his hand out. At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in, remember? She tried to get his hand to go back in. Wouldn't go back in, so her son's back was 3 feet away. Where the police found it the next morning. Same spot. No one
Remember?
attempts to
Remember?
hide.
Please remember. Please remember.
No
I
attempts
need
to leave
this
home.
for you to remember.
No attempts to
Memory buffering. My memory is
nothing.
buffering. Help.
And
But
the
it's
same
also
spot
like,
it was. She picks up the bag,
you know, she could have used it to beat him, right? You
Pokes him
know,
hard.
not just poke.
trying to get him
It's a beat.
to stop trying to get out. And eventually he does. And you've seen the blunt force injuries. And you saw some
Which
of
means it wasn't a
injuries,
fucking poke.
And you can tell there's a poking. I think it's right around here.
Yeah,
And she
Jolie
poked him
King,
several
defense
times.
could be trying to make a
The
mistrial.
pathologist
It's
said, I
true.
think,
They sometimes do
maybe
do
5,
that.
6, or 7 times. She pokes him. And he's got some scratches. I don't know if they'll let you look at it, but
Lonia Bong says, when you have lawyers like this, I think of the jury from Michael Jackson case that he's not
suitcase
guilty
has got
because
some bars.
I didn't like how he pointed at me.
inside the lining. And it's for support.
Mouth is for two. Lawyer, please remember, because I don't. That's funny.
She testified. You heard what she said.
Troubleshooter
She
for
is
two was
justified.
like, insert
That's
small violin
uncontroversial.
noises for this poor woman.
One of those pauses when he raises, he breathes in. I love it. He's like, what were we talking
The
about?
jury instructions just for a minute. I want to talk about reasonable doubt for a minute.
That's court TV.
If we find it. If y'all are all looking. I think it's on page 15 of 22. And we're going to talk about reasonable doubt in a minute, but if you look at those bottom 3 short paragraphs, it is the evidence introduced in this trial.
I think he's already gone longer than the prosecutor, and he hasn't passed the baton yet.
Reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or lack of evidence. But here's the main thing. And, you know, obviously, I represent her.
No shit.
And I'm trying my best to show you honestly and fairly. the
Yeah,
doubt
he's
in
up to
this
55 minutes.
case. And
Is he?
5 reasonable doubts, 17 reasonable doubts, 25 reasonable doubts. You have to have 1 reasonable doubt. I'm trying to show you throughout the evidence that each one of you can have a different reasonable doubt. Difference, but 1 reasonable doubt about the state's case, and your verdict is not guilty, according to law. Proof beyond a reasonable doubt does not mean proof beyond all
But
doubt.
wasn't he not supposed to read
Reasonable doubt
this?
is not a mere possible doubt,
Or did he
speculative
edit it?
doubt,
I think he
or
edited it.
imaginary or forced doubt. Such a doubt must not influence you
He edited it. Yeah.
to return a verdict of not guilty if you have an abiding conviction of guilt. And this is a deeply held belief. You know, reasonable doubt is the highest
I almost
standard
just shit myself as well, but I think you're right. He edited it.
car wreck or something like that is preponderance of the evidence standard.
Find the
Hey,
able to
everybody.
make LTB. I'll put your
Abiding
link
conviction.
below.
That's a deeply held belief that you must have if you're thinking about something. That's a firm belief. That's a level of certainty that you would have. That's what you got to have as a juror. I've got to be certain of her guilt. If on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do, there is not an abiding conviction of guilt. So I'm not certain. I'm not certain of a guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable. You understand that? You've got to be certain of guilt. That's the high standard we recognize. If you've got some evidence of guilt, so okay, there's some evidence for conviction, but it's not it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt. And you've got the power and authority and the obligation under the law. If that's the way you
Yeah,
see it,
do you understand that is not a good look.
I agree.
later in the instruction it goes on, it's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jury to decide that. The jury may believe or disbelieve any or all the part of the evidence or the testimony of any witness. I want to show you this before I forget it. But Dr. Werner said, this is their expert again. He testified that Sarah Boone suffers from battered style syndrome. Battered women's experiences affect her perception of imminent danger. Those past experiences with George Torres, and there's a bunch, affect their perception. Remember Dr. Brandon, Michael Brandon talked about perception of imminent danger. Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from George, was because of George Torres. George Torres is responsible for her mental state because of the way he has violently treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase? She knows. The second video is played. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her. She used the bat to get him to stop trying to get out of it. Why would she do that?
Because she's a crazy bitch.
Why would she do that? I know what he's going to do.
Welcome, Triforce A7X as a member. Appreciate you.
I know him like I know more. I know him more than he knows himself. I know what he's going to do to me. You don't have to wait. That was justifiable.
She does excel at everything. She must be able to know more than someone knows about themselves. Jesus.
She intentionally used the bat to defend herself. She intentionally didn't unzip him to defend herself. Both of those are lawful under our law.
I can't with this woman.
She went upstairs. The dogs were upstairs. At some point, she called her husband, her ex-husband, Ryan Boone. We know that many times she testified, or somebody in court said she would often flee to her ex-husband's house sometimes. I believe that testimony came out from either Sarah or somebody.
We're going to read the divorce court letter while we're waiting for the
Sometimes
verdict
She would flee to upstairs.
with Sarah Boone's divorce court letter.
One of those two. But the dogs were up there. She made a phone call. At some point, she fell asleep, passed out, fell asleep. We don't know. They had 2 big bottles of wine, right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? You remember that?
3 unintentionals, guys. Someone has to take 3 shots.
I don't know if we did a good job of this, but
I've only got water right now.
it came out that she got arrested. You remember
Those
the-
wine bottles are empty.
She got arrested for strangulation.
Sarah drank them all.
Remember that? It was, they ended up over there by the dryer.
I know LDB has some alcohol. Yeah,
I know, I'm looking. I'm like, what do I have?
I heard a bottle clink. I'm like, yeah.
And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her. And that's when he got up and stomped her.
3 shots of water
Yeah.
works. Hydrate yourself.
Remember? Well, the police came for that
Or get
event,
some coffee. What the hell? Was
and
it
they
like
took
this
them-
all
Sarah-
day?
Sarah was honest with the officers about and they arrested her.
Yeah.
You remember?
Oh my god, my choice of a nap was way
they
better. What the
arrested
fuck?
And she said, why? I was fighting back.
The prosecution was good.
I will say,
Remember that?
prosecution's closing
Why?
was
I was fighting back.
precise. I think it was a little less than an hour.
I'll
from
I'll
that point
flip
on,
back
she didn't trust
when this
law
is
enforcement.
over.
The video that they
Nikki
showed
P
while
says
ago,
this drinking game is going to kill me.
about
No suitcase needed.
George, that was about dropping the case, where she was defending herself.
Want to bet the
And fighting
reacted
back.
word is expert, says Bad News Badger. True. It's probably
Literally
true.
not admitted.
Nobody
Literally
was
did not
qualified.
admit the expert. So must scratch out.
I want to talk about this investigation.
Chris Cannon for 5 said she fled to the ex-husband, but I don't think it was for protection.
She didn't know the law. She's not a lawyer. She gets up the next morning. Brian's calling. Sarah's got to pick up Lucas at 3. Brian's calling. Eventually she walks down. She's looking for George. Where's George? He's quiet down there.
Because he's
She looks in the
dead.
bathroom,
You know
she
why
looks
he's
out,
pausing so
smokes
much? Because your
cigarettes,
brain has to work harder when you're lying.
and
The save scumming didn't work yesterday. He's just like, which checkpoint are we at? Hold on.
she sees him in a suitcase. She panics. What does she do? What does she do? She tries to get her fiance out of the suitcase. They're engaged to be married. She's not trying to kill him. They're engaged to be married. She gets him out. She tries to do, he's purple. She tries her best to do CPR. She doesn't, you heard her, I didn't know what to do. I didn't know, call Brian. That's her safety valve. That's all she's got. Brian eventually says,
Yes,
come on.
save
we-
file
she called again in 2
corrupted.
minutes.
What did
By
I
the way,
say? Jury, do you know what I
She
said?
said call 911. Man told her before, call 911. She calls 911. She tries to do CPR again. Is she busy trying to hide evidence? She busy trying to hide evidence? She busy trying to hide the back? No, she's trying to save his life.
She didn't even want to do CPR.
Yeah.
She was fighting the dispatch because she didn't want to do CPR.
So the police get there. She knows if she told them, she fought back, she's going to be arrested. That's
I
what
don't think she
happened.
did CPR. There would have been broken bones if she had done it right.
happened
There would have
before,
been
George is
bruising
sitting
on
there.
that
She'd never been
chest if
arrested
it had been done right.
Before that time, she was charged with that with George.
Fought back, meaning kept him in the suitcase that he was already locked into. So that's fighting back.
She lies. She lies. She's scared.
She lies a lot.
She's scared.
All the
She doesn't know
time.
what to do.
On the
She
stand.
lies. She makes a decision to lie. Don't trust law
She
enforcement.
said she lies.
She doesn't know the law. She doesn't call a lawyer.
Why she always lying?
Talk to.
She doesn't call a lawyer because her best friends are the cops.
Right, right.
She was calling the police for therapy.
She was calling
Wait,
the
wait, wait.
police constantly, but not for the one time when somebody is dead in the suitcase.
She lied. And then the
It's
detectives
just the one
eventually
time
get
she
there,
didn't
and
have
they're
her
in
pink
SWAT
shorts
car,
at the
and
ready.
audio. I think it was played.
Do you have pink
She lies
shorts?
again, then the
Not
next day,
on me.
She goes down to the
Okay.
sheriff's department. Now, if they would have told her, hey, man, we're gonna arrest you, and she gets a lawyer to go down there to make a statement, and the lawyer would advise her.
Objection. Facts on evidence.
Sustained.
Move to strike.
Stricken. The jury will pay no mention or give any weight to that statement.
She's not a lawyer.
Get fucked, Boomer.
She didn't have a lawyer present when she made this statement. She didn't know the law.
I haven't seen someone objected to in their closing this much in a while.
And they've been sustained multiple times.
In this dysfunctional, toxic, abusive relationship.
Toast Burner says, defense right now. Are you sure? Really sure? Robin the Hood says, do you understand that, retards?
I don't know if you remember, it was a 2-hour video, but there was some.
LM just dropped more and more rank in the simp scale.
She
Yeah, when you
said,
joined.
You know, it was not intentional. And
I'm going to get no votes.
She wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What she was talking about was that George passed, was that George died. That was not intentional.
JP
All right,
Ravenfire.
guys, that's the fourth shot to whoever had intentional in the closing. Oh, that's 5.
Would he sober up?
Do we not have a counter?
We've learned from their history.
No, I don't.
When Sarah gets drunk, she calls for help. When George gets
JP's
drunk,
right. Ignorance
he
of law is
beats
no
Sarah.
excuse.
That's their pattern.
Just because she didn't know that what she did was illegal doesn't make it less illegal.
That's their pattern. Sarah,
Ignorantia juris non exist. I forget the last word, how to pronounce
I
it.
think she said, I didn't know something like this could happen. I've never done it before. And Detective Lowen said, well, what did you expect that was going to happen? I've got a daughter that she's about 18 or 19, and she got a grandmother's hand-me-down pickup truck. It was an older truck, but she didn't have it long, and she was gassing it up, but she didn't put any oil in it. Eventually, it burnt them up.
Anthony says, I'll give you a pity simp vote.
You don't know what you don't know.
Fuck you, Anthony, but
I hadn't done a good
thank
job
you. Thank you.
of explaining, hey, you got to put oil in it too. Sarah Boone didn't know that he could die in there. It's an old beat up canvas suitcase that she left a gap in. And as naive as that sounds, she didn't appreciate the danger. I mean, is that the way you want to kill somebody? Is that the way you're going to do it? She had Lucas to take care of it. Am I going to go to prison doing it like this? No attempt to hide the crime. I think the evidence is clear. That's how this happened. I don't want to belabor the point. I do want to show you. Just quickly show you the ending.
He doesn't want to belabor the point, but trust me, he's going to belabor the point.
Think about that.
Well, he has to play it down because they've already showed the pictures. The prosecution literally pulled his pants down
And she stayed with him.
by preempting this, which was brilliant.
Stayed with him. Poked
Brain fried, welcome as a member.
between the
Appreciate you.
eyes with a curtain rod. Stalked in the eye.
Yeah, prosecution definitely did how to do an effective closing 101.
It was a weird black guy. But once again, whether or not it's fake or not is irrelevant to the fact that it doesn't none of it justifies what she did.
The law empowers
That's a
an
black eye,
individual
like
to
if you
defend their
fell
life and safety
onto
when
like a
faced with
wine
threat.
bottle because it's not like around the cheek area.
That's what Sarah
Right.
Boone did.
That's not a black eye if you get punched in the face.
Right.
That's what Sarah Boone did.
A budget Amber Heard black eye. She didn't have makeup, guys.
Oh no.
That's a legit hit.
Like Malthus for 2 Canadian. I double dog dare you not to find her guilty. I triple dog dare you. He likes the double dog. Hound of a Loman, to sum up, Your Honor, I would like to plead sexism to murder charges.
He's a man. He should be able to take it.
Yeah.
Understand.
Man up and break out of that suitcase.
Sarah had
Let's
to be
see.
a parent a lot of times. It was her place.
But I'm so scared.
She had
Scared for my life.
$1,000 a month from the divorce settlement coming in. She had the car. She had the phone. She had the keys. She had to be the parent in a lot of ways.
Chat.
In
But
Korea,
wait,
I'm
there's
guessing
more.
it's probably around 4, maybe 5 in the morning.
It's 6:58 in Korea. I've been up all night, but I also slept during the day.
I
So
want to talk a little bit about Dr. Harper. Do you remember?
I have a little bit more sleep today. I had 6 hours instead of 4.
Up in the Panhandle, close to where you were from. And she's the doctor that treated Sarah from early on. Remember, this happened in 2020. I think she first treated or first saw Sarah Boone shortly thereafter. And over the 4.5 years, saw her 9 times and did all the testing for post-traumatic stress. Of course, she has the experience from the veterans, and she's testified that she's now just traveling around the state, testifying as a forensic psychologist.
Yes, this is sympathy baiting. They have to make her appear as human as possible.
You know, she talked about how important it was to develop trust with the patient over a course of time. It's just going to take time when you have somebody suffering that kind of trauma and that kind of damaged psyche. It's going to take some time to get them where they can trust you and really tell you and talk to you and tell you what's going on with you. You know, she talked about, you know, that Sarah uses her words for power. I think her testimony, I don't think, but I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony was
Objection
credible.
is sustained.
I can't give my personal.
Sustained. Yep.
The evidence supports that her testimony was credible because of the time that she spent, because of the number of tests that she did. That she diagnosed her with post-traumatic stress disorder, alcohol use disorder, I think anxiety disorder, and battered spouse syndrome. Dr. Warner confirmed that And, you know, Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert. So he hadn't treated Sarah. He was just testifying about the condition. He's been doing it a long time. He's an expert at it. And that's to advise you to try to understand what's going on. And as crazy as it sounds, in this syndrome, they try to protect the abuser. They're in love with them. They try to protect them. I don't know if you remember that there was a time where Sarah Boone had a conversation with one of the neighbors, and they were talking about something. And she said, "Did you hear anything yet last night?" Remember, she said, "Shh, it's okay." Both George and Sarah lied to the police. They lied to medical people. I don't know if it's shame, but it just comes with the syndrome that you stay trapped in it. I think another big, if you'll think about this, when Sarah gets beaten by George, she calls the police. When Sarah gets beaten by George, she calls the police. And a lot of times she just wants him out. Just get him out. Get him to leave. She doesn't want him to get in trouble. She just wants him out. There never was a report of George calling the police on Sarah. She wasn't physically abusing him.
That's men almost never call for multiple reasons, but also remember George was getting
Sustained.
police called when he was asleep.
Members of the jury will pay no attention to that comment. Give it no weight whatsoever.
I believe the evidence that's been presented by the state is an attempt to show that Sarah.
Sparky for two says, get to the point. He's dragging right here. He is dragging.
Again, she's not charged with that.
Ryden says, you should use the Tim. Are you sure about that meme?
Some of that was her trauma. In Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some, you know. But the homicide detectives, I know if you saw that 2-hour video, at some point during the 2-hour video, they started talking about some of the violence. And they go, we know. They had already checked with neighbors or whoever. They knew. The neighbors knew. Police officers knew who responded. Torres' family knew. They all knew about the abuse. Dr. Harper testified that abused women act differently when they perceive a threat. I think Sarah Boone was loyal to a fault to George.
He's going beyond that, Saber. We'll talk about that. I don't think he's just doing his job. He's going a little bit beyond, but we'll get into that.
Judge, I want to make a comment about a couple of things that were said by the prosecutor in opening statement.
You may proceed.
Okay. The prosecutor in opening statement, when he was talking about George Torres passing away, he started talking about Sarah Boone. And his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torres deserved it.
It's true. Look at the text messages.
George Torres deserved it. That's the position they're taking.
In Sarah's mind, yeah, true.
He deserved to die. She loved the man. She wasn't trying to kill him. He also commented about.
Yes.
Oh man, this is getting fun crazy. Malthus said real quick in the poll, if Legal Mindset wants more votes, he could bring Rima back on. Oof. Anthony says Ava as an elf is more human than this lady. That's fucked up. Christopher Candler said she probably called Brian first to pin the murder on him. He saw the body. No, I legitimately think. Yeah, you're nodding at the beat.
I agree.
I think she wanted to hide the body.
Or she wanted him to be more involved than he was to have somebody else to put blame on.
And that's why he knew to walk the fuck out. He was smart for that.
Mm-hmm.
And he did walk the fuck out. Tatsumi says, I can't imagine the meme of the laughing wolves in chat voting for everyone except for Legal Mindset and Ava with the most votes and laughing at Legal Mindset with no votes. Bro, fucked. That's so fucked. Captain Fire says, not to be an advocate for this, but how else is a defense attorney supposed to defend a client like Sherpa? There's a way. I mean, look, even in the Chandler Halderson case, they got up and did reasonable doubt. You can argue a fuck ton about reasonable doubt. You can also argue, I mean, if she's going to argue this, like I said, you can argue it, but you don't need to go there with the, like, did he need to, for example, right, Captain Spire, did he need to make them, the girls can't be guilty of anything and girls can't hit boys sort of argument? That's completely unnecessary. Yeah, you're laughing. That's completely unnecessary to prove self-defense. Self-defense is true.
Did he need to go into veterans about it in his argument earlier too?
Yeah, and you know, literally, what did that do? Every single veteran here, every single veteran made a comment about that in the chat, right? Right, Kiet Nguyen for 5, who said, as a veteran who's in Iraq, I'm getting PTS just listening to this closing argument. And Nikki P for 5 says, it sickens me they're trying to equate her with what me and my brothers and sisters had to deal with. And for veterans, you know, and look, I'm not a veteran, but a lot of my friends are veterans. A lot of my friends in Korea here are currently serving at the base here in Pyeongtaek. It's fucking disgusting. Like, Sarah did not sacrifice anything, right? The only trauma she's had is all self-inflicted. She sits around collecting money from child support and alimony that she gets from Brian and doesn't do jack shit. So, you know, sorry, that's not equivalent to war, right? And getting drunk all day. I'm sorry. No, not giving her points for that. Drisbin for 5 says, funny argument by the defense. Who is positive and who is abusive on the video? All the video I've seen, all the video we've seen, all of it. We've never seen George legitimately angry in any of the videos. And the only one was him baseball batting the TV, but we didn't get the complete context of that and why he was doing that, right? I think it might be because she asked him to take it out and he asked her to help and she wouldn't. So he just started baseball batting it. I don't know, whatever it was. But the fucking guy was winded after one swing of the baseball bat because he's 100 fucking
You know what
pounds.
I think the TV already broke and they made a fun video together because he said, you're going to help me take it out. And then he started wailing on it. Like you said, like an emaciated Nigerian child. Like he
couldn't
strong.
wail on it. The dude like lost like no air. His lungs were not functioning.
He did one strike and he's like like panting for air. I'm like, bro, you like whenever I think I'm in bad shape. Yeah, no, it was bad. It was bad. Fulpa X for 5 British pounds says, when he is forced into an early retirement, people will ask him, remember? Dude, if any of you are taking shots every time this motherfucker says remember, you're more drunk than Sarah Boone after 3 fucking liters of Woodbridge. LJ O'Rourke says for 989 says, what are the odds that the prosecution will finish closing arguments in record time? I don't know about the prosecution. To be honest, I think they should keep it short when they come back because they've already heard enough. But like, they do need to kind of rebut a lot of the bullshit that he's bringing up here and just like, defense said this is a lie. Defense said this is a lie. They do need to rebut some of this. Malta says even George was better defended in that suitcase. Brain Fried says, damn, if it ain't the strangest thing I've seen all day, a fossilized lawyer with his head up his own client's ass. Well, and once again, zealous advocacy you have to do, but you don't have to be fucking extreme about it.
The prosecutor said in opening about the violence, the violent episodes. It's a bunch of violent nonsense, was his statement to you in opening statement. All this here, the photographs, is a bunch of violent nonsense. You'll have to make your mind up whether that's that. there were a couple of exhibits.
This guy needs some serious
that I
member
introduced
berries.
late, and they were no contact provisions, where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for George Torres not to have any contact with Sarah Boone. Okay? Court system got involved. They're to have no contact with George Torres. Now, I need to talk a little bit about that. And they talked about coercion, coercive control, power and control, power and control.
By the way, to those who are
know
wondering,
about
it's past 6 o'clock over there.
You
It's
know,
because the
you store
judge
the
mentioned
home
that
that
they're
you
willing to
need.
stay to
You know
9
about
o'clock
his
and even
jealousy.
after if necessary.
Well, thank God I took a nap.
Some of the things he said to her. You know about how he treated her dogs nicely when he was sober, but at times abused the dogs or threatened to do so. If you think about power and control, when you're controlling a person, and I think she testified.
How
that
much
it kind of
screaming did Sarah like? How much screaming do you think Sarah did to her lawyer for him to have to sit here and like blow up so much smoke?
part of his fear.
Well, remember, he's the 9th lawyer. The 9th lawyer.
She'd had enough.
You need to tell the whole world what a perfect human being I am.
JP for
She'd
2.
get the strength
You
over
remember?
time.
I remember. Pepperidge Farm members.
If she had enough time away from him, where she wasn't in control of it, and he wasn't in control of it. Enough time away, she would come to her senses and realize she could do better. Judge has been giving court orders all week.
Yeah, no, he's dragging. He's trying to force this to resume on Monday. I don't think it's going to work.
Knew he was going to lose control.
I think they are trying to
She
delay.
had a bunch of time away from him. She might move on. He was willing to violate a court order to maintain control. That's George Torres. I want to show a couple of videos. And I want to say something to you. Shelby Andrews is going to help me. If we could dim the light. Yes.
He's fucking stalling. Guys, 26 more likes and Ava has to do a big iron cover. 26 more. We can do it. We got the power.
Jeez, that flew by. I was not expecting that quick.
Mechanicus Golden Gear for 2 says, I just want to know what she has on him. No, it's just he wants clout.
She told him that the 10th lawyer was already dead.
Do you understand? As of this moment, and until I can get you
We hit the
out,
goal.
get the fuck out of here. You're a room. I dare you.
Did you see him?
Yep, look at him. Wait, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
This is incomplete. And the jury viewed the whole thing. So they know that the defense is being dishonest here. She had a camera in his face the entire time.
We lost it, even though the video was going.
This is the most disingenuous argument.
Maybe pushed her. Because she had a fucking camera in his face. What type of strategic? Look at him.
You can hear him breathing.
He is exhausted. Those 3 shots took everything. And that took a little more.
Thank you, Judge. You turn it off. Can you turn it on? Ladies and gentlemen, I'm going to finish up right here.
Oh, wow.
And,
Really? Really? Finally. Fuck.
Sarah Boone, I've gotten to know.
Yeah, because you know what? I bet that last sidebar was like, you need to freaking wrap this up.
Sarah Boone is like any other citizen. Equal justice under the law. She's to be treated like any other citizen.
And thrown in fucking jail for committing a crime.
Fairly and impartially. Based on the circumstances she was facing at the time of this tragedy. Based on the battered spouse instruction, which is a special instruction that's given when women have a heightened sense of fear.
Not women, spouses, you fucking boomer.
That you're to utilize in applying her subjective standard to the reasonable standard. Of what a
This guy is
reasonable
so
person would do
sexist.
under her
I mean, like,
circumstances.
it's
And using the
1920
force that she
sexist.
used to defend herself. I hope I hadn't missed anything. I tried my best.
It's
Yeah,
good
we
enough.
know. We know you've thrown out the kitchen sink.
Sarah Boone fought back and survived.
She
With the
fought
baby.
back and
We
survived.
ask that you do justice. in
Do you know
this
what's
case.
funny? That was like a Lane's
not guilty
thing,
because
right?
the
I'm
doubt
really
is
trying
reasonable.
here, Your Honor.
Yeah.
Show
Trying,
you
I'm
where the doubt
trying.
was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you. We appreciate your service and your obligation to do your duty. You have the power and authority to right this wrong. That's what we're asking you to do. And give Sarah Boone some hope for a better life and freedom. Thank you.
Thank you, sir. Any rebuttal?
Yes, sir.
You may proceed.
Oh shit, here we go. Hold on, I'm gonna pause it and read some of these comments, but because we'll get into it because we're gonna have a pause here. So let me make sure I get everybody. Kid Loco said, "Damn, it is disgusting." That comparative, yes. That was comparing it to veterans. That was disgusting. Bologna Bong says, "Brain with no ridges or bumps, no valleys or lumps." Smooth brained indeed. Tatsumi said, "The lawyers brushing off trauma like it is a matter of time really pisses me off. And it's an insult to the field of psychology for 5," says Tatsumi. Yeah, I agree. And saying, well, like it's only a matter of having time apart. Well, no, that's not exactly how trauma works. That's how you're framing it. And no expert said that. LJ Rourke says he really is just pissing people off. I wonder if the jury's in the same boat. I imagine that there's been things he's pissed them off about, particularly making them leave all the time to deal with his bullshit. Floppa X says his argument so far, Your Honor, the chicken has 2 legs and therefore that man is a chicken. Logical fallacy much? Shadow Imagery said, objection, death doesn't heal, points angrily.
Phoenix down. Phoenix down was in that wine bottle.
Critical Splat for 5 said, what can a judge do to keep him from dragging out without risking appeal? They can give him time limits. So it's not common, but they can say you have 2 hours on your side and you have 2 hours, including rebuttal. So you have to divide that the way you want. And I'm going to call you at 2 hours. Now they got to be careful with that. It's got to be a pretty generous amount, but they got to make sure that it's equal. Popa X says this man was gifted with ±0 charisma during his spawning. Mechanicus Golden Gear said that none of what he's saying makes sense for suffocating someone in a box. Correct. Once again, what are you defending yourself against? They're in a fucking suitcase. Regina Sharp says, I swear if he starts randomly reading the Gettysburg Address, I'm going to start putting mumble gumble bumble in a suitcase. Frostbit for 5 said, ladies and gentlemen of the jury, pay no mind that my client bludgeoned someone like a seal and locked him in a suitcase. It was a good day. It was a good day. They had puzzles. Malthus says he couldn't get out of the case and neither could she. Brain Fried said, fun fact, only in DC, Indiana, I think Mississippi, and South Dakota banned trial on TV. Interesting fun fact. I know why DC does. They don't want the politicians' trials on TV. That's for sure. Brian Hunt says can do better by destroying his birth certificate. That was fucking crazy. The fact that she tore his birth certificate and then took a photo of it. Right? Sparky's text quarter said, Ava.
I couldn't believe that. Yeah, look at that. And then his only response is, that's so childish. I would be absolutely livid.
And he took it like a champ. He didn't even get mad. JP Ravenfire said, George wasn't even angry when hitting the TV. No, he was just winded. Sparky said, Ava, I've separated the audio files for Big Iron for making the Legal Mindset cover. I'll send them to you now. Natasha, for 5, says, hold up. Did what he just say make an appellate issue?
All right. I'm dedicated now. It'll be happening.
It's happening. We're over. We're at 1,030, maybe more. We're at 1,036 likes. So thank you guys for liking the video, getting over 1,000. Appreciate that so much. Natasha said, hold up. Did you just say he wanted to make an appellate issue for trying his best? Maybe, right? Maybe, but there's more than that. Ineffective assistance of counsel, and the other lawyers on the panel can speak to this. It's very difficult to win that.
Yeah.
I rarely.
I mean, they usually don't throw a case on purpose.
And like
to create an issue.
I don't know about in New York where you practice, but like in Florida, you would pretty much to be like really fucked up, like high or drunk, and even then, you might still be allowed. Like
in Florida, I believe that.
Yeah, like New York. I mean, I don't know. Christopher Candler said even the closed caption is trolling her. It said she called the sheriff and she was blowing him. Wait, what? That's hilarious. LJ O'Rourke says throw out the kitchen sink. He stripped the house of copper. And Sigrun said, this is really boring. Legal question. Could you self-defense the Black Knight from the Holy Grail, even though all of his limbs were gone, but he was still threatening to bite your knees off? I mean, yeah, he's got that helmet. You know, he might charge you with his stumps. You know, you got fear of the stumps. Oh, that's a good one. All right, let's continue here. Now we got the rebuttal. Now the prosecution gets to respond to all that bullshit. Caleb for 5 says, if I stall a little longer, they'll get amnesia. They're going to have to forget all the facts because, damn, it's not looking good. I would just play the suitcase video again. Just play the fucking suitcase video again. Oh, that was a loud drop.
It was on purpose to wake up the jury.
Ladies and gentlemen.
Oh.
George Torres.
Yeah,
is
he
dead.
put it out. Yeah, he put it out too.
Believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her, when he choked her, and to hold him there as a captive audience, according to her testimony. Now he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means viewing pornography. Well, we saw cheating really means women. And the heated conversation on June 14th about these women in Facebook. And that is what leads to the arrest on June 15th. He's out whoring, Candy Crush, all the bizarre things that you see in her phone. She uses the legal system as a weapon at times. There's no denying that they are engaging in violent behavior, and it is over nonsense. It is smashing TVs. They call the police, and then they're standing there looking bewildered about what to do and who to say, and laughing and joking. Ladies and gentlemen, the courtroom is the place for justice, not a suitcase. The reason we have a jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim. So it developed into a system where citizens would have to say, yes, you can take our fellow citizen. But the opposite is also true.
The prosecution is good.
A citizen cannot take another citizen's life because he or she feels like it. That likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence and caution. Like Mr. Cacciatore argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still laws in place about when and how this can be done in a justifiable manner. I want to talk about the most important jury instruction in this case that has not been discussed very well.
This man is preaching.
However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And we'll stop at that comment. The facts of the case that came from her own mouth, if she is to be believed, and we will explore thoroughly why you should disregard every bit of her testimony, from court to the detectives, to the 911 operator, to the doctors. Her testimony, if it is to be believed, the most favorable light that she has presented of herself, is that at the end of a Sunday fun day, where we are drinking, we're outside by the dartboard, we're doing puzzles, we're doing arts and crafts, and there finally comes a point in time where we're gonna play hide and seek. And he says, tag, you're it. Even though she's it, she goes upstairs, hides in the shower, eventually gets tired of being there, it's cold, so on and so forth, and she comes back downstairs. And as she comes back downstairs, she can see Mr. Torres fiddling to place himself inside the suitcase to try and hide for this game. And the lid is not closed and it's flapping. And out of jest, out of levity, undisputed according to her testimony, she comes over there and zips it shut. Whether it's 100% or enough for 2 fingers to get out, that is something that you decide as the jury. But there came a point in time where the fun and games was over. And Mr. Torres told her that. Babe, I can't breathe. Sarah, babe, let me out. This is all on video. We don't have to imagine this. This is all on video. 1062. At that point in time, she is using force against him that is not justified. She is the initial provocateur. She is the aggressor under the law. And what level of force is it? I can't breathe. Not let go of my hand, not get your hands off me. I can't breathe. This is no different than 2 people, maybe they're buddies at the bar, similar to an example that was given by Mr. Owen, who are wrestling, and one has another one in a headlock. And there comes a point in time where the person on the
This
receiving end of the
argument might
headlock
be
says,
based, but the tie is not.
you know, that's enough. I'm tapping. George Torres was tapping. And she ignored it. And she was kind enough to tell you why. Out of anger, which translates to hatred, ill will, spite, just like that in jury instruction for second-degree murder. She told you exactly why. She got angry. Him saying, I can't breathe, babe, was what triggered her. Not a fear of imminent harm. Those are her own words. That is the law. These are the 2 paragraphs that solve this equation without getting up on a big whiteboard in college that's 30 feet long, 15 feet high, and a ladder, and somebody's scribbling Latin words and Greek letters for months and months to solve this huge, complicated equation.
Oh.
The equation is solved in 2 paragraphs. She is the initial aggressor. He is saying, I can't breathe. It is no different than a naked chokehold that she does not let go of. And she told you it's because I want him to listen to me This is my bully pulpit. This is how he made me feel in the past. She doesn't describe it as teaching him a lesson, but that's exactly what she says. I want him to feel like I felt in the past. I want to tell him things. Ladies and gentlemen, we can play semantical games, but that is teaching him a lesson. Therefore, we have to look at the other two paragraphs. Because right now, plain as day, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threat and use of force against herself. And what force are we talking about? Well, the threat of force that she tells you she was facing was him fighting for survival, him sticking his fingers out of the suitcase, him sticking his hand out. That is the threat of force, coupled with, I'm going to end you. Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold, at least until we're separated. He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of two things. And she did neither. Not even close. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution. The state of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt. But a reasonable doubt is not an imaginary doubt, forced doubt, speculative doubt. So accepting that all their past history, accepting the doctor's testimony and the limitations on what they reviewed compared to what we reviewed. We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist and saying that he will end her if he gets out, we'll give her that. But just like Mr. Cacciatore mentioned earlier, lawyers' words mean things to us, and they mean things to everybody, but really to us. Or an and. There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. She did not use every reasonable means to escape the danger that now, after provoking him,
Cadbear, the power of the tie compels you.
she didn't
Vote
pick
guilty.
up her cell phone and start walking. Call
It looks like an
911.
earthworm on his tie.
She didn't do anything other than, if you believe that is why she called Brian Boone.
Words
made a
mean
phone
things
call to
is
Brian
an
Boone,
inside
Boone,
joke
and
between me and my
unfortunately,
father
past history,
because that's how
he just
important
ignored
words
the
are to me.
phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this. Other than using the deadly force on George Torres. Now, this is a weird situation. This is not a rear naked chokehold. This is a suitcase, or as Mr. Cacciatore said, a box, or actually more aptly described it as a coffin. And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance. I'll give you a quick example from a couple of movies that I love. In 1977 in May, a movie came out, it's called Star Wars. They eventually called it Episode 4. In the first scene, there is this large, imposing figure that wears black armor. He is a government agent.
They're using a Darth Vader defense.
Documents.
Prosecution.
He picks a man up who he believes is responsible for this treachery, and breaks his neck and chokes him to death when he doesn't tell him where the.
I was expecting a Chewbacca
We
defense,
all
not
understand
a
that.
Darth
That is
Vader
direct
offense.
Force we all understand.
Darth Vader offense, yeah.
But what we need to understand is the force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came out in 1977, another co-employee of this dark, imposing figure, Vader, insults his religion. He does not go to HR. He takes matters into his own hands and chokes this person from a distance. Ironically, while we're talking about force,
You'd be surprised how many Star
and then
Wars
in the subsequent
analogies
movie,
lawyers tend to use.
he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force, can be exerted from a distance in this situation. So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him. She has not exhausted every reasonable means to escape.
She
this danger.
freaking force
Do
choked him,
something.
dude.
You started this. You put him in the position where he cannot breathe. She's required by law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres
The tie
that
is
she wanted to
important.
withdraw and stop the use of deadly force. But George just reads this for me. George Torres continued or resumed the threatened use of force. That did not happen. She never withdrew from physical contact.
Vader
She
offense.
is still, like Vader, choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on George Torres' movements. She never indicated that she wanted to withdraw. Sarah, babe, I can't breathe. All right, if I let you out, are you going to come out peacefully? Since I started this, I'm the one that made you not be able to breathe. That didn't happen. So, ladies and gentlemen, this entire analysis about deadly force starts and ends there. She was the provocateur. These are her obligations when she starts it. She put him in fear of death. He is literally telling her, I cannot breathe. A couple other things about the law. Second-degree murder does not require a proof of intent to kill. Argument was made repeatedly that she didn't intend to kill him. That has never been the state's suggestion. Because why would we suggest we prove something that we don't have to? It's not her subjective belief. Well, Sarah Boone doesn't believe that this suitcase can kill him, even though he's repeatedly said, I can't breathe. It's a person of ordinary judgment who would know, is reasonably certain to kill or do serious bodily injury to another. A person of ordinary judgment who hears, I can't breathe, babe, Sarah, and his voice gets weaker 9 minutes later, you're on notice. This is statutory notice. Done from ill will, hatred, spite, or evil intent. Her words speak for herself. This was not out of fear. This was out of hatred and anger. Born out of all those horrible things that has been done to her and done to him. Understand it. We're not going to belabor the past. Is of such nature that the act itself indicates an indifference to human life. I don't care that you're saying you can't breathe. Fuck you. That's my name. Don't wear it out. Fuck you. It's second-degree murder. We do not have to prove the intent to kill. We have to, she intended the act. She intended the act of zipping him shut. She continued to intend that act when he said, I can't breathe. That act resulted in his death. That's a manslaughter, but then when you add in the hatred, ill will, spite, and the depraved mind, that's what makes it second-degree murder. And that 2-minute video is the textbook definition of depraved mind as we define it here in Florida. Voluntary intoxication is not a defense. You cannot feel sorry for her because
Vader didn't go to HR is a great line. I love
1.5
that.
liter bottles of wine and then some from the leftovers from the day before. And quite frankly, she's blackout drunk. She's blackout drunk. She doesn't remember making the videos. She turns her phone over right to the deputy the next day because she doesn't know what's on it. She doesn't remember doing it. Another thing that we just haven't talked about much is her story. She can't be up in the shower hiding and taking a picture at 11:03 p.m., 9 minutes before the video. That portion of her story just doesn't add up. And what it shows is it's more like 20 minutes instead of 11 or 12 minutes that we know he's trapped in what turns out to be his coffin. Let's talk about her testimony at trial. And we'll talk about all the problems. A lot of her issues predated her relationship with Mr. Torres. So it's not attributable to the trauma from Mr. Torres with all the luggage she brought into the relationship. And listen to the way she talks. It's not splitting the bills. It's helping without argument. It's not cleaning up and doing Sunday chores. It's cleaning up so we can relax. It's a reward. She talks about him like he's a child. I need to lead him to the next activity from one to the other. And then you saw the videos, and I'm not going to belabor it, that we showed in Rebuttal, but the relationship and the power dynamics speak for itself. He was treated like the third dog. And it might very well have been a dog that bit and was violent.
Yes.
But
He
was
treats
treated
everyone like a dog.
Why are you leaning against my door?
True.
Get out of here. Go downstairs. You're worthless. You're garbage. They showed the part of the video where he slaps the phone, but that's after 5 or 6 minutes of being berated and dehumanized in a way that nobody should be treated. He just wanted to get in bed and lay down next to his fiance. Instead, get away from the side of my door, you useless dog.
You can go sleep on the floor.
I thought it might be a good point in time to listen to the music. You know, when does Mr. Torres get to decide what to do? I mean, she paints this picture that he goes off and does all these things on his own, goes and buys wine when he's not supposed to, does all these things when he's not supposed to, but when does he get to do what he wants? Suitcase downstairs for a week so they can donate it. What was in their lives that was preventing them from getting that suitcase to the Goodwill or whatever? Neither one of them worked. What's going on? Lucas is over there on Mondays and Tuesdays. The story about the suitcase having already been down there is quite suspect, and we will get into that more. But again, it's not we went on a trip together, we had a great time. It's I quote unquote, I recently took him on a trip. Then it comes down to the moment of truth, which we've already gone over. And it's just quite frankly inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs. There's a major glitch in her matrix.
He's using a lot of movie
Suitcase.
references.
Please stop doing this to me. And then his hand gets out. Now she's the point in time when she gets angry and doesn't do what the law requires after basically choking him with his coffin. Beats him into submission with the bat and turns it back over. For the first time ever at trial, she says, I'm going to fucking end you, is what he said. She never told that to even her doctors. We've heard the arguments why she didn't tell the truth to the police and all that. And there's a lot of truth into the argument that was made. There's a lot of truth. When the argument is made that she didn't understand self-defense, what that means, what it comes across as, she makes this story change as she learns about it. When we apply the jury instructions to her statement, all 6 of them apply against her. belabor this since it was discussed earlier, but did the witness have an opportunity to see and know the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot, but she was so intoxicated that she still felt the effects of it at 1 PM the following day.
That's pretty fucked up.
The medical examiner told you that alcohol dissipates in the average person. Everybody's different, tolerance, all sorts of things come into play, but on average,
Talk nerdy to
0.015 grams per deciliter will dissipate every hour. So you can do the math. 0.015 times 14 puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police. You should not believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03. You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding. Does the witness seem to have an accurate memory? Well, this ties into what we're talking about. But again, there's a glitch in the matrix, 11:03 to 11:12. Her memory is not accurate. By her own admission, I don't remember. She tells the police when they show her the video, I don't remember that happening. Was the witness honest and straightforward?
Okay,
in
how
answering
many
the attorney's
movie
questions?
references is that by now?
I submit when we got off script, and by we, I mean both, with both attorneys, she wasn't as honest and straightforward as when it was a very directed and smooth examination.
I'll
I
take a
came out of the
movie
gate with
reference over
something
being
that,
talked down to.
Yeah, at least that's relatable.
Tell
Yeah.
me about Pamela Erickson. Tell me about Christine. Tell me about Crystal. Because she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were and that she believed that he was cheating on them with her. And apparently she is too with some guy named Ben. That when I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real. But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Judge, object.
Approach.
History of resentment.
Yep. Let's see, we got here. Oh my God, so many comments. Coding says this guy is giving Judge Schroeder from the Rittenhouse trial vibes. Yeah, cool. I see that. Chaos Smash says, I think
Good old objection.
everyone is zeroed in on the tie. By the way, in the poll, where to get the tie? Bill Cosby's Closet is winning with 31%, followed by the 90s. Followed by the 90s. Chaos Smash says his tie will be a reminder of those who cross him. Malthus says, I first thought it was a worm too. Then I thought of Earthworm Jim. Groovy. Yeah, good old game. That's also a 90s game. Nikki P says, Star Wars in court, mega based. Charlie Spur, no freaking way. Yes, it happened. NR says, imagine having such a solid case that you can use a freaking Star Wars example. Yeah, he's feeling himself for sure. Chaos Smash says, don't remember his name, so I'll call him the tie guy. Kid Loco says, hell yeah, we just need the Imperial March. And then Troubleshooter with probably one of the best jokes out here for €6 says, considering the Star Wars reference, this fella is a TIE fighter. Let's see what you did there. Charlie Spur copied that too. So it's TIE as a TIE fighter, but Troubleshooter got it first though, Charlie. He got it first. Philip Ray said, force choke him via suitcase. Didn't have that on my bingo card. Sigrun Eternian said, I get his point, but I think the analogy is wrong. Yeah, and that's the problem with using a movie analogy. Because if it's not spot on, you want to be very careful with that. It's a little bit of a ballsy move, but he did get some lines in there, like the HR line. And Sebastian Mueller said, Vader doesn't go to HR, he is the HR. Yeah, that's true. JP Ravenfire, talk nerdy to me every single day, baby. Halmer23 says he's trying to win a bet with how many movie references. He's got like at least 13 and 3 different movies. So good job. Royal Wee says, who's the extremely attractive blonde? Well, she can introduce herself.
Hi guys. My name is Alana, and I have a podcast called Legally Dirty Blonde. I'm an attorney in New York. Yeah, that's pretty much it. Not super exciting. I actually have kind of been on a hiatus from my podcast, but we'll be back soon. Courtney Clenny for sure.
Courtney Clenny for sure. And she's a good friend of mine and makes incredible content.
Oh, thank you. What did they say her blood alcohol content was? Something.
So that means that we have like all three major areas: New York, California, and Florida. It was
Yeah.
2.3.
2.3. She drank in the morning.
Let me see it loud and
I'm
clear.
positive.
Battered spouse syndrome does not have any effect on this
He's
case.
gonna say
It has
American
no
Beauty?
relationship with
No.
this case because
Hear him,
she is the
Amin,
aggressor.
no.
She zipped him shut in the suitcase after he said, I couldn't breathe, she wouldn't let him out. Therefore, all of the instructions above that paragraph of however do not apply. They do not apply. Now, turning back to what I was saying, did the witness have some interest in how the case would be decided? Well, of course. 3 out of 4 panels that y'all came from indicated to the judge fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend, as you should, because all 6 of these things, we haven't even gotten to the inconsistent statements. Let's pretend her testimony doesn't exist, and you just have to look at the circumstances. The testimony from the defendant is George Torres' head is here. You can stand if you need. You've been sitting a long time too. His head is here. His butt is kind of down here. His feet are here. And his hands and his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back are on his left side. You hear that? That's solid. You don't have to accept that she put those marks on him when he was in there. The evidence doesn't support it. You can conclude she used this bat when he was outside the suitcase.
Boom!
You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But
We never got ourselves a hide and seek expert.
We also didn't get a zipper expert.
She can't expect you to believe her testimony about the loud boom being the day before compared to her 2 neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek. Something made that loud boom. It takes energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the evidence supports, is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. It's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be, how you're going to live your life. Go take a walk. Do this. Do that. You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happened outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't.
There you go. You shouldn't. Yep.
The inconsistencies, I'm not going to belabor it. Your dinner is waiting in back. Let's just briefly talk about the experts, and we'll move on to the end. Dr. Brandon was absolutely fantastic. He explained everything that you all needed to know about battered spouse syndrome. And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor, and she had the duty to do the things that the law requires. But it does call into question the credibility of the past power dynamics of their relationship. Those videos speak for themselves. The officer in the last video asks him, dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? It's like, man, I'm not a beefcake. I'm not going to rat her out. There's countless examples, if you apply Dr. Brandon's testimony to Juan Torres, that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper, I don't find much quarrel with what she says about battered spouse syndrome, and nobody should. I mean, she's the expert. But she's not Miss Boone's treating physician. She's not her treating psychologist.
There you go.
The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm. That's the crux of the matter, Doc. You're never going to ask her what it is he said or did for this grand jury instruction about threat of force or use of force? It's remarkable. And you know, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power to stop him from dying, because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop. She didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees, yes, Ms. Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't. After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations. There's details that matter. And again, it's not to belabor it. I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter of as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very edited clip of him attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos. Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes. You'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor. Ladies and gentlemen, this has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torres and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense if I was justified. It was not justified under our law.
Your Honor,
She
my
does not
midichlorians are
decide
drunk, says
that
professional
she has a
gentleman.
license to kill
Excellent
because of her
A-tier
past
reference.
The law requires her
That's
to
why
stop
professional gentleman's a mod.
the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. And you know what was in her heart. She tells you it's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him. She did, and then she left him there. And she had an obligation, if you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
Very good job.
Thank you both. Members of the jury, I have some additional instructions to read to you. If you would be so kind to turn to page 21 of 22. Instruction 3.12, verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven, beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. If you're looking for it, you don't have it. I do. That's why we only have one. The verdict form reads, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, case number 48-2020-CF-002603-0, State of Florida plaintiff versus Sarah Boone defendant. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this blank day of blank, 2024, signed the foreperson. Final instruction, members of the jury, page 22. Instruction 3.13, submitting case to jury. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom.
I'm going to put up a
when you
poll.
return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations.
I'm going to start the clock
with the
when they
exception
leave the room.
With the exception of Exhibit 10, which purports to be
I'm
a
voting
wooden
for
baseball
45
bat,
minutes tonight.
will be sent into the jury room with you when you begin to deliberate. If you wish to see Exhibit 10, which purports to be a wooden baseball bat, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply in this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. The parties approach.
Okay, so when they go out the door, I'm going to start it, guys. So we're finally there. And I'm going to stay on jury watch on this one because, number one, it's the morning already here, so I'm already fucking locked in. Second of all, at this point, I think it's not going to be like a 4-hour jury wait or a 6-hour jury wait.
Members of
I
our
just
jury,
don't see that.
I want to take a moment and thank you for your time, your service, and your participation in this very important process. As I said to you last week, be it Monday or Tuesday, maybe even on Wednesday, without your sacrifice and your service, the wheels of justice would simply come to a screeching halt. And on behalf of myself, the state, the defense, and Ms. Boone, we thank you for that sacrifice. With that, jurors wearing badge 295, 9, 569, 515, 130, 249, and 448, and 110, you successfully served as our alternate jurors in this trial. I wish I could give you more than my thanks and a hot meal that's waiting for you, but I do thank you for your service and your sacrifice. Courtroom deputy is going to take you out at this time so you can collect your meal, and I'll meet you back there momentarily to give you your jury certificates. Thank you for your service. The rest of y'all, if I didn't call your badge, you need to hang out.
Yeah, because you're the jury. Yeah. Rolando Feliciano says something for later. Think you'll look at the Hololive JP FTC issue? Yes. I think it's the issue I'm going to cover. I'm going to cover probably that on a separate stream.
You all may be
but
seated.
If we have extra time, I'll
For
do
you
it today.
six, you are the jury that will be deliberating in this case. I thank you again for your time and your service. The exhibits will be brought back to you momentarily, and a meal is waiting for you.
We do
will
have
work
a
till
Nickety
approximately 10
Crackets
o'clock tonight.
case
If
as
you
well.
do not render a
We have a
verdict before
Crackett's
then.
update, yes.
And I thank you again for your time and your service. I'm going to ask the courtroom deputy to go ahead and take you back now to the deliberation room.
She doesn't look very happy.
I think she knows. She knows, like.
You can bring your phone with you. There's a basket that the deputy will take and collect for you. Thank you.
Natasha says for 5. Come on, what's in the box? George Torres in the box. Sigrun for 5 says, do you think it's possible some of the jury might be wearing movie t-shirts and the lawyer picked up on that? Maybe, or maybe they had at some point they wore like a Star Wars thing. So that could be it. It's possible. Nikki P says, I'm betting on Goodwill Hunting quote to finish it. No. That would have been too on the nose.
How do you like them
You all
apples?
can be seated. Thank you very much.
There you go. 199 Super Samantha says his tie was in style when closing started.
Into the deliberation rooms?
Yes.
Okay, I would object to that on the grounds that it allows one juror to potentially assert that their notes are better than others as opposed to just relying on their memories.
Any response, State?
That's not the law.
There's a verdict form that there's an instruction that I read specifically on that, sir, that no one juror's notes should trump another juror's notes or their memory. So your objections.
Suck it.
Excuse me, sir.
Mr. J and
Starting
Mr.
the-
Cacciatore, do you have the clean laptop for the review by the defense? While we're putting that together, can both the state and the defense review all exhibits that were entered into evidence and confirm they are what they purport to be, so that all exhibits
Should I wait? I'll wait till they have their
exception
evidence.
of Exhibit 10, the bat would be sent back to our jury.
I'll wait till they send out the evidence here. I'll give him a minute.
Yes, please.
I'll give him a minute. Give him a minute.
Dude, this guy does not understand house rules. Like, my house,
Andrew-
my game.
Andrew, I'd say the trial is in the bag. Yeah. Darth Vader was a hide and seek expert. I mean, he found the rebels. Bald Eagle, 1787 says, to think if that jury had called 911 after hearing that boom, George would still be alive. The neighbor. Yes, if he had, yes. Charlie Spurs said, Vader, Sarah isn't as forgiving as I am. My master, Sarah, is not as forgiving as I am. Mark of Reality says, I want that tie. How to not get sanctioned when they really, really want to. A trouble causes dream. Commodore Proxy for 10 Canadians is the only way this should take longer than 90 minutes if the same people in the jury aren't familiar with Star Wars and the others need to explain it. That'd be hilarious. All right, so make sure that I'm going to timer's going because they're sending the evidence out there. I know they'll have a little bit of food and get that going. But let me turn first before we go anywhere else. We've got a Crackett's update. We've also got a video on the divorce papers, the divorce letter for Sarah Boone. But before we do any of that, I want to flip it to my lovely guests here today. So why don't we go top to bottom? So Cypher, why don't you tell me what you thought about the closings?
But I'm on the bottom.
I'm sorry, bottom to top. We're leading a rebellion.
Damn it.
We're leading a rebellion from the bottom. Sorry.
So
I'm
what was the
boomering.
question?
I'm boomering it like the defense. No, just what did you think about the respective defenses? Who did better? Who did worse? Things you really liked? Stuff that caught your attention?
So I live by the attitude of if you have to use a significant amount of words to be right, then you're not right to begin with. And when he, like everyone was saying it, he's dragging. I was like, yeah, you're done. Because you should be able to just say what you need to say in a short hit, right? Like an empathy hit. Just like FBI negotiators do it all the time too. They can say one question and it completely turns the conversation. He's just so condescending that I'm sitting here I'm thinking like a poker house. I'm like, dude, it's house, my rules. Shut the fuck up. Get to your point. Okay. And then we'll, place bets. But I'm so glad I took a nap. I was like, what the hell are people sitting through? So yes, brain processing power.
Yeah, a lot. So I know it's not the defense, but which of the prosecution closings did you like better? The first one or the second one?
I think I came in. I don't think I saw the first one because I came in later.
Yeah.
But
Because you weren't
honestly,
watching. You weren't watching.
no, I wasn't. I was napping.
So
I was
okay,
mentally preparing myself
I'll
for
give
damage.
I'll give you and Alana the same pass because it's like the you missed the first one, and the first one was arguably, at least in my opinion, I thought was better.
Okay.
I see.
I didn't see that one either.
You saw it or you didn't see it?
I didn't see it.
Yeah, it was pretty good. It was pretty fucking good.
Yeah, I thought just whipping out the suitcase was good enough. Like, honestly, I would have whipped out the suitcase and asked them, like, can you, like, can a person actually, like, fit in here? Because that would have just set everything up. Like, everyone would have to just think about that for a second and then just, that rabbit hole of a mind would just go. But yeah, I just figured
I think they should.
I thought was pretty good.
I think they should have had a fucking mannequin or something. I think they should have recreated that. I know it would have been weird, but like, just even trying.
There was a court case. Maybe you guys remember. I don't remember exactly who it was, but there was this court case that was like a done deal because the lawyer brought out like a dummy and literally showed, what physical impact would happen to this dummy, matching whatever the case was going. But I don't remember what, but chat probably knows better. There's too many true crime cases.
I think the problem here was that Sarah took him out of the suitcase. So because he was out of the suitcase, it like they couldn't reconstruct it the same way. Well, I think it was Zimmerman. People are mentioning the Zimmerman trial. Might have been the Zimmerman trial. Charlie Spur said, this means it's relevant so jurors can watch. Well, jurors get all the evidence. So they get every piece of evidence to go through. So they get all that. Malthus for 5 Canadian says, I know it's not much, but thanks to you and your guests for carrying us through all this. You're super awesome and cute, even legal mindset, I guess. You know what? I'll take it. Appreciate that. No, but really, seriously, thank you to all my guests. Thanks to Ava. Thanks to Cypher. Thanks to LDB. And also the people who came on other days like Mama Akko, Rima, Sparky, Errant, everybody who came on throughout the week. Thank you so much for joining me. It was really fun. My goal was to have fun and also to bring on smaller content creators because that's kind of how I got started, was coming on during a trial stream, and hopefully it helps everybody else. I know Ava had about, 400 or 500 new subs or something throughout this trial, Ava. So hopefully that helped out a lot with your getting a start.
Yeah, I started out with 150 on day 1, and today it's well over 600, I believe.
That's awesome.
Yeah, that's really good. And hopefully there's lots of love for your podcast, both for LDB and for Cypher, because both of you are podcast girls. So hopefully your podcasts do very well.
Podcast girlies.
Yes.
You should tell them I finally got it to work. Oh my God. Apple podcast vetting was painful.
Oh, it's hard to get on Apple Podcasts.
Every platform process is different. So like Spotify will throw it up fairly quickly, but like if you're with like iHeartRadio and like Apple, so Apple took at least 24 hours, but iHeartRadio takes up to 48 hours, and it's because they have criterias for what like different genres of podcasting. But I think they must have changed.
State of Florida versus Sarah Boone. State appearances for the record.
Like, are they back already?
Defense.
Sir, this meal is not hot enough.
To review and inspect all the evidence to be sent back with the jury.
Oh, Junie too. Junie. I forgot Junie.
Okay.
Junie's great. I love Junie. She was on here too. Appreciate it.
Madam Clerk is the best, so I have no doubts that everything is included. State had the opportunity to review it. Okay. All right. And with regard to the laptop, has it been inspected?
Yes.
All right. Okay. So we'll send the exhibits back with the exception of Exhibit 10, the bat, and the clean laptop to our jury. Ms. Boone, I've got a couple of questions to go over with you again, ma'am, if I could. Ma'am, you were sworn previously this morning. You've been present throughout the entire trial, starting last week through today. You've been seated next to your lawyers at counsel's table. You've had the opportunity to observe the opening statements, the direct
It's trying to
examination,
start
and
bullshit.
cross-examination of all the state's witnesses, the direct examination and cross-examination of all the defense witnesses, and the opening or the closing statements as well that were presented by both sides. You've also had the opportunity to observe all of the exhibits that were presented as evidence in this case. Are you satisfied with your lawyers up and until this point?
Absolutely.
And are you in agreement with the strategy utilized in your defense?
Yes.
The last issue that I need to address is the state's request for in-camera hearing regarding financial arrangements between defendant and defense team. State, what is your concern?
It's a very expensive defense, and she's indigent, and there are bar rules that limit the ways that things can be done.
Yep.
I don't know.
She's indigent. She doesn't have
None of my
money.
business unless it's raised in a 3850. So if there's an in-camera proceeding, I would ask to be sealed, and won't be any need to get into it unless there's a 3850 claim that there's a conflict of interest.
Is there anything other than concern or speculation that you have?
Just things in passing that have been said and observed. It's a very expensive defense. That's my concern. I don't want her to be able to raise any arguments that, well, I would have pled if I had a conflict-free lawyer who did not want it to go to trial for his or her own reasons.
Okay. Mr. Owens, is there anything of concern that I need to be aware of in camera?
No, sir.
Mr. Henderson, same question to you, sir. Is there anything of concern that I need to be aware of in camera or otherwise?
No, sir.
Mr. Beck, same question for you. Is there anything of concern that I need to be aware of, be it here or in camera?
No, Your Honor.
Okay. All right.
Judge, and if you need to inquire from my client about whether or not she wanted to enter a plea or whether she wanted to go to trial, but, you know, we made it clear that it was her decision, not my decision to go to trial because I'm trying to gain some publicity or money.
Bullshit. But yeah.
But that was her decision. There was some strong conversations we had about
That's why he signed up.
what was on the table. And Ms. Boone
Why the fuck you lying?
wanted to try.
Yeah, there's no way
Mr.
we all saw the ad
Henderson
yesterday
and
that
Mr. Beck,
he
would you
responded
agree
to.
with Mr. Owens' recitation as to none of the financial issues being book deals or anything on the table at this point in time?
Judge, yes, because I definitely don't know about it.
Okay.
Because
Mr. Beck, anything to add, sir?
Only, Your Honor, that I believe this is attorney-client privilege information, but there are no concerns about comment.
I colloquied Mr. Owens, your client, before we picked a jury as to the offer in this case and whether or not she was ready and wanted to proceed to trial. And she had affirmed at that point in time that's what she wanted to do. So I see no reason to inquire of that further. State, is there anything else we need to address? Defense, anything else?
No, sir.
All right, please give your cell phone numbers to Madam Clerk. We will be on verdict watch. And I thank you all for your hard work in this case. We're off the record.
All right. So I'm going to drop this out and we're on, we're on verdict watch now. Now, of course it is, what time? Well, let's see what time it is. Time EST. So they've said they said 9, which is an hour and 30 minutes. I still think that's even going to be long, but okay, we'll see. We'll see. They got to eat food, so they'll probably take some time to eat food, right? Also, I forgot to share this meme. Somebody shared this. This was great. As a Neon Genesis Evangelion nerd, prosecution Owens. Very nice. All right. So, and I'll have a poll in the chat because we've got 2 other topics to cover here. And I want to know which one you guys want to hear first because I'm a man of the chat. Now, you guys do think in the poll, how long will it take? 736 votes. 15 minutes with 15%. Most people think 41% takes somewhere between 15 to 45 minutes. The rest, by and large, believe 32% believe 45 to 90. And only 12% think it's going to take over 90 minutes. So I think most of you think it's not going too long. So as we go here, I'm going to put a poll. Which do you want to hear about first? So they're two kind of longer things. So there's Sarah Boone's divorce, or a Nick Rekieta update. So you get to see both. You get either Sarah Boone's divorce or a Nick Rekieta update. You can have one or the other first. If we have more time, I'll do them both. All right. I didn't get to ask Ava this question, but Ava, what did you think overall, since you saw every single closing? Which one was the best to you, and what did you like the most? Also, is there...
So prosecution started out pretty strong, especially with the makeshift coffin comment. Defense was, I can't stress how rare it is and how improper it is normally to object during closing, but it can happen. How many times it was sustained with defense's closing was kind of surprising as well. Strongest was rebuttal, especially his loud use of the suitcase, him waking up the jury by slamming it on the ground and then using the bat. I didn't know that there was wood in that suitcase until he did that. And I'm like, wow, there's no way that happened.
It was rigid.
That's a good point.
It was rigid. I don't know whether it's wood in the suitcase, but it was rigid, whichever way it was. So there wasn't a way for him to be whacked to create that while he's in there. It had to be from something else. So
right. I also think that it was pretty impressive that, like, I don't know, I felt like defense counsel was all over the place with their closing. Like, I didn't feel like there was any organization to it. And I felt like on rebuttal, he was, I don't know the attorneys' names, but he was able to kind of address everything he said without making it as complicated as
He was very clear.
Did.
So
Yeah.
Alana, specifically for you, what was the best and worst things you saw? Like the best thing you saw and the worst thing you saw?
Today?
Yeah, in the closings.
I agree with Ava about I thought waking up the jury was a good thing to do because they were definitely falling asleep and throwing that suitcase. Yeah, we do that in trial sometimes with we'll drop a book on the floor so that the jury's like, whoa, because people fall asleep.
Yeah, it's
people
boring.
really do. And it'll just get them paying attention. So I definitely think that I agree with that. I don't know. Like I said, I missed the first, I missed the closing. So the original closing. So I can't really comment on that. The worst thing I saw was probably all the objections getting sustained for defense counsel. I mean, I think that's just going to annoy the jury even more.
Yeah, that was really annoying. Mark says, since she's indigent, are these PD office, RCC, or registry attorneys? Since there's a lot of them, it's registry attorney are probably no-go. No, they volunteered after they saw her ad that she put up in prison. They're not the PD's office. The PD office was one of the first she had, and they were out. So now some of them were for conflicts, but they were out. The PD's office has been out for a while. So yeah, it's been going through the list of attorneys, but these guys, she was actually pro se for a very long time. And then she finally found them in the months leading up to trial. So she was very lucky that she did not have a pro se trial, although I don't know how it would have looked if she had pro se. It would have been very interesting. Very, very interesting. All right. In the poll, we have 65% want a 66% want a Nick update, and then 35% want a Sarah. So we'll go with that first. All right, here we go. The Crack Kata update. First of all, we have a new lawyer for Mr. Nicky the Real King Rackets, Brian Lewis of the Francis White Law Firm. Remember, these are the best friends of Boss Baby, our good buddy, Boss Baby, his BFFs. Brian Lewis here is the attorney. He goes, "It's been a long evening. I'm just leaving work after submitting an appellate brief. I can't even begin to describe those thoughts. It will end up bad in both ways if the things going around doesn't stop soon. Time to go watch the only Air Force Master Sergeant or whoever mattered be in the quiet room now that the HP blowers are gone, and think some more." So he's going to listen to some music, but it will end up bad for the brief. Now, what brief is that? Well, my friends and family, it is indeed Nick's petition for discretionary review. He's filing what's known as an interlocutory motion. Now, it may sound very nerdy, and I know the lawyers on the panel know this, but an interlocutory review is when you're appealing for a higher court to review what the current court is doing because you think it's no good. Now, let me ask Alana, and I know because this applies in the civil context, the criminal context, all contexts, right? Even transactional stuff, people, if they're challenging in court, could bring it up. How often are interlocutory reviews granted?
In my career, I have never done one. So never.
So,
and that's
so
almost 10 years.
What would you say the probability of one being granted is?
I mean, this
In
is
general.
in his criminal case. I've been paying super close attention to this, so I don't know a lot about what's going on.
I'm just in general, just speaking of generalism, because I know that you're not an expert in Minnesota law, you're not a Minnesota lawyer, it's not being paying attention. So all the caveats.
Not often. That's what I'm gonna go with. I'm not giving you a percentage.
Sure. So not often. And Ava, you're probably of the same mind over there in California. I mean, have you had much experience with interlocutory appeals or seen one that's seen one even?
No, and I can't think of anyone that was granted. I think I've seen one filed. That the person, the attorney I was studying under, did, but I think it was denied. I can't think of one that was ever approved.
Oh, and I know I'm going to go through this because I actually, fun fact, for my moot court, I had a moot court argument, and I was like, I made an interlocutory argument, and actually it was like a very successful interlocutory argument. So I like studied a shit ton of law regarding interlocutory appeals. So actually I know a lot about interlocutory in general, just from a legal standpoint. But that being said, I also know a lot about LDB, and I know she loves the Yankees, and I know she's got to go. But thank you for joining us. Appreciate you. And definitely, guys, check out her podcast. It's great. I hope you come back very soon. You're going to have a lot to cover with Courtney Clenny, and I'd be really excited to hear your take on that.
Absolutely. Thank you so much for having me as always. And ladies, it was so nice to meet both of you, and you will have, each of you will have a new subscriber soon.
See you.
See you.
Bye, guys.
So,
thank you very much. You have a
God, no lag.
Lag elf. Mercenary X21 for 2 says Delta is now banning people for jokes on X now. Oh man, that's fucking sad. That's sad. That's real sad. All right, so let's get into this. So he is doing an interlocutory appeal. I'm going to tell you right now, the case law is not good for interlocutory appeals. Very low probability of going. I'm once again not going to give a percentage, but this probably has as much probability of winning as a Franks hearing, right? Which, for the record, he lost, right? So his probability here, I'm going to probably put it the same probability as the Franks hearing, which is really fucking low. So the state of Minnesota.
I'm going to have to object here. You ambushed me by having specific knowledge of interlocutory appeals when I had broad knowledge, and I have a problem with that.
Get wrecked, Elf. Brain Fried says, why does the crime reproduction not happen until rebuttal closing? Sandbagging, did the evidence of George beating only come out this time? No, it's because they like crime reproduction is an actual thing, and if you're going to put it back together, you need to call an expert. It can be very expensive, and like they said, Sarah's indigent, so they don't want to spend too much money on this thing, right? So yeah, that there'd have to be a little bit more at stake. I think it comes more into place when it's like a car crash or something like that that lends itself to the reconstruction. But let me continue here. This is filed by the Francis White law firm, Brian K. Lewis. So once again, this frustrated attorney is the one that filed it, and the timing lines up perfectly because this was filed today. And it was filed with the Kandiyohi County attorney. So what does it say? It's to the Court of Appeals. The defendant, Nicholas Requeda, requests that Minnesota Rule of Criminal Procedure 2802 and the Minnesota Court of Appeals exercise its discretion to review the order of the district court and requests this honorable court grant this petition for discretionary review. Statement of facts. The Kandiyohi County Sheriff's Office, hereinafter the KCSO, opened a criminal investigation into the defendant. To secure the search warrant at issue in this case, Deputy Quinn Pomplum, hereinafter the Pomplum, knowingly and willfully deceived and misled the signing judge through his application for a search warrant. Okay, so this has actually already been disproved. So the fact that they're restating it after they've already lost their Franks hearing means they're trying to get a second bite of the apple to prove this, right? Pomplum based his application on 3 distinct indicia, none of which defendant argued were truthful or sufficient for a warrant to issue. A report on May 16th alleging possible child neglect and controlled substance abuse. Defendant, in his motion for a Franks hearing, alleged that Pomplum had failed to disclose to the judicial officer the existence of a May 20th letter sent to the KCSO from Kandiyohi County Health and Human Services, informing KCSO that the May 16th report does not fit the definition of child abuse neglect as defined in Minnesota's statute, Chapter 260, reporting maltreatment. This was 2 days prior to his application for a search warrant. Just because one letter came in there, this does not change whether or not he had probable cause to know Nick was on the booger sugar. You know, once again, you had him on camera, you had other reporters, you had anonymous people and mandatory reporters coming in that were saying he was using the booger sugar and there's possible child neglect. So regardless of what KCSO says, or sorry, regardless of what Health and Human Services says, that is different from this, right? So even if they're coming to that conclusion, that doesn't necessarily mean there's not probable cause for the search warrant. Next, defendant alleged that Pomplum's failure to inform the judicial officer of the prior determination is material and is an initial predicate for seeking a warrant had already been deemed insufficient by the very county agency charged with protecting children, preventing the judicial officer from approaching a warrant application with facts necessary to authorize the intrusion upon defendant's home and repose. A video made by Aaron Imholt, hereinafter Imholt, which alleged drug use by the defendant. Defendant, in his motion for a Franks hearing, alleged that Pomplum had intentionally misled the court in his application for a search warrant by suggesting that Imholt was a concerned citizen. Well, he was. What do you want to call him? You want to call him a member of your little polycule? You want to call him a member of the cover with a Q? Like, what the fuck are you trying to do there? Like, he is a concerned citizen in addition to being somebody who was fucking Nick's wife. Pomplum asserted that defendant and Imholt may have recently had a falling out. Defendant alleged in this was an intentional misrepresentation. So Nick wanted to say it was much more than a falling out. Well, that's a way to say it, right? Just because it's not Heartbreak Hotel like Nick wants to describe it, right? Nick wants to have it with all the heartbreak that his wife had after his wife's boyfriend left. You know, I mean, how else do you want to describe it? I mean, I guess Nick wants to proudly be known as a cuck in the search warrant. I don't know. In a 5/22/2024 video blog by Imholt, referenced by Pomplum, Imholt makes clear that his relationship with defendant had degraded far beyond a falling out. Imholt stated at 1 hour and 4 minutes, peace, brother, is not what Nick told me when I would not be hanging out with him anymore. The text I got was something about a flabby, mishappen, doughy piece of shit I am, and the world would be a better place if I killed myself. Imholt stated at 1:06 that he communicated to Nick, okay, addict, and Imholt blocked defendant's number. Well, that is more proof, if anything, that Nick is using drugs. It lines up with the other testimony and leads to probable cause. Nick is literally giving probable cause and calling him an addict, right? Because he would know, because he was over there fucking Nick's wife regularly. Pomplum initially admitted from his affidavit that Imholt had several threats ranging from thinly veiled to fully throated against defendant. I think Nick made more the other way, but whatever, it doesn't matter. And Aaron is culpable in this too, but that's neither here nor there. Imholt stated at 1 hour and 2 minutes, Nick, sweetie baby, first of all, get help. Second of all, you better hope, as I said this last night, you better pray to God I don't say what I want. If I said what I want, motherfucker, that's Mount Vesuvius. Let's make a quick rule for Nicky Boy here. You keep my name out of your fucking mouth in ways like that, and I can promise I'll be as good boy as I can be. Imholt then proceeded at 1:03 to compare himself to Lefty Rosenthal, popularly analyzed as Ace Rothstein from the film Casino, and stated, you want to keep a guy like that happy, right? Because he could blow your shit, right? Imholt made a comparison and simple threats at multiple points throughout the video. Pomplum misrepresented both the extent of the falling out between Imholt and the defendant and Imholt's overt personal animus, bringing his statements well outside those of a concerned citizen. I mean, to this, look, Nick and Aaron don't like each other because they're mutually fucking each other's significant others, right? So Nick was fucking Aaron's wife and Aaron was fucking Nick's wife, right? So like there's some animus there. And as much as they were all cool with polygamy or whatever the fuck that is, or the polycule, they actually weren't. And these things don't work in the long run, right? No matter how much they're cuck brothers. And believe you me, I've said this before, I'll say it again. This thing that Nick's got going on with his wife in April is going to blow up at some point. Even if it doesn't blow up now, it'll blow up 6 months from now, a year from now. These things don't work out long run, right? Especially the way that Nick is trying to keep everything secret and hiding it and keeping it veiled. That's not going to work. The cuckoldry will be outed. Pomplum and fighting will start, etc., all that stuff. Pomplum initially admitted from his affidavit that Imholt, and by the way, sorry, legally Nick is a cuckold as well because he's admitted that Aaron has photos of his wife and that they had those because they were engaged in this sexual relationship, right? So legally Nick is already a cuckold. It's just a matter of when he decides to own up to that to the world, right? Anyways. Pomplum initially admitted from his affidavit that Imholt made several. Oh no, got that already. Okay, let's go down here. A video supposedly made by defendant in which a white powdery substance was said to be present on defendant's nose. Defendant in his Frank's hearing alleged Pomplum materially misrepresented that he had been able to review the video that was taken, off Nicholas YouTube and Rumble social media. He stated that the video was taken off of social media sites. This was a misrepresentation, as those videos were placed in private on each platform. No, it's not. Taken off includes when somebody else downloads it and clips it. That's common knowledge. So if somebody clips my show, which many people do clip my show, right? Like Alyssa clips. When Alyssa clips, downloads my stuff and clips it, that is taken off my channel. It is not inaccurate to say that is taken off my channel. So this is actually still not a misrepresentation, right? Defendant alleged that if a user attempts to access the video link on each of the social media platforms, they inform the video is private and the user must have special permission. For Pomplum to be able to review the original video, he would have to have served a warrant in Alphabet, the parent company of YouTube. The warrant has not been produced in discovery. It will be a potential Brady violation. That's not true at all. Pomplum said in 522, Imholt did a video blog. He got it off someone who clipped Nick's show, which we've all seen. So Nick trying to pretend that's not what happened. That's what happened. Pomplum stated on 522, Imholt did a video blog where he talked about Nick and insinuated a controlled substance use and also referenced a video blog Nick put online on 521 and since taken off the internet. Aaron clearly states on 55 seconds, so a woman who clips a bunch of shit from my show, from Nick's show, DM me. It was Nick telling a disjointed, drunken story in his dream. Here's a clip that got me riled up. The clip that Imholt plays is 1 minute and 1 second long. Pomplum says defendant's video blog is 4 hours and 4 minutes long. Pomplum therefore knew the video presented by Imholt in his video blog is an altered rendition of his and cannot be authenticated. That's totally false. You could completely do it. Nick could authenticate it right away. So could Google, right? It's easy to authenticate at trial. Very easy. Pomplum failed to inform the judicial officer of the unknown provenance and unreliable nature of the edited video clip. More likely, Pomplum's assumption was he was able to review the video, did not necessitate serving a warrant in Alphabet because Pomplum reviewed the edited version entitled Nick's Drunk Stream after losing his appeal. In discovery, the state produced a PowerPoint presentation with what purports to be a clip of his video, as well as an image purporting to be a screenshot. Not only is this video title different, it comes from a different channel, Backwards Internet, that's COG of the sector. It was uploaded at a different time and date from the defendant's original. It contains a watermark not present in the original video. The watermark is notorious and in the left-hand lower right-hand corner of the video and appears to be mimicking the branding of the edited video's host channel. Pomplum did not review defendant's original video. This was a misrepresentation of material fact. No, it's not. This is some pickety shit, which he already lost at a Franks hearing, as we see here. Defendant filed a Franks motion alleging various material representations. After argument, the district court and Honorable Judge Wenzel denied his motion. They found the information contained within the application was accurate and reliable, and there were no clear false statements, significant material
Yeah, he
omissions,
should not be relitigating this.
and material misrepresentations that cause a search warrant to be false, misleading, or a violation of the rights. He's going to lose this again. In fact, they're probably going to just deny his ability to go up and get interlocutory appeal. They're probably going to say, get fucking bent, Nick. You don't get interlocutory appeal. This is not an area of law. Why? Because you have to meet very specific criteria for interlocutory appeal. Let me just skip down here. The court noted that using social media video as support for a warrant is somewhat unusual, and caution must be used to ensure the altered video parody are not used as support for a warrant. However, the district court then found there's no indication that Depley Pomplum did not watch the May 21st video, nor is there any evidence the video is altered, a parody, or in any ways inaccurate. It's not. It's not. We all know it's true. It's what we saw. I've got clips of that on my channel as well. It's what we saw. However, defendant specifically alleged that Pomplum not only did not watch the May 21st video, but could not have watched it and alleged the video he did watch, which had been produced in discovery, had been altered. It was a material misrepresentation that had been reported otherwise to the signing judicial officer. So the statement of the issue is that under Franks, so they're literally going to challenge this to try to prove he's right about Franks. Did the district court err in not granting an evidentiary hearing when the defendant demonstrated a plethora of evidence showing
The editing was a watermark, by the way.
a fucking watermark made material? Once again, guys, the question you got to ask is it material? None of this is material. It's bickety bitch shit. Statement why an immediate review of an interlocutory or otherwise non-appealable order is necessary. So here's the big thing, and this is true in many places. The Minnesota Supreme Court and most Supreme Courts in America, I've studied this specifically, say generally interlocutory appeals are disfavored and only final judgments are appealable. An interlocutory appeal is an appeal during the pendency of trial. They don't like to do this. They don't like to review stuff until it's at the end of the trial. So this review is discretionary, and it's only granted if you meet all the factors of this test. Number one, whether the challenge ruling is vested in the district court's discretion. So if they have discretion to bring it up to the higher court. Second, whether the ruling is questionable or involves an unsettled area of law. This is not inventing the wheel. This is not something that's a new area of law. Now, I know Nick is trying to say social media is new, but the law around social media has not really changed, and Nick is not changing it by putting some booger sugar up his tutor and by there being a watermark on a clip. That's not inventing some new area of the law. 3, the impact of the ruling on the petitioning party's ability to proceed. It can still proceed to trial, and he can still appeal this once it's ultimately over. If he really feels this is fundamentally unfair, he can still just appeal the whole case. 4, the importance of the legal issue. It's not. It's actually a factual dispute, not a legal dispute. Number 5, whether the appellate court would benefit from a more development of a complete record, or where a ruling would be reviewable upon appeal. This also is against the granting of the interlocutory. This case needs a full record and needs stuff to come out at trial, because at trial it's going to be proven that half the stuff that Nick has said is completely fucking irrelevant. 6, the specific circumstances of the case. There's nothing special about Nick, despite the fact he thinks he's a snowflake. All these factors are against him. So they're asking him to grant this, saying that, hey, this is a significant unsettled area of law, right? It's unsettled. Because the question of what must be shown in social media context to demonstrate unreliability has never been answered in the context of a Franks motion. This is fucking digging for straws. It is absolute desperation. It's a weak trial strategy. It's a weak point, right? There's nothing there that is strong enough for that. So that's Nick's motion, right? They're trying to get them to come up and exercise their discretionary review. They're petitioning. Brian K. Lewis is petitioning the higher court to do that. My prediction is it will be denied. So I look forward to seeing the denial of that and reviewing that once that goes down. So that is the Nickety Crackets update there for you guys today. Gonzalo Gonsby Bergali is a new member. Welcome. Appreciate you. Sigrun Eternia said Andrews is coping and seething that Ava is more popular than he is in his own chat. Try to be a 2D lawyer, man. I know. Until I go 2D, I'll never beat Ava. And even then, I may not beat the allegations. All right. Only if Nick had a suitcase to zip into. He may feel like it after he gets destroyed in court. All right. No verdict yet, guys. Don't worry. I've got that. So I've got, just so you guys know, I have the music. I have this pulled up in the background, right? And you hear how it's got music? You guys, Ava, you can hear the music, right? So when the music dies and when they go back to court, I'm like listening to it very low. I'm going to flip back over to it. So whenever they go back, which I imagine maybe at some point in the near future. But until then, we've got some, yeah, you guys heard it? Okay, cool. Ava's got that lag. She's got that lag. Cali internet is botched. Yeah.
Dude, every time I talk to someone in Cali, like the internet, not even just internet, just mobile itself also just cuts out. And I'm like, what is happening? Are you okay? Is there an earthquake?
So let's pay attention to this. This is the Sarah Boone divorce court letter. Let's watch.
Welcome back. This is a Sarah Boone letter that kind of goes under the radar, but this is a letter she sent to her divorce court. I'm not really sure what it's called, family court. This is the letter she sent to the family court judge because Brian has not been paying alimony. She's broke. She's mad. And he filed for a dissolution of alimony, being like, she's in jail. I don't need to pay for her life anymore. And she's complaining, being like, he still needs to pay me alimony, which technically, I didn't know this, but you do have to keep paying alimony, even if your spouse or ex-spouse goes to jail, prison, whatever, unless you do what Brian's trying to do and file a motion to cut that off. And even though this is in a completely different case, she still acts the same way. So is everyone in the court systems terrible? Is the criminal court out to get her? Is family court out to get her?
Everybody's out to get her.
Or is it maybe her? And I know now this case has been sealed more or less, so there aren't any other updates, but there's some videos done out already about this. So I took some screenshots and kind of had to like cut it together to read this letter. But yeah, let's get into it. I will try to reserve my comments for the end. I have also included a letter from a legal resource that she reached out to that basically rejected her services, but she underlined a line in there that she thought was a serve, and it was just funny because it absolutely was not. And I also put the judge's order. So she wants to have a conference meeting, and this is the order from the judge after that meeting, and the judge throws shade, and I love it.
New poll in the chat on the
I
verdict
have a little
prediction.
thing at the very end just to compare and contrast what she says she's facing versus what he said he faced with her. Judge Michael Dean, in all my attempts, 16 plus, to protect myself and help from the still ongoing hate, lies, slander, degradation, cruelty, and active abuse from former husband, Brian C. Boone, nothing has been improved, made better, corrected, relieved in any way for myself, the respondent, from former husband, the court, or judge. I have tried everything. I have made innumerable requests and sent many letters asking for aid from all with no success or assistance, listening, or care by anyone other than myself trying to relieve or altogether stop his inappropriateness, bitterness, anger, and wrongdoing. Please see list below of my letters sent to you and court per the Records Management Division of the Clerks of Courts when for the third time tried getting a copy of my active dissolution of marriage agreement. I cannot have because they are wanting payment in order to receive, and I am in jail. I also have no bank account after the one I had was closed after having for 30 years due to non-payment of alimony from former husband and stated in prior letters. It is appalling how uninterested, uncaring, and nonchalant you and the justice system are about my side in any of this, and will not listen without the right paperwork and attorney, knowing I am actively being taken advantage of and wrongfully mistreated by former husband Brian C. Boone. You have continuously enabled him and given him a self-appointed right and understanding to keep doing, saying, and taking everything wrongfully and illegally from me, including and especially the love and respect from my son.
Oh, God.
It is not okay.
She wants all the attention. If anybody else gets it, she fucking hates them. This woman is a psycho. And the classic narcissist, too.
You're a killer. That's why I'm not doing anything. Former husband said in front of son on phone, you're not.
Bro. What?
Not important to anyone. Former husband, numerous dates. You are not priority. Former.
Well, why should you be? Sorry, but like when you're divorced, you're not a fucking priority. So I'm sorry, yeah. You're not a priority. You lose the priority when you're an ex, you lost that. If you want to be a wife, then you're a priority. But if you're an ex, like, no, you don't get to be a priority anymore. You're a fucking ex. Like, that's based as fuck. Yeah, Brian Boone dodged a bullet. Yeah, he dodged a suitcase. Mark. Fucking crazy.
This is why he got a divorce.
Dad says you're annoying and beg all the time. Son told me after asking him to ask former husband if he finally ordered a book and hot meal after being made to call daily to check for 13 weeks. I lie to you because I can. Dad does all the time. Son, you make no difference in our lives. Former husband, numerous dates. That's okay with you and acceptable, Judge Dean? Is that what you are giving him permission for and to keep doing and in front of my son?
Real pause here. People do this in family law situations all the fucking time and way worse, right? The unfortunate thing is, and Ava can speak to this, the kids get fucked because they're caught in the middle and the parents will have them say stuff or lie or do all sorts of stuff in these conflicts. It's one of the most saddest things about family law. It really is.
Yeah, there's lots of coaching and stuff. And in family law, what'll often happen is you'll end up getting a minor's advocate for the child's interests to be protected in how messy that divorce might end up getting.
Mm-hmm. Let's see here. Okay, let's continue.
Why won't you stop any of his abuse? Verbal, mental, emotional.
Which is ironic because she's abusing George Torres.
Why aren't you, as my judge, doing anything to hear, understand both sides? What else needs to be done to me by former husband in order for you to help me? What else can I do? I have not done
law of
already for any
transference,
relief
I kind
on
of am
my
horrified
side.
to think of what
Stop
she might
enabling.
do to
Judicially, you
Lucas.
must.
Oh, so yeah, let me pause there. So you're afraid of what she might do to Lucas? I can see that because I could see her fucking with
or what she has done, because here's the thing, abusers transfer their abuse to everyone in their lives. And yeah, it's on a scale, you could say it's on a spectrum, but if it isn't happening yet, it's only a matter of if, not when. I mean, it's a matter of when, not if.
Yeah. And you better believe that kid is going to, even if she was free, when that kid is an adult, they're going to have nothing fucking to do with Sarah. Because It's like she went off and decided to like live this life where she's just getting drunk and living off alimony, right? Which is why he's trying to cut her off, because she's a fucking bed sore at this point. King Luigi said, good morning, everyone. Hey, good morning. It's 9 a.m. over here in sunny Seoul, South Korea. So it's good to see everybody. Let's continue.
No, this is wrong in how I am being treated. I am told every time when trying to reduce any anguish or mistreatment from former husband and cooperate, trying to help, the judge doesn't care what you write. My son now says the same when I correct him on how he is being mean and rude to me. He's never going to do anything for you until your trial is over, and even then, it will still all be in my favor. My other document is ready to go, so I can take the rest. I have an attorney. You deserve nothing, you mean nothing. Then former husband gets his precious attorney to file another answer denying allegations because I'm telling the truth all the time about his awful lies, and I am right. Judge Dean, so I have to continue taking former husband's abuse, neglect, unlawful actions, cruel comments, and hate until my trial, when it happens? However long that will be, now considering my attorney has withdrawn from my case and no date of trial is known or will be for an undetermined amount of time. How much
How
more
many
hate
lawyers does she
and
blow through for
disrespect
this?
will former husband encourage my son to keep lying and overall being mean to me, his mother? Former husband is teaching and reflecting a terrible example of how women can and should be treated, nonetheless the mother of his child. This is egregious and wrong. Please read my prior motion for case management hearing I sent 6/28/23 with no response to date. I am requesting again, please to schedule. It is fair, and there are too many topics to be discussed, including my attorney, to write, and I only have one pen. Necessary, lawful, active, important topics. What is the certified notice of delinquent support filed on 8/3/23? Please grant my motions and schedule my imperative, overdue, owed meeting. Everyone needs and must have the same understanding now and future. It is fair. What else can I do? What's left except for begging, which former husband says I do all the time? What am I doing wrong in order to be treated rightfully, properly, ethically correct, in order to finally receive your judicial assistance? How I am and have been and will be treated by former husband Brian C. Boone is unfair, malicious, and wrong, and should not be in any way allowed to continue. Stop.
Crazy.
Please see, please listen.
Oh, here we
help.
go.
Judge Dean,
sympathy.
What was the reason for your comment made in your courtroom about former husband violating my constitutional rights? If you're not going to help or uphold said rights and lawfully allow me to use, what's the point? Why do I even have? You know I do in order for you to remark and see they are being violated. 9/19/22. Please schedule. It is my right. It is fair. Sincerely, Sarah Boone. Please send a copy of this letter so I know it was received and will serve as my receipt.
See, at the end, she's trying to give them. She does this to the police too, so she's using everybody as their bitch, and she's trying to get them to do what she wants. The judge is under no legal obligation to send a fucking receipt to you or anything else. That's ridiculous. But she's trying to make everybody else do shit for you and inconvenience them, and she thinks she's fucking smart. And that's the point. She thinks she's smart. She's not. She's not. It's crazy. It's crazy. So Emily Baker as Judge watched in 3 hours. Has she not been? I think she hasn't been paying attention to the trial then, because frankly, I don't think it's going to take that long. I think that's way too long. But anyways, more craziness from Sarah Boone. Let's see here.
Are there 4 jurors in this case that are deliberating?
What, excuse me? 6 jurors. 6 jurors. What do you mean 4? Why did you say 4?
6 jurors up there. I was just wondering. I don't know why I had that number in my head.
Yeah, 6, not 12, 6. It's 12 in capital crimes. So crimes in which there is like a death penalty involved, but this is not one of those cases. So yeah, but I think 3 is way too long. I think that's like maybe they weren't watching the trial and they didn't see what's going on. But frankly, I don't expect it to be that long. I mean, we're already at, according to their own clock, we're actually, I thought they had a clock there for a second. I've got my clock though. So according to my clock, we're already at 51 minutes. So I don't expect it to take hours and hours and hours. We're already at 51 minutes. It's pretty good. It's pretty good. Cypher, did you have any other thoughts just in general on the trial, the documents you've seen, and maybe that video,
I mean, it's just pattern recognition, right? Like, it's
Right.
almost like Pavlovian. Like, please
Well-
listen to me. Oh, no, this again, you guys. I'm taking, like, my brain shuts off for an hour, and then it's like, hey, I'm
Mhm.
checking back in. Does she stop? No? Okay. Like, it's
Mhm.
just with abusers and, like, certain traits of, like, the dark triad and stuff, it's a pattern. It's like, you guys let me do this when I was, like, 5, and I'm gonna keep running with it because it keeps working. It's like, I'm not surprised that, like, I was saying good dad, right? Good dad ran away, protect himself, protect his son. People were like, oh, that kid doesn't know what he's missing. I was like, no, he probably does because he hears it. He hears it watching, dad and mom. And like you said, she treats everyone like, do everything for me. I mean, look, like she does nothing, right? That's actually a very classic pattern for people who are like, if everyone does things for me, right? I never have to lift a finger. I don't have to do anything. And the reason I yell and kick and scream and pout my face because you're not taking care of me. Like I want to be taken care of. And unfortunately, like that's very common, right? It doesn't matter how
If
old you
we
are.
view
There
it
are
from
just some
the
people.
window of narcissistic personality disorder as well, in the event of not having any power, asking for a receipt or asking for some kind of confirmation of what you might be being punished for, this is your way of wrestling back control. Is now the judge is having to write a receipt. You're the one being sentenced. He doesn't need to do crap.
No, but she doesn't understand that. That's why, like, she's like, no, like I don't care what role you have, responsibility. I don't care who you are, right? You have to take care of me. Like, she's essentially, treating everyone like, no matter who you are, I don't care if I have blood relations, right? You
Right.
need to take care of me. I'm so precious and so fucking fragile that like you literally need to like spot clean me every day, pamper me, like carry me. Like essentially she's like, I don't even want to walk. Carry me. Right?
Well,
Why
yeah.
aren't you carrying me?
Well, and remember, even when she was under arrest, she's like, I need water, I need a drink, I need cigarettes, right? She's like,
Where's my snack tray?
Where's my fucking snack tray? Right?
She is a child.
She's entitled to a snack tray as a fucking indigent. It's like, sorry, no, you don't get a fucking snack tray. Like, no one gets a snack tray. It's not given out.
Honestly,
Sorry, period.
seeing her is why, like I mentioned this in chat, I was like, there's a no contact movement, and I thought this was the most bizarre
No
social
contact
movement.
movement.
Yeah, so there's a no contact movement amongst like millennials because of parents like this. So like the whole attitude
Really?
is like for years children would try to like work out with their relationship with their parents, right? Whether it's like we don't get along, we don't argue, we're not on the same page, whatever. But it's like after 5 to 10 years of trying to fix a toxic relationship between parent and child, the children, who are about late 20s, mid 30s are like, fuck this, no contact. I'm not speaking to you. I'm never seeing you.
I found a video on this. We can watch that in the intro. And that's actually a really cool thing. I've never heard about this. Because
No,
we
and
gotta kill some time.
Right. Well, and what I thought was like really, so it's like heartbreaking and heartwarming because like I have experience with that too. I went well, I tell people I'm an orphan because, at 16 I was like, fuck it, I'm out. But like all these people like in this generation was like these parents are on a whole different like reality of understanding like the way that they want to live, and they pass their, you know, prejudice and trauma to the kids, and the kids are like, this is not how the world works, right? So there's like a whole group of people just finding like comfort in each other, knowing like, yeah, I had to like cut off my mom because she was like doing crazy shit. Oh, I stopped talking to my dad. Like he's basically a sperm donor. See ya. Like I don't even know who you are. Like, and I just think it's wild, like
Well, I
that this
think
is a whole thing in it, in at least in the West.
I think it's smart insofar as if anybody is dragging you, anybody, and they're really dragging you. And I'm not saying, by the way, I'm not saying they're dragging you because they're like trying to improve you or help you, because obviously, like for example, with a friend, like for example with Mr. Crackett's that we covered earlier, like all of his friends were the ones that were telling him to pull up. They're the ones who were telling him to get help. The ones who were telling him, hey, you know, this is not good, or you know, would have listened to him if he had a problem. It's not the people that are shoving the, you know, booger sugar in your nose, right? And it's always going to be the easiest friends to hang out with are the ones that are enabling you and are pushing you down that path. So sometimes parents are like the friends that are telling you to get clean. They're the least easy to talk to or hear it from, right? But that said, they can also be a poison. They can also be the ones dragging you down, whether it's into mediocrity or unhappiness, or saying you have to do X, Y, or Z, or you're a failure. You have to go to college or you're a failure. When you're like, you know what, I don't. And then you can look over at your friend or whatever else, and they can do just fine without it. My one of my best friends, he was being pushed to go to college by his parents until the point where he had to run away from home in the middle of the night. And he ended up, within 1 year of running away, he was making 6 figures. No college degree at all, because he was finally allowed to work for himself. Right.
Yeah, that energy, it's infectious. Like, and people don't know that. Like, they won't know until you like completely, you know, new game plus, guys, find a new environment, just start over, and then you're gonna be like, oh my God, like things are great.
And I'm not, once again, I'm not saying like everybody, like that's great for everybody, but I mean, in certain circumstances.
Yeah, I mean, I was also someone who pulled the old Irish exit when it came to you know, moving out after you were, you know, early, and I stayed gone for a while. But I realized that no contact isn't necessarily fixing the problem so much as like cauterizing the wound.
No, it's last
it's not
resort.
the best fix.
No, it's most of the time this no contact is because it's the last resort. It's like you're not able to break through, and it depends on who it is, right? Like it could be just the kids being like, look, I tried for 10 fucking years and like I can't deal with this. Like I still have a life. I want to have a decent life, you know. Because like a lot of the videos, it's really fascinating to watch because the parents are like, I don't really know what the problem is. And it's like, then you weren't paying attention. Like if your kid's been crying help for like 10 years and you're like, I don't know what's going on, you know, and sometimes it is the other way, but very rarely in all these like no contact cases, it's the kids cutting off the parents. It's not, very rarely will you hear it be the other way around. I did see one video and I love this man because he must be, like,
I think this may be
fantastic.
it. Well, let me show you. I think this may be it. Is this the one right here? The one by Amir Odom?
Yes, he's a very sweet man.
Let me play this. We have lots of time, so we're good.
Spoken to in 10 years and tell him to come visit him before he dies.
That's your mom. Like, how can you just not talk to her?
Yeah, when we needed you to eat and live and to survive, of course we had to stick around and deal with your. But once we don't need you anymore, what's left is the relationship that y'all cultivated or lack thereof.
People are fed up and boundaries have been put in place, even for me. If you're unfamiliar with what going no contact means, it basically means when you don't talk to your parents at all. There's no contact and there's low contact, but to be honest, after I was doing research about this video, I was surprised and really happy to know that I wasn't the only person going through something like this. I always thought I was alone regarding this issue, but as we go through this video, it is clear that I am not. There are a lot of people who start to go no contact with their parents for a plethora of reasons, mainly being childhood trauma and emotional abuse. But I do find it important to note that I'm not talking about what's becoming a quote unquote a trend with cutting off your parents or going no contact with your parents. I'm not talking about oh, we have different political views, or oh, they made me mad this one time. I'm talking about decades worth of problems and issues that people are fed up with, and they're just cutting it off high and dry. But if you're someone that has a great relationship with your parents, good. I'm happy for you, and I'm glad that that is the case. But as we go through this video, you're going to find out that there are a lot of just genuinely bad parents out there. You are going to be shocked with how some parents act towards their own offspring, and to the point where it doesn't even sound believable, because for the people in my life that I know that grew up with both parents or have no issues with their parents, it seems so unreal to me. Like, it seems like an HGTV Hallmark movie, like seeing the relationships that some of my friends have with their parents. I'm just like, damn, I didn't know this really existed. And the same thing on the flip side for them to me. When they hear about my family trauma and my stories, which I will be sharing, in this video, they are shocked with some of the things that we've gone through. And do know that regarding going no contact with your parents, it is the last resort for a lot of people. It is not something easy that they have decided to do. It is not fun for them, but it's not something they wanted or desired. It is hard. And I hope that this video gives grace to people who are going through issues like this, or if you're someone who's from the outside looking in, you approach this topic with a little more empathy, because I am seeing a lot of people say, oh, it's toxic and it's wrong. How could you ever? We're definitely going to get into all these questions. In this video, we're going to listen to several stories of people who have gone no contact and try to understand why this is becoming more common, as well as talk about my own experience and how I don't have a relationship really with both of my parents. And if you like this kind of content, you like these deep dives, and you're just hanging out with me, be sure to subscribe. It helps me out a ton, and I really appreciate you being here.
These are the things that I didn't expect when I went no contact with my mom. I have been no contact with my mom on and off for the past 10 years, but I was...
well, that's not really on no contact. Like, if you're on and off, that's not really no contact. But okay.
Say it's been pretty consistent for the last 5 or 6 years. When I say no contact, I mean no contact. I don't have her phone number. I don't have her address. She met my son, but only once when he was 2 years old, and now he's about to be 7 years old this year. And she's never met my daughter, and she has not met my fiance. And the one thing that I did not expect when I went no contact with her was the amount of people in my life that would meet me for the very first time, find out that I'm no contact with my mom, and then ask me to mend the relationship. They would just automatically assume that that was my first course of action, and I did nothing to try to make the relationship between me and my mom work before I cut her off.
That is beyond relatable. Backstory. My mom and I, we are very low contact. I'll share more about that as this video progresses when it's applicable or towards the end. She lives, 30 minutes from me, and I've seen her twice this year. It's not an easy decision. It's not something that we talk about often, but it wasn't the first thing to do. It wasn't my first thought to do. And even for my father, he left the family when I was like 4 and 5. And there have been many times throughout middle school and high school where I tell people, yeah, I don't talk to my dad at all. I talk to him maybe once every 3 years if he randomly gets my number, or he's on the phone with a cousin and I'm around, whatever it may be. But there have been people that have been like, yeah, Amir, well, you should try to fix your relationship with your dad. It's really important. And I'm just like, first off, he's the one that left. Why am I the one that's having to fix this at that? Do you don't think I've ever tried? You don't think I've ever reached out or tried to connect and make a relationship happen?
Yeah, I do agree with like the general principle of like, look, the duty is not, there's not an unlimited duty on you. Like, the unlimited duty is not on you to mend something. If a party thinks something is not important, like, for example, if you have a contract and only one side is honoring the contract, like, then the contract really isn't working, right? Because only one side is playing by the rules, is putting in the work, right? So if you're the one who's doing 100% of the work, well, that's not really working, right? So I get that. I get that. Now, if it's something where you can see it's like 60-40 or something where it's like almost pretty clear, in the middle, or 75-25, and you can work on making that better or talk about that and fix that, sure. But, if it's really disproportionate, I get it.
And it's weird. So when people are just like, you should really fix your relationship with your mother and your father, it's like, bruh.
What I need for people to realize is that is the result of trying to make the relationship work. The no contact is the end of something. It's not the beginning of something. Typically, adult children that have gone no contact with their parents, that wasn't their first plan of action. They tried for probably many years to make the relationship with their mom or dad work. I know for me personally, there were years where my mom didn't take accountability. It wasn't just one conversation. True healing between two people cannot happen if only one person is acknowledging the trauma.
Facts. It cannot. It's literally, it's like a relation. It's a relationship. If you're in a relationship and it's one-sided, you're gonna leave. So it's like, if you're in a relationship, if you have a relationship with your parents and it's one-sided, you're gonna leave. Why should you have to feel this obligation to stick around and stay there just because it's family? It doesn't make sense to me, and it never has growing up. And it's like, it's clear there are some people who do not view family that way. It's clear to some people, some parents, family means nothing, and that means because I'm the parent, I could walk all over you, and it is okay and accepted for a adult child to put up their boundaries and put their foot down, and say, well, you know what, enough is enough. Perfectly fine for someone to do.
And then even once the trauma is acknowledged, there needs to be a change in behavior. And it drives me absolutely insane when people just think, oh, you took the easy way out by just cutting her off. That was not the easy part. That was a very difficult decision. And it's a decision that I personally do not regret, because I know everything that took place, and I know that I'd made the best decision for myself. And as a result of not having contact with me, she also does not have contact with my children.
Period. I don't see my kids really spending a lot of time over there. They definitely will probably meet my mom, but like staying the night, babysitting, all that, no. I know what I went through. I know what it's like, and I know if it's toxic for me, I don't want that toxicity for my children. This video is crazy. We're on. Oh my gosh. Yeah, we have a lot we're going to be going through in this video.
And I've said this in a video before, but children, no matter what the age, do not owe their parents anything. And that includes contact with their grandchildren. Parenting is a one-way street. It always has been that way. It is a job that you do not get thanked for because your children did not ask to be here. You did not have to have them. I also didn't expect the fallout that would happen with other family members because of my decision to cut off my mom. There are family members that don't talk to me, mostly siblings, just because of the fact that I won't have a relationship with our mom. And that's okay too, because although we have the same mother, I do realize we had a different experience with her based on the amount of time that we spent around her. I'm just saying, if you meet a person and find out that they're no contact with their parents, please respect their decision. Keep in mind that it is always the parent's responsibility to mend that relationship. It's never the child's responsibility, no matter how old they are.
See, I disagree with that. I do think that it's a two-way street. You should be able to work on this and try to fix it. And if not, then leave. I think that's totally acceptable. I don't think parenting is just a one-way street and it should stay that way. I think that's why there's a lot of problems. I think it should be a two-way street, having conversations, and trying to work to mend that relationship.
There is absolutely a grieving process when you end or limit your relationship with your mom. And I talk about the 3 different parts of grief in a Toxic Mom Recovery Guide, because not only are you grieving the loss of the relationship that you did have with your mom, but you're also grieving what it should have been. And if you're no contact with your mom, then you're mourning that loss like a death, except she's still alive and you know that your relationship with her is probably never going to change.
Very true. It's not for the faint of heart. It's not something that, again, I say it's wanted or desired to do, but there definitely is a grieving and mourning process with it. Even though, you feel better afterwards. Like, my mental health has never been as clear as it is now.
So pause this real quick because I want to get some of the comments here because we've got a couple. TV Boone says, I've been a fan of Amer since he started. Appreciate you showing this video. Yeah, cool. No, it's good. We're gonna continue with it in a second. Amir. Sorry, fuck. I'm a little bit tired here. 9 hours and 51 minutes of streaming. Like
I give you a pass.
I just got a warning from my email because I started using a time management software because I'm trying to manage my time a little bit better. So it's called Toggle, right? So it's a tracker, and it literally asks me if I fucked up in leaving, because if you just leave it on the same task, it'll warn you, hey, the tracker is still running. I'm like, yeah, I know, because I change it when I start streaming. I'm like, okay, streaming, boom, and it puts it in a little category to show how much time I'm streaming. And it's like, are you sure you're still doing this? I'm like, yes, I am still doing this. Thank you.
That's why I stopped using
10-hour
those when I'm like working.
Come on, this is weak sauce, boomer.
Yeah. Hey,
what are you doing for 16 hours?
Yeah. Well, it's just 10 hours. God, what is that? That's nothing. That's garbage. Malthus says she's like Pakled from Star Trek. We smirk. And then Mark said earlier, how pissed off is she going to be when she finds out that the judges actually don't read these letters from jail? Yeah, because it's not a fucking motion. It's just a letter. Right? Unless the judge has a legal duty to respond to it, he's not reading your fucking complaining letter, right? It's not a motion. He doesn't need to read it. He doesn't need to consider it. It's not material. None of the things stated in there would change an analysis on an alimony, on an alteration to alimony. So, let's see. It's trial time. You should be pulling all-nighters. I mean, I really have, guys. Like, I really have. Verdict clocked is currently at 1 hour and 10 minutes. This is exactly what I predicted. So I'm about to lose by going over. Next one up is Ava, who predicted 10 more minutes than me. And then we've got the folks that were predicting it to go long. By the way, of all of you, 94% say guilty, 1% says not guilty, 5% hung jury. So we have a lot of guilties in the chat. So cool. Let me just go and finish this video. Once again, I can hear the jury video music in the background, and I'm checking it periodically as well, just to visually check it as well. So yeah, I know people like to troll and say, judge is back, but don't do that stuff because obviously I know better, right? So you'll freak people out. All right, let's continue with the video.
I've never been this successful. I've never been this genuinely happy in my life with the decisions that I've made to go low contact. But it's hard. It's hard. It's double-sided. One, it's hard because it's like it just sucks knowing that you don't have the parents that you thought you would have. They still raised you. My mom still fought a lot in her life and provided for me and busted her butt. But at the same time, it's like that doesn't give you the right to disrespect me and walk all over me. And on the flip side, especially with in-laws, it's like, damn, it's crazy seeing what some moms actually are like. And it is, you do get jealous. It's like, damn, like I wish I had a relationship like that with my parents. And I felt that way growing up in terms of, my dad being gone. It's like seeing my friend's dad. Well, really, when I got my mentor when I was 18, 19, I spent a lot of time with him. I was like, he became like a father figure. It was
We're
like, oh
about 30
shit,
minutes
this is
away from 9 o'clock.
crazy. Like, this is what having a dad probably was like. That was eye-opening. But I mean, I didn't go no contact with him. He went no contact with me. So it's a little different, but she's spot on.
Important to know. You can absolutely 100% heal from your mom, regardless of whether or not you're in a relationship with her, even if she's already passed, because your healing journey is not dependent on her.
She has a point in that you don't
pause this for a super chat. Mark a reality for 5 says, how close are we getting to 9? Are we going to Monday? Well, it's 30 minutes. It's 8:30. And they said they're cool going to 9. So my thought is they're going to use 9 around about when they should aim for how long they go. So my thought is that.
Well, remember too, the judge did say that if it takes longer than that, he will file for an exception because that's as late as they go.
Yeah, so they were going to allow them to go later than 9, but I think they go back there, they start putting in work, start talking about this. They can come back pretty quickly. They don't need to have 6-7 hours. Although if they're going to go through all of the text messages and stuff and all those logs, right, that could take a little while. Sure. I don't think we're going to Monday though. I really don't. They'll go into overtime before they go to Monday, and then at a certain point somebody will break one way or another. No, they said they can go past 9, which might mean 10. So, okay, I don't think they can go past like midnight. White Rabbit Ann says abusers pick the weakest to attack their own children. What the spouse abuser do to adult dwarfs, what they do to kids. No abusers ever. Yeah, it's picking on the weak. George was like an adult child. He was a dwarf. He is a manlet, and that's why she didn't respect him. She pushed him around and controlled him, and that was probably part of the appeal she saw in him was because she could control him. Garlic said the only way I could.
I mean, that video of him in the stairwell, literally, basically cowering in fear on the wall it's crazy.
Yeah. But that tells the whole story. Tells the whole story. Garling says the only way I could see not guilty is from a jury of misandrous, which the judge and prosecutor seem too competent to allow. Yeah, I could see a hung jury though. That's the only thing I could see. Not guilty, but someone who's like, I'm not voting for it because I had DV in my history. I'll end that poll though. Because almost everybody's voted here, and we have 1,111 likes. Awesome, very based, guys. Very, very based. Really appreciate the support today. You guys have been fucking great, and yeah.
Woof.
Let's continue.
Have to suffer, and it is something you will get through. If there's one thing I'm incredibly thankful for, it is all the lessons in my life that have helped create me and turn me into the man that I am today. I'm thankful for the amount of hardship and turmoil that me and my mother have gone throughout the years, because it's helped shape me into the man I am today. I know the type of relationships I want in my life. I know how to speak to somebody, what not to say, what to say. I know certain things.
It's actually a good mindset. Like, if you've had to deal with adversity, you should always try to reframe it in a positive way. Like, you can choose to bitch about something. You can choose to be like, hey, I might learn something from this. I might grow from this. I might, improve from this, versus just bitching and complaining about having to do every little struggle in life or every problem in life. Sometimes problems end up making you into a better person.
To identify and look out for. Even my father.
Oh, go ahead. Did you want to say something, Cypher? Was that who, or was that?
Yeah, I was like, that's why you have people who, when they do have kids, they're like, I'm doing the opposite of whatever like I had growing up, because they were like, I saw everything you should not do, and let me like do better.
Right. And actually, for this, I guess what I'll do, guys, because I don't want to. Obviously, if we go past 10 o'clock, I think that'll be it. So I'll say that like 10 o'clock will be the general cutoff. Like, if we don't hear back, then it'll be 10, because I don't know whether they'll come back in the courtroom or whether they would just inform the juries that it's going to go. So if it's past 10 p.m. Eastern, that would be like the far end cutoff.
He is one of the best presents I've ever had in my life, because he's the way he just left, the way he is now when I do speak to him, the once every 2-3 years, shows me the man that I do want to be. Makes me very eager to adopt and pour the love and life into a child that is out there right now that doesn't have that there for them. It excites me to be a parent because of the parents that I had growing up with. They've equipped me with the tools to be the best parent ever. On the flip side to most, by just doing the opposite of what they did. Jay-Z has an incredible song called Adness, and you should really look it up. But he's talking about his father and, how he made, he's the present of the past. Like he passed down this torch of, hey, here's all my mistakes, and going forward, just learn from this and grow and move on. And that's what I've taken from him. That's what I've taken from my mother. I've gone through this grieving process and really being upset that they're not in my life and going through all those things. It's just, I'm in a way better state than I ever have been dealing with this and trying to mend these relationships. And it's just not an easy thing to go through or do. I don't wish it on anybody, but at the same time, I can't help what happens in my life. I can only help how I choose to go forward. It's all we ever can do.
Telling people who are no contact with their parents that they need to either make things right, they need to talk to their parents, or that's your mom. Like, how can you just not talk to her? I had someone on my live yesterday say that my mom is not guaranteed tomorrow, and that should give me the reason that I need to talk to her. Y'all only know the 2 stories that I've told y'all. I have 26 years worth of things that have happened.
Yeah. I'm on 20. I'm 28. I'll be 29 this year. If y'all only knew half the things that I've gone through regarding my mother, you would be amazed. So it's not an easy thing to do. This is not something you even wanted to do, but had to protect me and my mental health and my space. And my father, he left me But growing up, you know, I've had family members, you know, here and there.
There are
You try and
segments
talk
from
to
the
him, you
parents'
try to
point
mend
of
things.
view.
It's like mend things for
Yeah,
what?
I want to see the parents'
I
point of
barely
view.
even know the man. He left when I was 4 or 5. The time when he would come around would be the times when he
Fourth
didn't
grade
say he
box
was coming,
go
because the
one more.
times he did say he was coming,
That
I'm
one.
sitting at the front door
This
looking like
one.
Boo Boo the Fool, wait on him to show.
Okay, I want to see the parents' point of view here.
Because this is actually one of the common ones too, which is really because there is a lot of parents who agree with this woman on TikTok, and these parents are going to therapy, and like therapists are actually going on TikTok and asking like the general
Different
public like
versions of
what is
families and
happening.
moms and dads.
That's crazy. Let me see this.
And there's a lot of people out there who have poor experiences and poor people for what a mother and a father is.
I have 3 adult children and 2 aren't talking to me. And do I give a damn? Of course I care, but I'm not going to feed into their bullshit.
See, like, okay,
So
who?
for
Yeah,
someone I know,
who's the problem?
that mom clearly.
Not me.
Again,
Yeah, who's
outside
the
looking in,
problem?
we even haven't gone into this. This is this first impression. I feel like that mother's very like gaslighting type and hasn't even done the work to recognize what they've done wrong personally. And they have this like higher than thou mentality of like, I am the parent, I am this, I am that.
Mm-hmm.
This video is interesting to watch because I think it encapsulates how a lot of parents feel about their millennial Gen Z children. And as a millennial myself, I want to give my perspective on this topic.
This creator asked the question why, and then another creator stitched.
Okay, hold on. Parents, kids who are treating you like trash after you giving your best life, just live your best life. And that's what was on the OP, the original Posters video. And then the person reacting to, she's talking about how the video she stitched of a creator asking why her kids don't speak to her when she feels like she did nothing wrong was stitched by someone else who explained why they cut off their parents. And then the other creator stitched her video. So that's all that text.
Guys, it looks like
You're
verdict
wondering.
is reached.
That was.
Her video, and it was like, okay, well, I did this, and I'm one of those kids, and I walked away.
Really?
Well,
Already?
From my parents because they had trauma. Well, I
I'm here,
look at
yeah.
it this way.
I'm not seeing anything yet, so I think you're getting trolled. I think you're getting trolled. That's troll. That's troll. They're trolling you. See? Troll. It's a troll. Court TV says verdict? Hold on, let me double check. Oh, there you go. Okay, fine.
The whole chat.
Chat.
The whole chat
Okay.
got me.
We have to gaslight chat. We have to gaslight chat just like Sarah Boone. No, I refreshed. It was fine. We have to gaslight chat just like Sarah Boone. Triforce A7X says, I've been enjoying your coverage of trial and I'm definitely going to be simping for a legal lolly. Yeah. That's going to be the segment when we have Ava on. It's legal lolly. It's going to trigger so many people. That phrase is going to trigger so many people. Okay. So let's put here. Boop, boop.
I'm
Verdict has
so
been
ready
made.
for it. It's going to be hilarious.
It's going to be ready. Go time, baby. Oh, Sparky, I'll send you an invite. I'll send you an invite, Sparky. So we're down to Trace. We need one more VTuber. So you got an invite, Sparky. Oyamata, off topic. Is Qualcomm versus ARM along your alley because it's another contract dispute? Also, VTuber Nyanners is banned from Twitch for a clicky game. Yes. So I'm going to do a VTuber episode both on the HoloLive violation, which I actually think is a good thing, despite the fact HoloLive Cover Corporation got in trouble. And then I'm going to do one on that ban as well, because that's also bullshit. So we'll be there, probably, which will probably degrade into me talking about Twitch and perhaps how I think Twitch may even eventually get taken down on terrorism, aiding and abetting. But we'll get to that. We'll get to that. But good to see you, Sparky. What's up, brother?
What's up?
You're home now, not driving. So
yeah, yeah. That last time I got unexpectedly busy.
It's all good, brother. Charlie Spurs says verdict. Charlie is Rima's little pog champ. Okay, we all know who's in the stables. Charlie, we know. Nisanek says some jurors just learn what Star Wars is. No fucking way. No fucking way. KT Shadow VT says they're triggered. Good, let them cope. I'll play this. Actually, you know what? Fuck it, we got time. Let them cope. And you know what? Let them cope from an elf.
You are coping and seething. You just can't accept what you see. Yes, you're coping and seething. The truth, it is scalding, and now you are molding and coping so hard.
Coping and seething. Still waiting on this. It's very healing music, yes. Range says, thanks, Andrew and chat. Great coverage and company along the way. Cheers, safe week and all. Thank you. I'm so glad we got through this together. And you know what else? I want to ask in the chat, how many people was this your first trial stream? Like, have you watched a trial stream before? I'll say before with commentary, right? So not just the trial before. Yes, I'll put like yes, no, and then like yes, but only Depp or but only Johnny Depp. I'll put it that way, because that's a lot of people. Just want to see if you guys, how many of you guys, if we're new or maybe just watch Depp or what did you guys watch? I want to know. So thank you for that, The Range. Charlie Spur says they're watching Star Wars in the jury room. Hopefully not the new ones. That would be a crime against humanity. Market Reality for 5 says, so who's excited for GTA 6 to come out in 2025? It's supposed to be the Florida Man version. Really? I would love if they made one like Orlando. So it's like you're breaking into Disney and kind of going crazy. That'd be great. That'd be great. White Rabbit Ann for 5 Canadian says, I learned to be the opposite of my mom. That's the only good she did. She created a good person by accident. Yeah, look, oftentimes people can overcorrect when they're trying to rebel or fight against a bad situation. So for example, when people are traumatized or by a person who's very strict, they have no rules. But having no rules also creates bad people as well. You need to have boundaries, but they should be logical. They should make sense. They should be related to, the kid improving and becoming better, right? So there's limits on both sides, right? Garling said, I lost my trial viewing virginity this week. Well, Garling, I hope that we were gentle with you, and I hope that you enjoyed, losing your virginity with a lawyer in Asia and a legal lolly. What was that, Cypher?
He came for the pink shorts.
You thought you were coming in for the pink shorts. You stayed for the legal lolly. It's good to see everybody who was here today. Also, 57% had watched a trial stream before. 16% was only Johnny Depp, but 27% were complete virgins. We took 27% of the chat's virginity, and I do appreciate all those that let me take your virginity, or really, Johnny Depp didn't count. I gave you a hall pass for Johnny Depp. So I'm going to add that 16 to the 27 and say, you know what? It's really more like almost 45%. So I feel like 45%, I was your first. Listen, you never forget your first, you never forget your first. Christopher Candler said, I only found your stream yesterday. It's not every day of a person who looks like my favorite anime character, a hot guy, and relaxed commentary. Yeah. Yeah. And honestly, that's the vibe. That's the vibe. The vibe here is good. And next time I do this, I'll probably be in 2D, but who knows? Who knows? You virgins, you were simping for grandma, weren't you? No, the people simping for grandma were the real hardcore degens. The people simping for grandma were the ones that they're really members of the community, you know?
They showed up with the baby oil.
Yeah, they brought
Oh,
the baby
no.
oil. Yeah. Sparky, by the way, I'll play it again, but your version of coping and seething is so fucking good. It's so fucking good. While we're waiting for this, I'll play it. I'll play it real quick. You know, your mindset AI. This is so good, man. You are coping and seething. You just can't accept what you're seeing. Yes, you're coping and seething. The truth that is scalding, and now you are molding and coping so hard. So good, Sparky. Good job.
There's actually a funny story behind that.
What's the story?
Well, Ava was having issues, and she was asking around the Discord if anyone had any revised music for it. And I said, give me your files. So I put it through the program I have and got separated. Well, whenever it did, it's like, I wonder if I could put Mindset's voice on this. So I put it through the filter and it came out pretty decent. So that's like first try.
That was pretty good. That's pretty good. I look forward to her with Big Iron. I think that'll be good.
Yeah, Ava, you got those files, right? That I sent?
Yeah, he's actually the one who's separating the vocals. Yeah, I did. He sent it to me, so he's Mr. Audio guy, I guess.
Oh, this is so good. I know you sent me the scripts, but this is good. This is good. I could karaoke that. That's so good. I like that song so much. It's so good. Very good. I approve
you like
the lyrics.
The script? Yeah, it's a pretty good script.
I approve the lyrics.
Yeah, I
approve.
thought it was a pretty good one. Yeah.
Andrew can be deep faked easily. Yes. That, by the way, that's not the first. Like one of my mods, Afix, he's probably out there, but he did some deep fakes back in the day, and I'm like, you son of a bitch. Like this was I think a year ago or so, actually. I've got some deep fakes stuff that I'm like, when I figured out how easy it was to do, it's very funny. It's very funny. That's all. See if I can even find some of it. But yeah, just crazy how the technology has truly advanced.
Yeah, it all started with me just trying to replicate Medica and grew from there.
Yep. And then all of a sudden, oh yeah, this is actually good. Hold on. Let me see. He was doing okay. Yeah, let me pull up a couple of these. These are actually really funny and based too. So let me see if I can pull these up. None of these are too spicy. Okay, yeah. I can pull this up. It won't dox me. It won't dox me too hard. All right. Let's see. I'll save this image. There and then. Oh man! So he was trying to modify some of my photos because he was seeing I was using AI generators for some of my thumbnails, particularly for Go East Gentlemen. So he took some images that I was using for Go East, which had some female images, right? And then came up with these two. Let me show this one here. This is kind of funny, but very based. This is like, these are why these people are my moderators, because they know me very well. It's like AI generated art. This is pretty good. That's like with tattoos, without. I prefer the without, but still looks pretty good. Still looks pretty good. I stand by this being 100% real.
You can actually probably put that back into a novel AI and probably can generate something more realistic than that now.
That was a year ago.
Oh, it's advanced since then.
Yeah, that was a year ago. So,
I mean,
With
For,
is hotter. You're a manlet.
Oh, here we go.
My giant ABGs. Yeah, no, once again, the technology's gotten harder. Like it's gotten easier to do and better.
Second. We are on the record in
All right, here we go, guys.
case number 2020 CF 2603, State of Florida versus Sarah Boone. State, let me get your parents for the record. Defense.
Why is the volume so low?
Is it low?
Okay, all right.
Yeah, it's low.
Seated at council's
Who's
table, wearing
whispering?
the same clothing from this morning. Yes, Mr. Beck.
Better?
Judge,
Yeah.
they've got her in chains and they've got her in the ankle.
They know that they got to keep her in chains because she's going to get ridiculous.
We would like to rise during the.
Keep her in chains. Fuck that bitch.
The handcuffs and the waist chain.
Holy shit, I just noticed she's still in cuffs.
Something wrong with the verdict form or, there's an issue.
Keep her in chains.
But that's my position.
Okay. I've been advised by the sheriff that during the reading of the verdict, due to Miss Boone's status as an inmate, their leg irons and the cuffs are to be attached.
Leg irons are not.
That's fine.
Fisticuffs.
All remain seated, and would you mind everybody in the gallery that there should be no emotional reactions?
I was just about to address that, sir. Thank you very much. All right, members of the jury, my understanding, or members of the gallery, good evening. My understanding is
She's
that the
gonna
jury
be
in
on
this
a
matter
chain
has
gang,
reached
let
a
me tell
verdict.
you what.
I don't know what it's going to be until it's read. If you are unable to contain yourself emotionally and you're going to react in any way, be it in joy or in sadness, I'm going to ask you politely to excuse
So
yourself
I'm going
at
to
this
stop
time.
the counter.
There cannot be any emotional outbursts when the
It took
verdict is
90
read.
minutes.
Does everybody understand that?
90 minutes.
See everybody nodding their heads.
Just
Okay.
about.
What's the quickest one
State, are we
been?
ready to bring in our jury? Yes.
Boom!
Defense,
What
are we
was
ready to
that,
bring in our
guys?
jury?
Right again on
Let's go ahead
the
and bring in our
dot.
jury. Everyone will
and the
remain
thing
I
is-
did
seated.
45 to 90.
You did good. It's right at the going time when they had to close down. So, good job, Legal Lolly. Malta says for 2 Canadians, secure her with a suitcase. She's about to be secured in a fucking prison for the rest of her life. We'll see, though. We'll see.
I was gonna say the time can be varied
Now,
from the
now
judge, can it?
here's the thing. What if they get her for manslaughter and not second degree? That would be a little bit of a throwing it for a curve. But to me, at least, she's guilty of something.
State, do you recognize our jury?
Yeah, sure.
Defense, do you recognize our jury? Members of the jury, you may be seated. Thank you. Members of our jury, good evening. I understand that you've come to a verdict in this case.
Here we go.
If you could please hand the verdict form to the deputy, please.
Here we go, motherfuckers.
What is it gonna be?
Thank you, sir. Madam Clerk, if you could please publish the verdict.
Let's see what it
In
is.
the Circuit Court of the Ninth Judicial Circuit in Orange County, Florida, case number 2020 CF 2603, the state of Florida versus Sarah Boone. Verdict. We, the jury, find the defendant guilty of murder in the second
Guilty.
Still say will dated at Orlando, Orange County, Florida, on this 25th day of October 2024. The form has been signed by the court.
Madam Clerk, please poll our jury.
Juror seat number 1, is this your true and correct verdict?
Yes, it is.
Juror seat number 2, is this your true and correct verdict?
She's not smiling now.
3, is this your true
Yes,
and
it
correct
is.
verdict? Juror seat number 4, is this your true and correct verdict?
Yes.
Juror seat number 5, is this your true and correct verdict?
Yes.
Juror seat number 6, is this your true and correct verdict?
Yes, ma'am.
Members of our jury, again, I want to thank you for your time, your sacrifice, and your attention in this matter. I know that we spent almost 2 weeks together, and it was not taken lightly, and I really appreciate the time and the effort and the sacrifice that you put into this case. I want to advise you now of your final instruction. Members, ladies and gentlemen, I wish to thank you for your time and your consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors.
Nobody's coming back Monday.
No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak to anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. With that, members of the jury, again, I thank you for your service. I'm going to ask you return to the deliberation room. I'll be back there shortly with your jury certificates, and thank you.
Yeah, I see that smile's not on her face no more.
Yeah, she ain't fucking smiling now. Suck that shit, Owen. Piece of shit.
It almost looked like she was giving them death glares for a moment.
Ms. Boone, the jury has spoken in this matter and has found you guilty of murder in the second degree. The court adjudicates you guilty of murder in the second degree. As this is your first felony conviction, you are entitled to a pre-sentencing investigation by the Department of Corrections. Mr. Owens, are you seeking that in this case?
Yes.
Okay.
Yep, there we go.
State, I will order the Department of Corrections to prepare the...
I'm ready for life in prison for Sarah.
State, for the purposes of sentencing, do you anticipate eliciting any
Smoking
testimony
on that Sarah pack, yep.
from be it the victim's family?
2 or 3 victim impact statements, sir.
Oh, that's gotta be
Mr. Owens, do you
interesting.
plan on presenting any evidence during the course of the sentencing hearing, sir?
Probably some testimony from Dr. Harper.
Okay, all right.
Ooh. Oh boy. That fucking
How long do you think, State, that you would need?
You mean timing wise, or are we thinking?
A quantum of time, sir. Yeah, well, normally it takes about 30 days or so. I'm confirming with Anita as to availability. I just want to know from your side of the ledger, how much time? Okay, 15 minutes. How much time do you think you're going to need to produce anything from your side of the ledger, sir? Mr. Owens?
I'd say 30 minutes. Okay. 30 to 45.
So if we set this for an hour, that would be sufficient.
Parties agree. Okay. State agrees.
Is that sufficient, Mr. Owens?
Yes.
Okay, all right, give me a moment.
Yeah, to think about that is I didn't think we are gonna lose.
Yep, she really thought it. She really believed it. And thank you for Fred. I'd like to say I called the exact time they would announce it, but it was 6 minutes off. Hey, close enough, buddy. Also, Orson Blast with 20 legal mindset memberships. Thank you, thank you, thank you.
Yes. Ms. Barrios is checking. Just give us a moment.
Yeah, they're just trying to get their scheduling down right now. They're just going to schedule the conference. Yeah, like Mark said, it should take about a month for sentencing. So, we'll get back to sentencing. But the important thing we have is that she's guilty. That's the most important thing, and I normally will follow up on it. Like, oh yeah, this bitch got, sentenced to life, because it's going to be a long time. It's not going to be, she gets out next Tuesday. Right.
Well, now you can actually go
set
trick or
this
treating
matter
at
for
Boone.
1:30 in the afternoon for sentencing on
Yeah.
December 2.
We could say she's a criminal.
State, is
I'm
that
okay.
acceptable? It's a Monday.
I just hearing, but
She's going to try
I
to
can move it
appeal
to
it,
later
but it ain't
if
going to work.
necessary.
I'm co-counsel on it.
Okay. Defense. Yes, sir.
No, the judge was extremely careful. I don't think
Yes,
he's going to
sir.
get appealed.
Ma'am, you've been adjudicated guilty. I now remand you into the custody of the Orange County Jail pending sentencing on December 2 at 1:30. State, anything else we need to address?
Nothing to say.
Defense. All right. Thank you very much. We're off the record.
Cool. So that is it, guys. That is the trial of Sarah Boone, guys. We are finally concluded with a guilty verdict. It's very cathartic after all that week of spending in the trial, but it's honestly good to have a conclusion. And it always feels like, you know, when you get to the end, it's like kind of getting to the end of a good book or a movie or something like that, where you want more. You know, you want like that extra day, that extra 2 days, because you're excited for it to be over, that it's over, and the next day you wake up and you're like, oh yeah, I'm not trial streaming anymore, right? Like we've gotten this conclusion. But this is one of the most fun trials I've covered in terms of being efficient, having great panelists, fantastic panelists, and you know, being something that is an interesting topic, right? Because this is, you know, it's murder. It's a very, very high profile one. And the defenses were kind of crazy and insane. So it's been really, really fun for me to cover. I want to give everybody a chance for some final thoughts before we close it out. So I'll start with our legal lolly, Ava. Do you want to give some final thoughts on the case before we close it out here today? And give her that 3 to 5 seconds.
I think that this was a case of Karen who thought she had gone way too long, not like getting away with it. And she tried to use the same outs that she had used to get away with this before. In terms of like, oh, it was a good day. We've heard before in some of the other arrests. We've heard all that same rhetoric from her. It didn't work this time, and it was extremely satisfying for especially people who've been victims of that kind of abuse, to see it not work and see the mask come off.
Yep. We really saw the mask off. Cypher, final thoughts now that we got the verdict?
Well, it was a dead on arrival case, but, you know, secondhand trauma to the chat being like, I'm having flashbacks of my own personal life because everyone knows someone like her.
Yes.
And some people are running from them. Some people successfully, you know, new game plus. But I had a great time. This is my first like being on a stream, and I appreciate that the chat runs with my jokes because I'm just sitting here being the normie going, how is this going to play out?
Well, next time they're going to groom you into a VTuber, so you're going to have a ping model. Yes.
We're at the fork of the road because I'm getting yelled at for going on cam or continuing to be a little ghost. So
VTuber is the
getting yelled
future.
at by everyone.
Do it.
You know what?
Yes.
If you guys
You could be a little
my
ghost VTuber.
podcast,
Oh, hold on. She's
Would
making a
like-
promise. Hold her accountable.
Yeah.
Don't blame her.
if you guys, you know, bump up my podcast,
How much? How much
maybe.
you want? How much you want?
Ah.
How many views? do
Okay,
you
how
want?
about this? Here's a metric because I can measure this easier. Instagram. You guys can get that up to like 1,000 followers. I'll come back with the choice of on cam or VTuber, but I gotta go find an artist because I'm lazy.
Yeah, well, that's fine because they will definitely do that. Okay,
We know
so
plenty of them.
now you guys got to go over here. I'm not logged into Instagram right now, but I'll just show you guys. So go over here to Stormy Cypher. I usually have Instagram on my phones. So go over here, follow her, A Stormy Cypher on Instagram, get her to 1,000, and then we're going to VTuber her. So there we go. Because no one cares about the face reveal. It's all about their VTuber model. So go over here, follow Cypher, get her to 1,000. We're going to get her into a
Guys, we're
VTuber
going to
model.
isekai the crap out of everybody into the VTubing world. Just wait.
Okay, no, don't start that. I have a rant for Isekai.
That's separate.
That's it.
Hey. Save it for the
No,
end of the
no.
Hey,
Shame on you.
Hey, no
Shame.
isekai here. We're not isekai right
Shame.
now. Don't make me call Truck Coon. I will call Truck Coon.
I was just gonna say that.
I will call Truck Coon. Motherfucker.
I'll just go right through it. Let's go.
Random.
I saw
attack.
JJK.
Yeah. Utsahiya said 22 to life or without parole. Yeah, they got to decide what the sentence is, right? So it says it's 22 to life. So in a mid sentence, the mid sentence might be what, 30, like 30, 25, so who knows? Or 22, right? I mean, that's the minimum. She could get the minimum. That's what she wants to try to ask for. It is a first offense. So we'll see. She's not going to get a maximum. Semper Augustus says maybe she'll want to go to prison because they have sweet hide and seek night.
Oh.
With the soap. Sparky. Thoughts on the trial? Now you were in the audience for most of it. Even
Oh, by the way, I forgot to mention, Andrew. You can, if you want to, later show the lyrics that I wrote.
Oh, do you want me to sing them? I can take a stab at it.
Oh boy.
Oh, if you think they're good enough for singing, go for it.
Okay, I got it. I got it. Let me do it right now. This is
you need music.
Curtis, I guess I could do it like to the. Well, I'm gonna get struck for Big Iron like instrumental, but
true.
Yeah, I'll just do it to the tune of, right? To the tune of. Okay, hold on. Where is this? Degenerate stuff. Okay. To the south, no, to a town in South Korea flew a lawyer one fine day. Hardly spoke to folks around him, didn't have too much to say. No one dared to ask his business, no one dared to make a slip. For the lawyer there among them had a briefcase on his hip. It was early in the morning when his flight landed down, with his suit pressures all polished, and he was known all around. He came to file a motion, had a case he couldn't slip, and the townfolk watched in silence at the briefcase on his hip. In court, he was a legend, known for winning every fight. With his legal pad and documents, he would argue day and night. The jury sat in silence while he laid on the script, for they knew he was clever with that briefcase on his hip. Now the lawyer's name was noted in the papers every week, and the people said he'd save them, though his charges made them weak. But he'd always find a loophole with the logic they'd all flip, and they'd cheer for him in court with the briefcase on his hip. Got it. Boom. Good. There we go.
I'm so gonna clip this and put it behind music.
You got it. Big Iron from Fallout, for those that haven't played Fallout, which is a fantastic game. Very fantastic game. All right. Cool. She's gonna do it now. She's got to do it. Okay. That said, Sparky, what did you think about the trial you were watching? So, what did you think in general?
It was wild. This is the first time I've been on a court panel. May not have been here the whole time, but it was fun while I was on.
Well, hold on. Pause for 1 second. NR said 7 out of 10 IGN. Fuck you. I know we all know what that means. Hold on. Sorry, I gotta interrupt. Hold on, I got a little clip here.
Fuck you!
And then Anthony said for 2, don't quit your day job. Oh my fucking God.
You should be careful. You might get Alyssa McConaughey in here.
I know. Oh God. Oh. God damn. Oh, you guys are killing me. LJ,
If I saw Alyssa McConaughey, I would immediately body slam her onto the ground without question.
She's been exiled from Boston.
Yes.
Her and her conspiracy shit.
Yes.
Exile her for sure. But seriously though, thank you, LJ Rook, for the 10 Legal Mindset memberships. Much appreciated. Very, very much. Thank you. Yes. And thank you, Doug Diaz, for the extra one there. That's 11 rounded out. Thank you so much. We've had total this stream today. We've had over 100 and almost 141. Just under 150 in terms of new members. So that's fucking awesome. Thank you guys. Appreciate that. So Sparky, back to you. What did you think of the trial in general? Watching it as a layperson, non-lawyer.
It's real nuts to think what people can pull in court, especially lawyers. It really it opens your eyes because it can happen to both sides. This time it was the BS was sought through and a correct vote was made, but there's a lot of court cases that this doesn't happen with. And watching this, it gives you an eye-opening experience. And it seems like every trial is different. Like with Johnny Depp and stuff like that. Everyone thought going to that trial, no, he's guilty and he's not going to win, but he did. And like Kyle Rittenhouse, it was we knew what happened, but it was just what the jury come up with it. So this one.
I mean, with Johnny Depp, I mean, a lot of people, they're like, oh, Andrew's a misogynist because he's going. In the beginning, it was actually a lot of us, because I thought that they were both going to be culpable, right? But I was like, I do know that Amber Heard is a crazy bitch, but they're like, oh, you're just being a misogynist, this and that. But then we listened to her testimony. It's like, no, she's really fucking crazy and she's a liar, right? Like, and it's clear she's lying to anybody who has eyes and ears and watches things.
I think what was most compelling for me in the Amber Heard case was the expert that they got on that basically walked us through what Amber Heard was going to do as for her performance of a testimony. And then Amber Heard just did exactly what that expert said. It was
was that the
textbook
was that
psychological
Dr. Curry?
profiling to the max?
You mean Dr. Curry, the blonde? The woman?
Yeah, Dr. Curry.
Everyone was simping for her. Yeah, she was Dr. Mom. That was Dr. Mommy. And then, of course, Camille.
The original one.
Yeah, Camille, too, as well. Yeah. I mean, those two were that combo.
Yeah, but watching this case going through.
Camille.
Yeah, everyone loved Camille.
Yeah, but watching this case go through from the beginning to the end, we kind of all knew the base concept. Yeah, she zipped him up in a suitcase and it was bad, and the Snapchat video and a couple of things like that. But what led through in this whole entire case, I think, made everyone's jaw drop at just how exactly bad it was. I came into it going, yeah, this looks bad, and it's most likely they're going to come to a guilty verdict. But when they started showing like the videos and the DMs, and it just when they put Sarah on the stand and how she acted, it's like, yeah, there's no way in hell she's going to be innocent.
Yep. LJ O'Rourke says, oh, yeah, Dr. Muffins. Yes, Dr. Muffins married to Mr. Muffins. Yes. But we were all checking her marital status very quickly during that trial. I remember that one. Also, Cypher, you've already got people. This is how base my community is. They're already making you proposed models.
That's actually pretty good.
Yeah, that's actually really good. They're already out there waifuizing you. This is what happens when you fuck with the VTuber community. They transition you very easily into VTubing.
Rule of thumb: never tempt chat.
Never question chat. Chat will do it. Chat's fucking crazy, right? They'll do it. And wait for your Instagram.
I
That
love
thing's gonna be a
you.
tough one. Yeah.
I won't put you in a suitcase.
Run, chat.
looks after
Fucking
a
run,
grandmother,
chat.
so
Run.
They are capable of everything.
For Fred for 5, thank you so much. And then Crimson Splat for 1, guys, getting me over. Now I'm officially over 150 memberships. Thank you so much, guys, for Fred and Splat. It's so good. Appreciate that so much. And let play one more clip. The brand new one. I actually like this one. This is courtesy of Eagle, who got this one out.
Excuse me, sir. What is your ethnicity? I am interested in calling you a slur.
That's so good.
Oh my God.
That one is perfect. I always am getting more, and some of them I'm like, when can I use this? All right. Let's see. And then Einhander says, chat challenge at your own risk. Exactly.
Slurs here. Get your slurs here.
So guys, everybody will be found in the description. I'm going to add Sparky to it. He's been in my previous channel descriptions as well, so you can find him there. Please go follow Ava, Cypher, Sparky. This is not the last you'll see of them, but I want to thank you once again for joining me, for sticking with me for this whole week. It's been fucking awesome. I will be back. My next stream will be on VTuber business, so we'll be talking about that. I probably will have some other stuff to get out in the future as well, my next other lives, but thank you for being here with me. I'll probably do that stream maybe later today, and then I'm going to take a break for a day. So your boy needs a break. So we're going to take a break after that. But until next time, guys, take care. And remember not to be like Sarah tonight, because you know she's going to be.
You are coping and seething. You just can't accept what you see. Yes, you're coping and seething.